it's got a bit of a delay of a few seconds. Many seconds. It may not actually go live 5 minutes. This way you can at least see your presentation.
Yeah, sure, I'll talk.
So you have either choose the keyboard or the remote that you're most comfortable with.
I don't have a
Yeah, they mentioned.
PowerPoint
So, so do you want
which
to?
I probably could have done. Yes.
Would you rather sit when you're talking through them?
Let's see.
You know, two choices, you know, I guess at the podium or at your chair.
Okay, so Lorraine's going to work from here with the
Yeah.
PowerPoint.
Yes.
Okay. Okay. No, I'll probably. Actually, is this live and good?
No, that's just the mic. That's just the microphone there.
Oh, okay. Okay. All right. No, I don't.
You're free to sit and talk.
Yeah. Let me just set up something.
Because the podium is really tall as well.
Oh yeah, you're right. You're right. Yeah.
Screen and everything.
Okay. Okay. All right. Yeah. No, I can work from right here. But we have a couple of opening remarks first.
Yes.
Okay. Then I'll just sit up. Okay.
Good morning, everyone. On behalf of all of our sponsoring organizations, the Aboriginal Law Group from the University of Ottawa, Amnesty International Canada, the Assembly of First Nations, the Canadian Friends Service Committee, the Grand Council of the Crees, Greenpeace Canada, Kairos, Mining Watch Canada, Oxfam Canada, Oxfam Quebec, and the Coalition of the Human Rights of Indigenous Peoples. We want to thank you all for joining us today for this forum on free, prior, and informed consent. We especially want to thank those of you who've traveled long distances and made far journeys to join us today, and those of us who are joining us via webcast. Before we begin today's events, I want to acknowledge the ancestral, traditional, and unceded territories of the Algonquin peoples on whose territory we work and live and whose land we meet today. In order to ensure that we begin this event in a good way, I'd like to call forward Claudette Commanda. Claudette Commanda is an Algonquin Anishinaabe from Kitigan-Zibi, Anishinaabe First Nation, located in the province of Quebec. She is an alumni of the University of Ottawa Faculty of Law and Faculty of Arts. She has dedicated the last 30 years of her life promoting First Nations people, their history, culture, and rights in various capacities, such as a University of Ottawa student, a professor, and as a member and a former chair of the Aboriginal Education Council, and in the public forum via speaking events. Since 1999, she has been a professor for the University of Ottawa's Institute of Women's Studies, Faculty of Education, Faculty of Law, and the Aboriginal Studies program, teaching courses on First Nations women, Native education, First Nations people, and history. In addition, from 2000 to the present day, she has served as the Executive Director of the First Nations Confederacy of Cultural Education Centers, a national organization mandated to protect and promote First Nations culture, languages, traditional knowledge, and education. In 2009, she was inducted into the Common Law Honor Society. In 2013, she was appointed for a second term to the Board of Governors for the First Nations University of Canada, and recently, in 2014, she was re-elected for a third term on the Kitigan-Zibi Band Council. She is a mother of 4 and a grandmother of 10, so please join me in welcoming Claudette Commanda.
Wow, talk about having my 15 seconds of fame. Thank you so much for that beautiful introduction. I really do appreciate acknowledging and honoring the protocols of the Algonquin people. Kwe Shiba. That means good morning in my language. The very first time, okay, first of all, let me explain to you. There are 10 Algonquin communities, 9 in Quebec, well, what's considered in the province of Quebec, and 1 that is considered in the province of Ontario. But we Anishinaabe, or any First Nation person, we know that there are no boundaries. We have not separated our mother Turtle Island into countries or states or provinces. So anyhow, in the Anishinaabe Algonquin Nation, the communities vary in dialect. Back from where I am, Kitigan-Zibi, we say, Minokijigad. It's a nice day. But my daughter-in-law, who comes from Boyer Lake, she's an Algonquin. It's about an hour north of my community. So when she says good morning, her people say Kwe Sheba. So one morning she says Kwe Sheba. So she texts me this Kwe Sheba. And I said, why is she calling me the Queen of Sheba? So I wrote back, I said, well, good morning to you, Cleopatra. So then she texts me and says, why are you calling me Cleopatra? I said, because you call me Sheba. She goes, no, I'm saying good morning. That's how we say good morning in Rapid Lake, Sheba. I said, oh yeah, okay, well, good morning. So Kwe Sheba. Kani Michki Jigun Kinu, Ni Dishnakaz, Kitigan-Zibi Don Jiba. Pijaje Goma, Anishinaabe, Ashish Nichki Wedug, Pijajigoma, Hogima, Roger Williams. Pijajigoma, Anishinaabe Aki. Mon nom c'est Claudette Commanda et je viens de la communauté de Kitagan-Zibi. Je suis une femme algonquine de Première Nation. Je suis très fière pour d'être ici à la terre de mes peuples, pour donner des mots à bienvenue. And I'm very honored to be here to welcome each and every one of you to unsurrendered, unceded, non-treaty, Anishinaabe Aki Algonquin land. I honor Chief Roger Williams, who is here today. Thank you for what you've done for your people. And thank you for making that great change for our people to advance their rights. And that the laws acknowledge that the First Nations people have title to this land that was given to us by the Creator. So Chimigwech, my friend, and your case is certainly going to help the Algonquin Nation because we too are not treaty, and we too must advance in our claim or our statement, our assertion that we never gave up our land. Miigwech for that. Thank you to you and your people. It is an honor to see everyone here. And you know what? I really miss being here. I just can't believe that 20 years ago when I walked in the doors to be a law student that I would never see the end of the day. But I can tell you in a blink of an eye, 20 years has gone by and I can't believe where has time gone. And I'm a bit panicky more so today than I was 20 years ago. Why? Because I'm realizing, oh my God, I'm getting old. Because 20 years has gone by so fast. I thank the law faculty for what you're doing here today and bringing forth this valuable information to the educators, the law students, the lawyers, and whomever else, the policy developers, and the work that you're doing here. Thanks again for being here, Chimigwech, and have a good day. And learn well because you're going to learn a lot. Miigwech.
Thank you, Claudette, for that beautiful and warm welcome. Before we get started with our first panel, there's just a couple housekeeping details that I'd like to point out at this time. The first thing I want to make you aware of is that there's the Wi-Fi access and password on the board here to my left. So those of you requiring Wi-Fi, the network name's at the top and then the password is underneath. Today's forum, as you'll notice, is being webcasted or broadcasted, and it's also being simultaneously taped. And that taping will be made available for all of you participants later on, I guess next month. We just need a little bit of time to edit it and get it together. After the forum, there will also be an outcomes document created. So this will be a practical and brief report with a series of recommendations that will be drafted for review, publication, and distribution to all of the forum participants. So we'd ask you to please visit our web domain, fpicforum.ca. To gain access to these materials. And we'd also ask that you ensure that we have your email and your name provided and written down at the registration table so that we can send these documents to you or make you aware of when they become available. So without further ado, I'd like to turn the time over to our first panel and we'll get started on today's fulsome agenda.
Are we good to go? Good morning. My name is Jennifer Preston, and I work for Canadian Friends Service Committee, which is the justice arm of the Quakers in Canada, and it's my privilege and honor to moderate our first panel today. As we are the first panel of the morning, before we begin our panel, I'm just going to say a couple of words about this symposium in general. The symposium was conceived by a group that loosely forms under the title of the Coalition for the Human Rights of Indigenous Peoples, which is a group of organizations, NGOs, faith-based groups, and Indigenous organizations that work together mainly around implementation of the UN Declaration on the Rights of Indigenous Peoples. And at one of our meetings last year, or perhaps the year before, there was discussion about having a symposium on FPIC. And so it was sort of a small seed that grew over a period of time with a lot of people involved. And then finally last fall, a steering committee was formed. And you can see on the list the various organizations that have been involved in putting this on. Our objective in the beginning of this idea was that, particularly when we're talking about implementation of the UN Declaration, that free, prior, and informed consent is something that is not well known or well known well. And we wanted to improve and increase the dialogue or the narrative in a positive way, in part because of our deep concerns of the narrative that exists that is not necessarily positive or not always accurate. So that's where the seed of this came from, and our hope is that over the course of the day today, that it will be a learning, rich experience for all of us and everyone who's also watching online. We had considerable numbers of people who registered to be online, so we're aware that you are with us also, and we welcome everyone here today. And we're so fortunate and pleased to have this space here at the University of Ottawa. So also, as we begin, I want to thank Claudette for our welcome and our blessing for our work here today. And also to acknowledge the Algonquin territory that we're all meeting on here today, and how lucky we are for all of these pieces. The symposium in itself started last night. We had an evening event, an evening reception at the Wabano Center, which for those of you who have been there is just a totally awesome space. We had a really rich evening, and we had Chief Roger William give us a presentation and talk on the journey of the Chilcotin Nation and the journey they had towards the Supreme Court, which of course the decision that came out almost a year ago now also was an impetus for us to go ahead and make this symposium become a reality. And so we were blessed with Chief Rogers' words and a song last night. You will hear from him later this morning as well. And some of the things that we talked about last night at the Wabano Center, we also had some words from the elder there, Elder Paul, and we also had words from their executive director, Allison. And there was some talk about how we were talking about clarity, and we were talking about the power of stories. And again, that leads us back to how we wanted to frame this symposium is about improving and increasing the narrative. And one of the things that Chief Roger said that I'm sure stayed with everyone there last night was that, we know our story, we know our past, and now we're all moving forward. And when we see where we want to come out of this day together, it's part of that moving forward and moving forward into a better reality. We did have some discussion about the order of the panels here today, and we had decided that this first panel would be our legal panel, because what we wanted to do is start your day with the context that free, prior, and informed consent, or FPIC, is not just a standard and social license, that it in fact has a legal context, both in international law as well as domestic Canadian law. And so we decided that's where we would start the day so that the rest of the day can build on that context. So now I'm going to introduce our panelists to you, who are going to give us that context in the order that they are speaking. So to my right, we have Daly Sambodoro. Daly is currently an expert member on the UN Permanent Forum on Indigenous Issues, and she's the former chairperson of the UN Permanent Forum on Indigenous Issues. Daly has a PhD from the University of British Columbia Faculty of Law and a Master of Arts in Law and Diplomacy from the Fletcher School at Tufts University. Daly is currently an Associate Professor of Political Science at the University of Alaska in Anchorage. She is an Alaska member of the Inuit Circumpolar Council Advisory Committee on UN Issues and a member of the International Law Association Committee on the implementation of the UN Declaration on the Rights of Indigenous Peoples. I met Daly in Geneva in the working group on the UN Declaration on the Rights of Indigenous Peoples, and Daly was one of the leaders who made a profound difference in the development of that instrument over its 20-year history at the UN. She was an active participant in the work from 1985 up to the adoption of the declaration by the UN General Assembly in 2007. And she was also a direct participant in the 2-year revision process of the International Labor Organization, the ILO, Convention number 107, which resulted in the adoption of Convention 169 concerning indigenous and tribal peoples in independent countries. During her tenure at the Inuit Circumpolar Council, Daly has been responsible for not only the international human rights standard setting work, but also the coordination of the Alaska Native Review Commission, which is regarded as the most important comprehensive reviews of the impact of the Alaska Native Settlement Act of 1971. And this commission's work was led by the former British Columbia Supreme Court Justice, Thomas Berger. And Daly will provide us with the international law context on FPIC. And then to my left, I have Lorraine Land. Lorraine will be speaking more to the domestic legal context. Lorraine is a partner at Otheus Clear Townsend, OTK. She represents Aboriginal clients from across Canada in negotiations and litigation on Aboriginal land rights and claims, Aboriginal consultation issues, impacts and benefit agreements, energy project reviews, and environmental matters. Lorraine was recently chosen by her peers and named in Lexpert as one of Canada's leading Aboriginal law experts. Lorraine has also served as legal counsel and acting director of legal services for the government of Nunavut, providing legal advice on a wide range of matters to the Ontario government, and as acting director overseeing provision of civil legal services in the territory. Lorraine is a member of the Ontario and Nunavut bars, past chair of the Aboriginal law section of the Nunavut branch of the Canadian Bar Association, and she's also currently adjunct faculty at Osgoode Hall Law School and teaches on Aboriginal peoples and resource development. So please join me in welcoming Daly and Lorraine to give us our legal context.
Thanks for putting a mic here. I don't know where the technical person is in the room, but I understood that there was only a lamp here. But first of all, Claudette, thank you very much for the welcome to your territory. Last night, I definitely felt the warmth of the welcome at the Wabano Center, and in particular Allison Fisher's introduction and also brief tour of the Wabano Center, which was really, really wonderful. First of all, let me thank the organizers. I was trying to count last night. I think there were 12 different organizations that are co-hosting this event. So thank you very much for the invitation to this important public forum on the crucial issue of the right to free, prior, and informed consent. In the next few minutes, I'd like to highlight the normative standards and international law concerning the right of Indigenous peoples to free, prior, and informed consent, and in particular, focus on this matter as it's affirmed in the UN Declaration on the Rights of Indigenous Peoples, as well as touch on the customary international law provisions of the Declaration that, in my view, reach into the neighborhood of free, prior, and informed consent. Before I begin, though, I want to reference a couple of examples on the implementation of free, prior, and informed consent in terms of especially the negotiation of the UN Declaration. As Jennifer pointed out, I was one of the key persons involved in the drafting of the UN Declaration on behalf of the Inuit Circumpolar Council. and also engaged in the 2-year revision process of ILO Convention 107, which resulted in ILO Convention 169. And throughout these processes, I focused on the right to self-determination, collective rights, free, prior, and informed consent, and a host of other provisions now affirmed in the UN Declaration. Throughout this drafting process, I was fortunate to have very good rapport with a number of government representatives, but in particular Ambassador Tui Lehmann of Denmark. Before the declaration was adopted by the Human Rights Council in 2006, and later when it shifted to the General Assembly, Ambassador Lehmann made a point of asking the representatives, the political leaders of the Inuit Circumpolar Council, whether or not we approved of the declaration in the form that it appeared at every single interval. Such a question was especially critical immediately before its adoption by the Human Rights Council and by the General Assembly. And from my point of view, this is an extraordinary example of the exercise of the right of the Inuit to free, prior, and informed consent at the international level. It represents ongoing dialogue, good faith, intellectual honesty, and genuine confidence-building measures between a member state and the beneficiaries of the rights affirmed in the UN Declaration. There was never a single doubt in my mind about the actions that Ambassador Lehmann would take publicly or privately to advance the UN Declaration, consistent with the human rights, views, and interests of Inuit. I know he was an anomaly in the overall drafting process, but for him to recognize at every stage that our free, prior, and informed consent in terms of the way the declaration appeared at every moment in time was important. And again, I think he was an anomaly as far as government diplomats are concerned. But again, it's an example in my mind, at least in terms of international negotiation, of how you put free, prior, and informed consent into action. Another example of free, prior, and informed consent from my point of view as somewhat of an outside observer to processes has been displayed in the framework of the Comprehensive Land Claims Agreements in Canada. If one studies at least just the procedural aspects of the decades-long negotiations to affirm Inuit rights to lands, territories, and resources throughout these various land claims agreements, like the James Bay Northern Quebec Agreement, the Inuvialuit Agreement, the Labrador Agreement, the right and principle of free, prior, and informed consent emerges. Each of these agreements involved the free and direct participation of Inuit in the negotiations, public information, as well as a comprehensive understanding of the terms of the agreements prior to a referendum of those concerned and eligible to vote. They were expressing their consent to the overall final agreements as they emerged. And I know that none of these agreements are perfect and that problems with implementation have emerged. However, the ratification and enumeration provisions reflect a unique example of how the state and Indigenous peoples can ultimately achieve free, prior, and informed consent. With regard to the normative standards, it's important to establish that the source of the right to free, prior, and informed consent is the right to self-determination. Free, prior, and informed consent is derived from this primordial, pre-existing, and inherent right of Indigenous peoples. The principle of self-determination is affirmed in the United Nations Charter, and the right to self-determination is explicitly affirmed in Common Article 1 of the International Covenant on Civil and Political Rights, and also the International Covenant on Economic, Social, and Cultural Rights, as well as in Article 3 of the UN Declaration on the Rights of Indigenous Peoples. It's important to underscore the fact that the right to self-determination affirmed in each of these international law instruments is exactly the same right. Furthermore, legal scholars have expressly affirmed that the right to self-determination is a prerequisite to the exercise and enjoyment of all other human rights. The recognition of and respect for the right to self-determination is required. It is interrelated, interconnected, indivisible, and interdependent for the exercise of the right to free, prior, and informed consent, as well as all other rights affirmed in the UN Declaration. Indeed, Article 1 of the International Covenants and Article 3 of the UN Declaration are about choice. And essentially, these few words encapsulate much of what we as Indigenous peoples are concerned about. I mean, if you think about the language of Article 1 and Article 3, it really says everything about what Indigenous peoples desire. All peoples have the right to self-determination. By virtue of that right, they freely determine their political status. This is about choice, right? And freely pursue their economic, social, and cultural development. Maybe in the Indigenous context, we would insert spiritual development as well. But if you think about it, these few words really reflect everything that Indigenous peoples desire in terms of safeguarding their rights and promoting and protecting their rights. Common Article 1, in the second paragraph of the Covenants, makes important reference to natural wealth and resources. This language corresponds with the provisions of the UN Declaration pertaining to the rights of Indigenous peoples to their lands, territories, and resources. And the final sentence of Common Article 1, Paragraph 2, concerning our own means of subsistence, is really about our traditional economies, which is the essence of Article 20 of the UN Declaration. If I were savvy enough, I'd have a PowerPoint, and you'd see all the language and could make the linkages, but essentially, if you think about the final phrase of paragraph 2 of Article 1 of the International Covenants, in no case may a peoples be deprived of their own means of subsistence. It's pretty strong language. We argued for that in the context of the negotiations of the Declaration. We didn't win the day on that particular point, but Article 20 of the UN Declaration does in fact embrace this concept of safeguarding our traditional economies. Naturally, this article is related to various other UN Declaration provisions concerning our relationship to the environment, the integrity and productive capacity of our environment, traditional knowledge, and the development and use of our lands, territories, and resources. All of these provisions are fundamental elements of the right to self-determination. Such an understanding is consistent with the interrelated nature of human rights and the linkage between the exercise of the right of self-determination and the right of Indigenous peoples to own, use, develop, and control the lands and territories and their resources. In this way, one must interpret every provision of the UN Declaration in the context of the whole of the Declaration and other international human rights law, including the UN Declaration's overall spirit and intent. Before I continue, I want to say a few words about the standards affirmed in the Declaration in regard to general international law and customary international law. I think it's time that we recognize that it's indisputable that customary norms concerning Indigenous peoples and their pull toward compliance are a reality in the context of the contemporary international legal order. I mean, it seems like decades, but really it's a short period of time in which we've come a long ways. We can't put any of these things back in the bag, so to speak. According to both the International Law Association and also the former Special Rapporteur on the Rights of Indigenous Peoples, James Anaya, the UN Declaration does in fact include such customary international norms. Both the International Law Association and Special Rapporteur Anaya have asserted that though the whole of the Declaration cannot be considered as an expression of customary international law, some of its key provisions can reasonably be regarded as corresponding to established principles of general international law, therefore implying the existence of equivalent and parallel international obligations to which states are bound to comply with. According to the ILA, and their expert commentary on the Declaration, the relevant areas of Indigenous peoples' rights with respect to which the discourse on customary international law arises are self-determination, autonomy or self-government, cultural rights and identity, land rights, as well as reparation, redress, and remedies. However, it would be inappropriate to deal with these areas separately. The rights just listed are all strictly interrelated to the extent that the change of one of its elements affects the whole. So if you think about the linkage between the right of self-determination and the right to free, prior, and informed consent, and you start messing with the latter in particular, you start to really mess with the right of self-determination of Indigenous peoples. That's what we mean by the linkage. The explicit references that comprise the normative standards related to free, prior, and informed consent within the UN Declaration include 6 provisions. 2 of the provisions concern forcible removal of Indigenous peoples from their lands and also storage and disposal of hazardous materials without the free, prior, and informed consent of Indigenous peoples. The other 2 relate to redress for cultural property and also redress for lands, territories, and resources taken without the free, prior, and informed consent of Indigenous peoples. Articles 19 and 32 make a clear connection between the duty of states to consult and cooperate in good faith with the Indigenous peoples concerned through their own representative institutions in order to obtain their free, prior, and informed consent to legislative and administrative matters and approval of projects affecting their lands, territories, and resources. Because of the reality of contentious issues between states and Indigenous peoples, specifically over lands, territories, and resources, and the abuse of Indigenous peoples' rights related to forced development or the exercise of development by others, namely colonial forces and powers or extractive industries, the part concerning lands, territories, and resources of the UN Declaration, when I say part, I mean several different provisions, this part was one of the most difficult to negotiate. You know, it's always been about the gold, right? Lands, territories, and resources. And of course, the right to self-determination was difficult to negotiate and finalize, but even more so, the rights to lands, territories, and resources was extremely difficult to negotiate. At one point, the proposed wording of Article 32 was that states would only have to seek Indigenous peoples' consent rather than to obtain consent. This is a dramatic difference, and that's just one example of the difficulty of negotiating some of the text. We could seek to do any range of things, but to have a very positive, explicit, affirmative requirement to obtain consent is finally what emerged in Article 32. So the present wording of Article 32 affirms Indigenous peoples have the right to determine and develop strategies for the development or use of their lands and territories and other resources. In accordance with Article 32, states must consult and cooperate with Indigenous peoples in order to obtain their free, prior, and informed consent prior to the approval of any project affecting their lands or territories and other resources, particularly in connection with the development, utilization, or exploitation of mineral, water, or other resources. So that's the content of Article 32. At this point, rather than addressing the procedural operation of the rights and standards related to free, prior, and informed consent, I'd like to establish their place in international law and customary international law specifically, as it gives rise to the important legally binding obligations of states that intersect with the right of Indigenous peoples to free, prior, and informed consent. Hence my earlier reference to the idea that such rights intersect with those that are considered within the neighborhood of customary international law. I make the reference because we as Indigenous peoples have the right to be consulted with respect to any project that may affect us as well as the related rights concerning projects that may significantly impact our rights and ways of life that are carried out without our free, prior, and informed consent. Indeed, the matter of free, prior, and informed consent has been and continues to be the subject of growing concern in the supervisory bodies of a number of legally binding UN human rights treaties. In fact, some of these important jurisprudential decisions by treaty bodies were being made well before the adoption of the Declaration, demonstrating that the UN Declaration, in merely its draft form, held the force of legal and moral imperatives in regard to the conditions Indigenous peoples were facing and their distinct status and human rights. Specifically, the Human Rights Committee has made the linkage between Article 27 of the International Covenant on Civil and Political Rights and the protection of Indigenous lifeways as a matter of culture and the notion of control over their lands and resources to a state duty to consult with Indigenous peoples prior to any development activities. Also, the Committee on Economic, Social, and Cultural Rights, in elaborating upon the rights of Indigenous peoples to maintain their cultural life in both country-specific cases as well as a general comment, they've affirmed a link between participation, consultation, and the goal of obtaining consent of the peoples concerned, and have further called upon ratifying member states to respect the principle of free, prior, and informed consent of Indigenous peoples in all matters covered by their specific rights. So you have important treaty body decisions and observations, and also in response to specific cases requiring free, prior, and informed consent. In the context of equality, the Committee on the Elimination of Racial Discrimination adopted a general recommendation outlining the right of Indigenous peoples to participate in decision-making affecting them, and further that no decisions relating specifically to them should be taken without their free, prior, and informed consent. They further elaborated upon such an interpretation in various country-specific concluding observations. Finally, within the UN system, a range of special procedures, including the Permanent Forum on Indigenous Issues, the Special Rapporteur on the Rights of Indigenous Peoples, UN agencies and specialized agencies, as well as the General Assembly, have all embraced and affirmed that the right of Indigenous peoples includes free, prior, and informed consent. In addition to the UN human rights regime, the International Labor Organization, the Inter-American Human Rights System, and the African Commission on Human and Peoples' Rights have also pronounced important interpretive jurisprudence on the matter of the right of Indigenous peoples to free, prior, and informed consent. Also, the International Labor Organization Committee of Experts, in its interpretation of Convention 169, have affirmed the state obligation to consult Indigenous peoples, and Convention 169 in particular includes a wide range of provisions to ensure direct participation of Indigenous peoples, as well as a number of clauses that affirm again the right of Indigenous peoples to free, prior, and informed consent. I've already mentioned that the Inter-American Commission, in terms of a regional mechanism involving North, Central, and South America, they've adjudicated through the Inter-American Court, as well as reviewed through the Inter-American Commission, a range of different cases that all affirm the right of Indigenous peoples to free, prior, and informed consent. In my view, it's become clear that all consultation should be undertaken with the objective of obtaining Indigenous peoples' free, prior, and informed consent, and that especially in cases of large-scale development or investment projects that may have a major, severe, or adverse impact on Indigenous peoples' territories, consent is necessary. Moreover, consultation must be undertaken in good faith, with the participation of Indigenous representatives, and the state must provide all relevant information well in advance of decision-making. In summary, in addition to the explicit reference to the right of free, prior, and informed consent in the UN Declaration, there's a clear consensus in international human rights law that there is a state duty to consult with the goal of reaching consent, especially in the area of development projects and extractive industry activities in relation to the lands, territories, and resources of Indigenous peoples, and more often than not, requiring consent of the peoples concerned. A critical element of the operationalization of this right is for member states to dialogue and negotiate in good faith in order to achieve consent. Furthermore, there are numerous other provisions affirmed in the Declaration that require states to undertake actions in conjunction with Indigenous peoples and in consultation and cooperation with Indigenous peoples. In addition, especially the language of Article 26 of the Declaration, Indigenous peoples have the right to own, use, develop, and control the lands, territories, and resources that they possess. And if you think about the term control, in its plain meaning, it suggests to have power over, to influence, to manage, to restrain, limit, or prevent something from taking place in regard to those lands, territories, and resources. Now, this in no way translates to a purported right of Indigenous peoples to a veto, as some states, including Canada, have suggested. There's a major distinction between the procedural and substantive aspects of free, prior, and informed consent and the notion of the power to veto an action. The latter is often outlined and reserved to a legislative or a constitutional authority invested in a political leader, such as the president, or in our case in Alaska, the governor of the state has the power to veto a budget, for example. But in contrast, free, prior, and informed consent entails dialogue, negotiation between the parties concerned, in good faith, and again, with the objective of achieving consent. And even then, the peoples concerned may choose to assert the right to give or withhold consent in regard to what may or may not take place on their territories. In this regard, states must recognize that human rights are not absolute and that there is a constant tension between the rights and interests of Indigenous peoples and all others. And in some cases, this constant tension is manifested amongst and between the Indigenous peoples themselves. Uranium mining in Greenland is a perfect example in terms of what the political leadership wants, but what the Indigenous peoples on the ground may in fact have in mind with regard to something like uranium mining. The right of Indigenous peoples to free, prior, and informed consent and its actual practice and implementation is where we must go to determine its full content. The contours of and the procedural operations or implementation of the right to free, prior, and informed consent must be sorted out by those who are the self in self-determination and addressed on a case-by-case basis according to the conditions and situation of the Indigenous peoples concerned. The overarching principles of negotiation, dialogue, partnership, consultation, and cooperation in order to achieve consent is the overall framework that must be recognized and respected. This requires a demonstration of good faith by all parties concerned, government, industry, and Indigenous peoples. The days of unilateral state action are over. We have arrived at a place and time wherein unilateral actions by states are no longer acceptable, where a human rights-based approach provides a positive roadmap for the resolution of competing rights and interests, while at the same time recognizing and respecting the human rights of Indigenous peoples. This can and should be done on the basis of genuine partnership and mutual respect. And in the end of the day, persons like Ambassador Tui Lehman, who understood the content of free, prior, and informed consent, can freely and openly demonstrate the political will that creates such genuine partnership and mutual respect. Kuyanak, thank you for your attention.
Okay, we're going to go right to Lorraine now, who has a PowerPoint with her presentation.
Good morning. Kayanamik Daly. Thank you for that great start. Thank you for those of you who are here. Thank you particularly to the Algonquin people on whose territory we are today for the privilege of being able to be here to assemble. It's an honor, and I'm frankly humbled to be here. The people who have organized this event have been in the leadership in Canada at pushing these issues around free, prior, and informed consent, and linking Indigenous rights in the international context to the domestic context. And I am honored that you invited me to participate, and humbled by the knowledge that is here in the room from all of you who have been working so hard on these issues already. So thank you for all of your good hard work. So I was asked to speak to the Canadian domestic legal context about free, prior, and informed consent, and most of what I'm going to focus on today is the notions of consent as they have evolved within the Canadian legal context. Not so much FPIC particularly, but generally the notion of consent. So I'm just trying to figure out, this is not a system I'm familiar with using here. Sorry, can you give me some guidance? Okay. Got it, okay. Okay. So what I'd like to do this morning, and I have 15 minutes, Jennifer has read me the Riot Act and told me she's going to cut me off after 15 minutes. You'd think that she thinks that lawyers are long-winded or something. But I wanted to start quickly with two stories that I think illustrate the status of how Aboriginal consent is evolving in Canadian law right now, because I think the stories that we tell really help to understand the issues. And part of the struggle, part of the goal that we have is sharing those stories with each other to understand where we need to push the benchmarks. Then I'm going to talk briefly about what the current federal position is on free, prior, and informed consent. That would be quick because it's short. And then I want to talk a little bit about how the Canadian law has evolved on the notion of Aboriginal consent, and then about how we move away from the rhetoric of fear, particularly fear around the notion of an Aboriginal veto, towards humanizing the ideas in free, prior, and informed consent and implementing FPIC. So the two stories I want to start with quickly are the stories of two of my clients that I'm privileged to be able to work with, the Saugeen Ojibwe Nation in Ontario, who are in the Bruce Peninsula area and whose traditional lands and waters are Lake Huron and Georgian Bay around the Bruce Peninsula and extending down to the Goderich to Shelburne area. And the Athabasca Chippewayan First Nation in northern Alberta, who are in the midst of the oil sands. And let me start by telling you a little bit about the story, a consent story that's current, topical, from the Saugeen Ojibwe Nation. The Saugeen Ojibwe Nation have within their traditional territory one of Canada's largest nuclear facilities, the Bruce Power Facility at Kincardine. It's about 15 kilometers away from Saugeen First Nation. Saugeen Ojibwe Nation is comprised of Saugeen First Nation and Chippewas of Nawash. And right now there is a proposal underway to store deep geological waste underneath Lake Huron in the Canadian Shield, under the water, just offshore, in the middle of their traditional territory. And they have been participating in the joint panel hearings on this process, and trying to understand the technical information, but also digging deep into what the implications are for their communities, and having fascinating engagement with their communities about, for instance, what does this mean if you can have radiation that is poisoning your dotem beings a million years from now, and the notion that beings evolve over time, over tens and hundreds of thousands and even millions of years. What's the long-term responsibility? What's interesting about their situation is that after intense efforts on their part to get meaningful engagement in the process and a lot of frustrations with the way that the nuclear approvals processes work, they have managed to obtain a commitment from the proponent, Ontario Power Generation, who late last year said that they would not proceed with the DGR project under Lake Huron unless the Saugeen Ojibwe Nation consents. And this was a critical win for those communities. And now, in fact, last week, the joint panel that has been conducting hearings on this project has reported and is recommending that the project proceeds, but OPG has committed that they will not proceed unless they have the consent of the First Nations. And now this is going to be an interesting test of just how solid that OPG commitment is. It is in writing, it is verbal, but it's not, there's no legislative force to it. There's no formal agreement on it. So it's going to be an interesting test of consent. The other story I want to tell you briefly about, just to set the context for where we're at, is the story of what's happening right now with the Athabasca Chippewayan First Nation. Many of you will be familiar with their efforts to raise awareness of what's happening in the oil sands. The oil sands are right in the midst of their traditional territory. They are in northern Alberta. They are Chippewayan Dene peoples, and they have done a stellar job of helping to focus international attention on the issue of the impacts of oil sands development on Indigenous peoples in northern Alberta and the associated issues with health impacts downstream from the projects, the impacts on harvesting and traditional ways of life, and just the stunning array of devastating impacts of this development and what to do in that context. And interestingly, 2 weeks ago, you may have heard in the news that a surprising political event happened in Alberta. NDP government was elected. And one of the things that the NDP did in Alberta when they were campaigning is they campaigned hard in First Nations communities. There were signs, political signs, and candidates visiting First Nations communities for the first time that anybody could remember in Alberta political history. But also, NDP had reached out before the election to talk to the chiefs and the communities across Alberta. And in their platform, they made the commitment that we will implement the 2007 UN Declaration on the Rights of Indigenous People and build it into provincial law. So that was part of their election platform. And so now, of course, the devil's in the details to see what's going to happen now that they were elected. But interestingly, Chief Adam from Athabasca Chippewayan First Nation was right beside Rachel Notley when she was elected and gave her a victory speech. And obviously there's some hope and expectation amongst First Nations in Alberta that we may be actually looking at not only a shift in the Alberta political context where in fact the Aboriginal consultation processes have been frankly abysmal and unconstitutional. That's my legal position because I'm arguing that in some cases. But you may actually be ironically in the situation where Alberta, of all jurisdictions in Canada, may be the first one to actually enshrine FPIC into provincial law. Wouldn't that be interesting? So what are some of the themes that these stories help us to elucidate? These are just some of the ones that come to top of mind. That the reason why these issues are hot and topical is that the current legal context for consultation is leaving big gaps in Indigenous rights protections in Canada. That there are situations where consent is being achieved, but it's in a checkerboard and erratic fashion without a systemic legislative or regulatory commitment being made. That there's a lot of domestic pressure now happening for free, prior, and informed consent that's being influenced by international pressures. These two clients that I just talked about have been very good at connecting their issues to the international context and international forums and generating international focus on their concerns. But also that there are complex issues that lie at the heart of these relationships and thus at the heart of consent. For instance, in the case of the Saugeen Ojibwe, they already have enormous storage of nuclear waste on their territory sitting in these big tanks right on the shore of Lake Huron. So what do you do about that? Consent is not just about no or yes to deep geological repository. It's what do you do with this enormous stash of nuclear waste that's already in the middle of the territory? And the fact that an interesting theme here is that we may in fact be moving towards the having FPIC recognized in legislation in Alberta. So here's a few more thoughts about the current Canadian legal landscape. What is Canada's position on free, prior, and informed consent? I suspect many of you are being here today are probably somewhat familiar with it. In 2007, Canada opposed the passing of the United Nations Declaration of the Rights of Indigenous Peoples. They were one of 4 nation states around the world to do so. Eventually, in 2010, Canada finally endorsed the UN declaration, but with caveats. They said that Canada's endorsement of the declaration was aspirational, and that they did not recognize UNDRIP as legally binding. What's happened more recently? 2 things that happened very recently. Recently, Canada at the World Conference of Indigenous Peoples, Canada's position when they were responding to the outcomes document was that they can't recognize FPIC because it can be interpreted as providing a veto to Indigenous people, and that cannot be reconciled with Canadian law. Just a couple weeks ago, I think a week and a half ago, we had a bill that died in the House of Commons on second reading, and that was Romeo Saganash's proposed bill C-641. That was an act that would have ensured that Canadian laws are in harmony with the UN Declaration. And again, in the parliamentary debates, the representatives of the government took the position that it's not possible to recognize UNDRIP because it's inconsistent with Canadian law, and they cannot be in a situation where Indigenous peoples would be allowed a veto. So that leaves a question about, is free, prior, and informed consent, as it's articulated in the UN Declaration, really incompatible with Canadian law? So there's 2 bases on which Canada says that. One is that it's inconsistent with the Constitution and the current state of Canadian law on Aboriginal consultation, and the other is that their other position is that international instruments are not legally binding. But indeed, there is a deep legal history in Canada of the notion of Indigenous consent, going all the way back to, for instance, the Royal Proclamation in 1763, that was based on the premise that when lands were acquired by sale or surrender from Indigenous peoples, that had to happen by consent. That goes right back to the early colonial history. There's been this constant theme and tension in our legal history, in our social history in continental North America, that has recognized that Indigenous people were certainly requiring consent from their perspective, and that the Crown in certain situations was respecting that, for instance, in the articulation of the Royal Proclamation. In more modern, I'm only able to give you a very 10,000-foot level overview of my perspective about where the notion of consent is in Canadian current case law. So I'm going to now focus a little bit on the modern Supreme Court cases that engage with consent in the context of Aboriginal rights cases. And I want to look quickly at the arc that goes from the Calder case in 1972 to the stunning 2014 Chilcotin decision on Aboriginal title. Starting with Calder in 1972, which is the first big seminal Aboriginal title decision in Canada, that established the principle that Aboriginal title can still exist, although in that case the Supreme Court split on whether the Nisga'a Nation still retained it, and that partly had to do with legal debates about whether the Royal Proclamation applied in British Columbia or not. But one of the things that's interesting in the Calder decision, if you read it, is that the judges refer to correspondence that happens in the 1850s and 1860s between the government in Victoria at the time and the imperial government in London, that's outlining the expectation of groups in current British Columbia that they have to consent to the sale or taking of their lands. And there's some dialogue and implicit acceptance of this. The debate between London and Victoria is who should pay for that sale, and London says it's up to you, colonial government, and then BC just never does it. Then, of course, in 1997, we have the important Dalgamook decision. That was one of the first major modern decisions on Aboriginal title. And in that case, you see for the first time the Supreme Court, in the context of looking at Aboriginal title, engaging with this issue of consent. And in Delgamuukw, again, the court finds that it is possible to establish Aboriginal title in Canada. They lay out the legal tests for how that has to happen. What are the legal benchmarks you have to meet? On the facts of the case, they don't find it because of other problems in the case history and the evidentiary record, and they send it back down to trial. So after 20 years and millions of dollars, the First Nations, as is so often the case, have to go back to the beginning to start it all over again. But it established this principle, again, that Aboriginal title could be proved, and if Aboriginal title was proved, then that there were benchmarks for when it could be infringed or impeded upon by the Crown, and made it clear that in some situations that consent would be required. So the notion of consent comes out very strongly first in the Delgamuukw case. And then you see the court pick up on that in the Haida case. So Haida in 2004, the Haida and Taku River Tlingit cases are the two leading Supreme Court cases that established the concept of the duty to consult. And they had to do with situations about what are the legal obligations when you have Aboriginal rights that have been asserted, including Aboriginal title, but not yet proven. So then what's the responsibility of the Crown? What's the responsibility of industry? And in the Haida case, again, the court looks at the question of consent and says that the duty to consult First Nations or Aboriginal groups can vary. So it comes up with a spectrum analysis and says it can be anywhere from a minimum duty to discuss the issues with the First Nation all the way up to the requirement for full consent when there are serious issues. And I think what's really important about Haida that is helpful is this understanding of the spectrum relationship, and I'll come back to that because it's all about the relationship, and I think that is the core of what we're talking about, is that human rights and Indigenous rights are always relational. So when you talk about consent or veto, you have to understand that in context of this is happening within the give and take of a relationship. What Haida does also say, the Supreme Court in Haida does also introduce this notion of veto, and this is where the federal government picks up on this notion of veto. And the court says in Haida, there's no duty to agree. The process doesn't give a veto to First Nations groups or Aboriginal groups about what can be done. And then it goes on to talk about that the consent spoken of in Delgamuukw is appropriate only in cases of established rights. So it's not saying that consent is never appropriate. It's saying that you have a spectrum, and in some cases, it's not going to be appropriate to have a veto. It's all about the consent process and the spectrum of obligations. Rather, what is required, the court says, is a balancing of interests. In other words, consent is still required in some situations, but it's all about that balancing of interests, the spectrum of the relationship. And Haida unpacks it and says, well, you have a weak claim and there's no serious impact, then the duty of the Crown to consult with First Nations is more minimal, and you go up the spectrum to where you have a strong claim, where there's a lot of evidence of serious impacts, where, for instance, you have a proven right. And that's where you get to the consent end of the spectrum. So I think that that's the helpful way of thinking about consent, is it lies on a spectrum of what occurs in different situations. In the Mikisew case, which comes after Haida, which is a treaty rights case about the duty to consult involving Treaty 8 and roads up in Wood Buffalo Park, the court again uses the language of veto and says here, if the consultation process had gone ahead like it should have, and the court says there should have been consultation in this case, it wouldn't have given Mikisew a veto over the alignment of the road. The language of veto has to be understood in the context of looking at what was going on in that case. It was a more minimal impact. It was a strong claim. It was a proven right, a treaty right, but a potentially minimal impact in terms of what the practical effects were on the harvesting right. So there still had to be consultation, but no, this may not be a situation where a veto would be required. And then, of course, most recently we get to the seminal Sokotan decision, and we're very honored to have Chief Roger with us today. He spoke last night as well. I think we all owe a deep debt of gratitude to his First Nation for their tenaciousness in bringing this case forward over the past 30 years. And in Silcotin is important for a number of reasons. First of all, because it's the first time that Supreme Court has actually said, based on the facts, here's a situation where an Aboriginal group has actually established that they retain Aboriginal title. They have title to the 1,700 square kilometers of territory. They also have Aboriginal rights that continue throughout the entire traditional territory. And the court expands on the notion of consent and places it within the context of the test for when it's justified for the Crown to infringe on Aboriginal title. So the court says that the right to control the land means that governments and others seeking to use the land must obtain the consent of the Aboriginal title holders. If the Aboriginal group does not consent to the use, the government's only recourse is to establish the proposed incursion on the lands under the justification test. And then they go on to, I won't go into the details, but for you legal beagles there, it's a new, I think, more robust articulation of the justification test that takes it a further step further in terms of Aboriginal title context. So Silcotin is important because it explores that concept of Aboriginal consent in more detail than in previous decisions. There's quite a bit of discussion about the notion of consent in Silcotin, and including focusing on what the Aboriginal perspective is on consent. In Delgmuuk, for instance, the perspective was the balancing test as seen from the perspective of the state. What's in the public interest? What do the non-Aboriginal people need in terms of a process? Silcotin makes it clear that you have to look at consent from the perspective of the Aboriginal nation whose rights are being impacted. The Supreme Court doesn't say specifically in the decision that they are endorsing the FPIC principle of free, prior, and informed consent as articulated in the UN Declaration, but they do emphasize consent is a starting point for the analysis. So as you can see, the notion of consent is firmly embedded in the arc of modern Canadian Aboriginal law on Aboriginal rights and title. Then, of course, the other argument that Canada makes is that international instruments and covenants are not enforceable in Canadian law. There are more international law scholars out there, and some of you who have worked on this issue. I'm just going to give a very brief overview to say that that is not a tenable position any longer. There is a clear line of cases in Canadian law that do outline how international human rights laws are enforceable in Canada, that customary law applies directly as part of Canadian domestic law, unless there's a specific law that ousts it, and that there's a presumption of conformity between Canadian statutes and international law, unless there's an intentional articulation that would oust that presumption of conformity. More recently, there was an important case, the Canadian Human Rights Commission versus Canada, that unpacked some of these principles even further, saying that Parliament is assumed to act in compliance with its international obligations, and that courts will interpret Canadian law to be consistent with the values and principles in international law. So why then does Canada use that language about veto? It's the language of fear. I think this is not a probably surprise analysis to any of you out there. I think a helpful way of understanding fear is false evidence appearing real. And that's exactly what this is. The false evidence that the message about veto and the fear about an Aboriginal veto is trying to tap into are the assumptions that all development proposals are reasonable, that all Aboriginal groups are anti-development, that Aboriginal groups are or will be unreasonable in making decisions, and this is an important one. I think this is a really strong myth in the Canadian narrative that we really have to address and put the boots to by telling practical stories that illustrate how that's not the case, and that other Canadians will suffer a loss if Aboriginal groups gain, that there's a win-loss scenario happening as opposed to a mutual gain. So how do we refute the fear? By articulating and exposing those fears and by showing the alternatives, including through the stories. There was discussion last night about the stories. I think that's so key, the stories, the culture, the way in which the rights are embedded in the culture through, as articulated through stories, through music, through art, all those different things. It was amazing to be in the Wabano Center last night to see that amazing space and to talk about Indigenous rights in the context of that beautiful healing space where the culture was so evident in the process and the space and the art around us. So supporting robust institutions of Indigenous governance is one of the ways to put the boots to the narrative about capricious decision-making in Indigenous governments. It's not the case factually that it happens. It does happen in some government cases as it does in non-Aboriginal society. But we need to tell the narratives and build the narratives and the practical experience in the robust Indigenous government institutions that respect the rules of natural justice. And we need to keep telling the stories about FPIC in action, what's actually happening in terms of consent, how communities are working it out on the ground, achieving the wins. And I think it's finally important in terms of the law to see that the concept of the free, prior, and informed consent is part of a growing branch on the tree of Canadian law. The law is not static. It's not just articulated in books. It is an evolving, growing, organic process whereby we as a society decide on our common norms and values, and FPIC is part of a modern articulation of how we understand human rights of Indigenous peoples. It's a growing story, and it's exciting to be part of that growth. I do think we are on the cusp of seeing some important and very positive developments in terms of recognizing FPIC in Canada. Thank you.
Great. Now we have some time for some Q&A, and I just want to remind people that are watching this on their computers at home or in their office that you can also pose questions online, and you do have to either have a Gmail account or a YouTube account to do that. Or if you don't have either of those and you don't actually, the instructions are on the website on how to do that. If you don't want to do that, the other thing you can always do is tweet your question. And we have a couple of people in the room that are moderating what's going on online. And so we will also be sharing your questions. So I will, and also encourage people who are using Twitter to use the hashtag FPIC Forum. So maybe, in fact, I'm going to let Craig start us off. No, I'm not. No, I'm not going to do that. All right. So for the people who are here in the room with us, we have 2 microphones set up. So you can go to either one of these microphones if you have a question. And I would just like to remind people, if we'll keep our questions reasonably brief so that we can keep the discussion going. And also remember, this is only the first of 4 panels over the course of the day, and to try and keep ourselves on topic as we go forward. We don't have an extraordinary amount of time for questions, but we will. We have a time for a few. And John?
Thank you for those excellent presentations. John Merritt, I'm an in-house counsel at Nunavut Tungavik. Question for both Delia and Lorraine. We know that the UN has recognized a collective right, perhaps for the first time in the human rights sphere. What does that entail, or how would you speculate how that will play out in terms of how Aboriginal peoples provide consent? Delia, you mentioned Greenland, a discussion between the Greenland government and people in communities, but how does that in the future impact on how Aboriginal people exercising their right will come to their own conclusion?
Sure. Yeah. Go ahead.
Toward the end of my presentation, I referenced who is the self and self-determination. And I think that, for example, and my reference to the Labrador Agreement, where it was very clear, and they enumerated who, in fact, would express consent through a referendum and ratification of a final agreement. And I think that both of those things are connected as far as the exercise of the collective right and how these decisions will in fact be made in terms of the self and self-determination. In our own context in Alaska and the I would venture to say, the imposition of the Alaska Native Claims Settlement Act becomes very, very complicated as to who is the self in self-determination. And you hold that against the backdrop of the tribal governments, for example. Are they the self in self-determination as far as a collective decision about free, prior, and informed consent? So I think that content and how to implement it has to be really handled on a case-by-case basis. And for the situation in Greenland is very complicated because technically the government is a public government. It's not an indigenous government. And so the self and self-determination, you're going to have to, I think, from my point of view, in terms of the right as affirmed in the UN Declaration, and a important question like uranium mining, you have to kind of peel away those layers and get to the expression by the indigenous peoples most directly impacted, and in this case, the communities that will be directly impacted, and their particular voice has to be heard. And I think to date, on that particular issue, the voices of those that will be most immediately impacted have not had a chance to express anything even remotely close to free, prior, and informed consent. But that is to say that I'm a little concerned about this notion of a sliding scale, so to speak, in terms of the severity of impact. And even the special rapporteur, the former special rapporteur, James Anaya, kind of toyed with this idea. And this is the way it's constructed now as far as the UN Declaration is concerned. But I think we have to be careful about that approach. And I think it's going to be played out on a case-by-case basis. And in some areas it's pretty straightforward. In other areas like Greenland or like Alaska, it's really complicated. I don't think there's an easy answer to that. Thanks for the question.
Yeah, just a fast response. Thanks for the question, John. Two fast things. One is that the international covenants around the rights of the child are also covenants that deal with the rights of a child within the context of a collective, the collective being the family. And I think it's going to be really illustrative to also look at what's happening in that context in terms of how it's unpacked. But I think it gets at a both an important and difficult theoretical and also practical question, which is that Indigenous rights are inherently collective rights, and how does that interplay with modern individual liberal human rights regimes and state law and concepts that are so embedded with that. And I would just point out that I don't have all the answers, but I'm looking with great interest and expectation to a thesis that's being completed now at the University of Victoria by Aaron Mills, who's an amazing young Anishinaabe scholar who is doing his PhD in law, looking at the inherent and perhaps unreconcilable tensions between Anishinaabe law, particularly the collective notions of Anishinaabe law, and contemporary liberal individual law concepts. So I think that there's going to be some interesting scholarship that will help us as practitioners to push our understanding on those issues.
Okay, and now I'm going to Craig, who has an online question.
So one of our online participants had a question for Lorraine. The question was, do you agree that the comprehensive land claims agreements can establish a solid foundation for FPIC?
Well, I think that the whole landscape of comprehensive land claims agreements is changing now in the wake of Chilcotin. I think everybody is stepping back and trying to understand what the existing comprehensive land claims process, what the existing agreements all mean in the view of the Chilcotin decision. I think what's important to remember is that the comprehensive claims are capture at a moment in time the understandings of the parties about what the basis of the treaty agreement is. But as the court has already made clear, the entirety of the legal obligations are not within the text of the treaties. That's the Little Salmon Carmack's decision. So there will always be this overriding common law obligation of, that looks at what the state's obligation is to Indigenous peoples based on the laws we understand of Aboriginal rights. So I think they can be a mechanism for capturing particularly processes for consent, but they will never oust the obligation legally, in my view.
I'm Dan Rubenstein. I'm a consultant. I do work in accounting for natural capital. My question is for our first speaker. You said, quote, "The state must provide all relevant information in advance." What is that all relevant information? Could you unpack that for us?
Well, again, it's, as far as that specific reference in particular was in the context of, for example, a comprehensive land claim agreement. And all relevant information, the various different provisions that would either affirm right to land, also measures related to co-management, measures related to harvesting rights. And I think in terms of comparative analysis, and I'll take the situation in Alaska and the Alaska Native Claims Settlement Act, all relevant information wasn't provided. And in the context of affirmation of Aboriginal right and title to approximately 10% of the whole of the territory of Alaska, in the mind of a person like my grandfather, he thought that this meant that all the territory he traditionally harvested, the area that he traditionally hunted on, was going to be affirmed and entrenched forever and ever and ever. And that meant something completely different to him than it meant to the individuals that had access to the information as to only 10% of this territory. And by the way, purportedly your Aboriginal hunting and fishing rights would be extinguished. We'll take care of that later. I mean, this is an example where that's pretty relevant information. The information should have been provided so that people knew what kind of deal they were getting. And this is in contrast to, and I'll take the Labrador Agreement as an example. And I'm saying this as an outside observer to the process in terms of those who sat at the table and negotiated word for word exactly what the content would in fact be, understood it, and were able to then translate that to the people who are going to be the beneficiaries of that land claim agreement. So in terms of all relevant information and understanding the substance and the content and what was being put on the table in order for you to provide your agreement to it and to consent to it, that was very, very clear. And I think it again depends on the particular case and the rights and the implications of the various different provisions. And they could be on a very micro, small scale, or they could be on a major, comprehensive scale. And in their case, Labrador for certain, it took decades. In our case, it was a matter of congressional action that actually took place in a relatively short period of time where people weren't afforded the opportunity to understand the full content of what we were supposedly gaining in a settlement act.
Thank you.
Hello. Nice to be here. Thank you for organizing such a distinguished event. I was last night at 299 Montreal Street, and this is certainly a distinguished place, and thank you very much. I just want to build on a little bit of what one of the speakers said, but first I'll introduce myself. I'm Hector Pictou. I have held the title of National Chief for the Atlantic Region, elected 1983, 84, 85. We sat around the constitutional table with then Prime Minister Pierre Trudeau, March 15 and 16, 1983. So I'd like to say that I'm proud to tell you that I helped write the book on treating Aboriginal rights, recognizing Indigenous women, female persons as human beings with rights. For that, I'll just let that to you for information. Thank you. But I want to say that I thought I heard one of the speakers say that let's not invent the wheel. And sometimes I begin to believe that we are, or that you are. Maybe unintentionally. But I want to tell you that the Mi'kmaq, although I might say I'm from the Atlantic region, I don't want to give any illusion that I speak for anyone from the Atlantic region, but I did hold the title of National Chief for the Atlantic region. So I want to make that distinction. I don't want anybody to come back tomorrow and say, well, this guy speaks for no one. But I want to tell you that the Mi'kmaq have taken their cases to court many, many times. On February the 10th, 1926, then Grand Chief Gabriel Syliboy, in court, this is what the court said. And I put this out to the scholars here. We're in a law building. We have some distinguished people here, men and women who care. So I say this to you. This is what the Crown Prosecutor said to then Grand Chief Gabriel Syliboy. Oh, yes, of course, we know that there's such a thing as a Treaty of 1752, but that was only signed with the local chief and the local governor who had no authorization to do that. It wasn't passed through an act of parliament. I wonder if in 1752 the king was concerned about a parliament. I would say not. He was the first and last word on all of these issues. Then Grand Chief is found guilty for having beaver pelts. Some say muskrat, but whatever the difference is, pelts, and convicted. 1957, then Anthony Francis brought the Jay Treaty to the court, then the Treaty of 1752 to court. Then these men were found guilty. So you scholars, said, and those of you who knew him, I only knew him in passing, although I was invited to some of his wine and cheese parties, but nevertheless I didn't know him quite as well as some of you scholars here. This is what Pierre Trudeau said. I might add Prime Minister Trudeau, who chaired the constitutional conferences in 1983. He said on the afternoon of the 16th, I will take what we agreed on here yesterday and today into Parliament to debate it with the intent of passing it into law. He looked around the table at the premiers and he said to you, and I urge you to bring this back to your provincial legislatures, debate it with the intent of passing it into law. And he said, I want this done no later than the 31st of December, 1983. Ladies and gentlemen, distinguished people, my good friend Roger sitting right here, met him last summer in July in Halifax. I totally honor him. These laws that we're talking about as treaty and Aboriginal rights, they're not standards. These are laws of the land. When we sat there, then Prime Minister Trudeau said, these will be supreme laws. Those of us who were sent to Catholic schools, we were told God is supreme. I dare anyone to question me on that now. So I want to ask you, please, take these laws that we put in place in 1983, laws of the land, and I'm going to conclude, and I want to ask you a question. Thank you for your patience. Section 53, this is how the first three lines read. The Constitution of Canada is the supreme laws of Canada. And it says any law that is inconsistent with this provision of the Constitution is to the extent of the inconsistency is of no force or effect. Why aren't we knocking Stephen Harper down with that? Why don't we knock the racist John Chrétien down with that? Brian Mulroney took his ugly policy and he called it the Buffalo Jump of the 80s. Those of us who weren't dead when we hit the rocks on the bottom, there had been someone there to kill us. So I want to remind you what it says here now, section 52(3). Amendments to the Constitution of Canada shall be made only in accordance with the authority contained in the Constitution of Canada. And I am going to assure you that everything that these men, and maybe some women, are doing is not that at all. In fact, if we were living in a third world country, I'm sure they would have been standing against a wall already and a new batch of them to be put there. Thank you. So I want to ask these distinguished women in front here, please let it be known, tell the world that there are laws in the books that every time we pass a law, it's being undone. Undone by members in elected parliament. Stephen Harper does not represent the majority of Canada. 62% of the Canadians voted. That's 18 million people voted. And he got a small majority of that. He probably represents maybe 36% of Canada. So I want to say this, that these laws are our laws. These laws are in your book. These laws are in your constitutional laws, and you have an obligation to protect your country's constitution, because Pierre Trudeau said this will distinguish us from all countries of the world, including third world. And please, stand up. The chancellor of this university, Alan Rock, he was no friend of Aboriginal peoples. I guess I'm going to be able to live here even after saying that about him.
Hector,
But nevertheless,
I'm gonna
it's
get
true.
you.
Thank you.
Okay, thank you, Hector. Would either of you like to?
Thank you, Chief Pictou. I would say I agree with you. I think this is not about reinventing the wheel. It's about recognizing, as you say, a long historic arc that is both about the fact that these customary laws have existed from time immemorial, the understanding of Indigenous peoples about their rights and their lands, and the tension with that coming up against the state and the constant attempts to assimilate people, as you say, the white paper, the buffalo jump, and so on. I think you're absolutely right that we have, in this room we have legal scholars, legal practitioners, other people who have the ability to help keep pushing to do the right thing, which is to recognize what those laws have been saying all the way along, which is that Indigenous people must consent to what happens on their lands with their resources. And we need to keep fiercely defending that and not see that as a new exercise, but something that's part of a long and important historic, but currently pressing issue. Thank you for your remarks.
Craig, do you want to have one more before we're wrapping up here?
Well, acknowledging that we're over time, I think, just to say that one of our online participants wanted to hear more discussion about the issue of enforceability, in particular, how to hold private companies accountable to this standard. But I think that we'll have an opportunity in the subsequent panels to come back to this. So if the time is short, let's say that's on the floor.
We are already over time, and I think that is actually a major theme in panel 3. So I would suggest that we'll come back to that. And also, just to remind people that in addition to the fact that it's being webcast today, the entire forum will also then be placed online, so people can always go back and watch it if there's any parts that they are missing today. I think that out of respect for the panelists who follow us, we need to wrap ourselves up here. And we were scheduled, there is a coffee and upstairs, but rather than, I'm not going to encourage people to go off and get into long private conversations that are going to go on for a long time. I would actually encourage people to go upstairs if you want to get coffee or juice, but to come back down and while we are taking down this panel and setting up for panel 2, so that we can actually get started again pretty quickly, rather than having a lengthy break in between the panels. So please, everyone join me again in thanking. I want to thank Lorraine and I want to thank Daly for being here with us today. And to come back and reconvene in just a few moments so that we can start panel 2. Because we did go over time. We were only 2 panelists. It's okay.
I should have X'd out a bunch of my
No, it's good.
Yeah, but I think it was useful in ways for people to get that context.
and having the references makes a big difference, so people can actually see. Makes a big difference when you have that visual.
Yeah, you can put and pick whichever spot you want, and somebody's going to come and change name tags.
And I grabbed the French version. Oh. Is this learning stuff? No, that's
No, this is just here for everybody.
First. We don't have.
can't see that. I was just gonna go across the table, right? I mean.
So I mean, generally. It's up to you. I mean, if you want, you can still be with us too. Okay. And I was just gonna. My time is about. Yeah, do you want to sit? We can speak. That's why I like the. I was told you were coming. Oh, no. This is your deal. That's your deal. I'll do my because what you guys are like, this whole yes. What? It makes me sad. And then I can is that before or it's not what you said. The thing is, yeah, okay. A lot of people maybe I could just take care of your children. I think this I'll take the check. I'll take the check. Exactly. So, we'll just make sure that everything comes together. That's okay. Sounds good. I'll see if I can get a bio. I might just say it's no introduction. But yeah, sounds good. We even have a. Okay, we have. My stuff is on with my stuff. Okay, all right. And then what I'll do is I'll just let people go. Okay, great. Yeah, because my instinct was to put you on the last panel where people wrap up in the day.
Yeah.
but if you're gonna be gone.
Yeah, I'll be gone, yes.
It's really good though that people here sort of,
Yes.
what the challenges are.
Yes.
But also like with the good planning.
Yeah, for sure, yes.
Just
Oh,
I
wow.
know that's not something that just started right yesterday.
Yeah. I guess you got a few minutes?
Not many.
Not many. I'll just grab water then. I'm gonna grab some water.
Yes, I was gonna take on it.
Okay. So is it the nation? Or is there a little bit mentioned the nation of?
It's
Okay.
and then there's a bunch of different
My boss, Alex Peters from the Kanjikum First Nation,
Okay.
said we should get you to settle this with Steve Harper once and for all, arm wrestle.
Oh, I better work out. Start running.
Rodeo bull rider.
Yeah.
Right over.
Yeah.
Alaska to Navajo.
Not like the Mohawks, we don't get along with anybody, so we're all clustered, huddled together. We got a sense for why nobody likes us.
Yes. He's sitting beside you. They made some switch over here, so they had me speak after you guys, but they thought because I'm leaving this afternoon, like after lunch, I have to go back to BC. So
what time were you on?
I'm just on. I'm not too sure. I just
So everybody knows that.
here. I'm just gonna be here with you, right? So I'm not too sure.
But anyway, yeah.
I think so. Yeah. Yeah. And William David was supposed to be here with you, but he switched this to he's gonna moderate.
What is this?
So I guess he's changing a little bit of stuff, you know. Yeah.
Stated objectives is to enhance environmental
So
protection.
he's gonna moderate. Yeah.
Oh, somebody's pointing at me.
Yeah.
Oh. Do you want me to hang on to this? Or?
Oh.
Just figure any thought in your mind.
What
Plenty of thoughts I have.
I guess I wouldn't be able to.
Okay, I'll probably do that at the end, and you may have to flag me, like throw something at me to remind me. Because of my disability, right? Okay.
Oh, yeah. And you've been driving?
Yeah.
Wow.
Next week. This week, next week, and the following week,
Yeah. And it's pretty crazy sometimes.
I'm actually speaking at the University of Guelph.
Oh.
Consultations and conversations.
Yeah. Yeah.
Sure. Wherever I can.
Yeah.
Just sitting there.
Yes. Yes.
There's a few chiefs in the audience here.
Oh, okay.
It's great. Chief that watch me.
Yes.
Correct me.
Yes.
Or treaty chiefs.
Yes.
Who's interested in hearing?
Oh, yeah.
That's good.
This summer? I'm sure we're going to go. We've got a lot of things happening this summer as well.
Okay. Well, hello. Okay, I'd like to get started with the second panel, if possible. I'd like to start off by acknowledging the traditional territory of the Algonquin Nation and thanking Claudette Commanda for welcoming us to her territory. The first panel was about the law. This panel is much more about how the law is implemented, or what are the challenges in implementing free, prior, informed consent. As several have already noted, it's not about necessarily blocking development. It's about assuring control over developments, any number of different kinds of developments. And there's any number of challenges and any number of successes that we've seen with the tremendous diversity of peoples across Canada. I'll give very, very brief introductions to the speakers. Some of them need no introduction. Full bios are available on the FPIC forum website. So if you want to read more about any of our speakers, I strongly encourage you to go to the website. I'd like to start with Anne-Marie Sam. Anne-Marie was raised in the Sioux Frog Clan and is now a member of the Beaver Clan from the Nakaslii First Nation in Fort St. James, located in north central British Columbia. Currently, Anne-Marie is an elected councillor for the community of Nakaslii, an advisor with the Aboriginal Leadership Initiative, a board member with Mining Watch Canada, a member of the First Nations Women Advocating for Responsible Mining, and a Masters of Science candidate at the Norman B. Keevil Institute of Mining Engineering at the University of British Columbia. Sitting next to Anne is a man who needs no introduction, Chief Roger William, Gwiteen First Nation, lead plaintiff in the now famed Chilcotin Nation Supreme Court of Canada judgment. So not only is that a judgment where, as we've already heard, the Chilcotin secured Aboriginal title, the first Indigenous people to secure Indigenous title in Canada through a court, but are now actively working to implement that decision to articulate what control of their territory means for that nation. Sitting next to Chief William is Chief Dean Sayers from Batchewana First Nation. Chief Sayers has been Chief of Batchewana since 2005 and is now serving his sixth term. Chief Sayers and Batchewana First Nations led the charge in demanding Indigenous people's fair share of resource revenues. Resource developers are eager to work with Batchewana First Nation on a wide variety of resource extraction initiatives, from permitting to data collection to renewable energy projects. Just speaking from my own experience with Chief Sayers, he has, in my mind, one of the clearest articulations of self-determination and relationship between Indigenous peoples in the law in Canada. Next to Chief Sayers is Andrew Chapesky. Andrew has probably forgotten more about forest and forest development with First Nations than I am ever going to know. He's the senior advisor to the Whitefeather Forest Initiative of Pikangikum First Nation. He has 30 years of executive advisory and legal counsel experience related to Indigenous peoples, natural resources management, customary law, and stewardship. And finally, we have, Finally, we have John Cutfeet. John works for the Wildlands League as its Aboriginal Watershed Program Coordinator. His focus is to be a resource for communities in Ontario's far north on watershed protection and on resource proposals that may impact those watersheds. John is currently collaborating with communities and tribal councils of 4 major rivers in the far north of Ontario: Albany, Winnisk, Attawapiskat, and Severn, including the tributaries of Fawn and Pipestone. So with that, I would like to welcome my panel to commence speaking. We will try to be as quick as possible to encourage dialogue, but I believe all of them have quite a bit to say. So lunch may be delayed. I'm just going to warn us now.
And it's not our fault. I thank you for that introduction and for the welcome to the territory this morning by Claudette. I wanted to start, could we put it to view? Slideshow. Can you just click on it? Oh, right there. Oh, it's view. Right?
Yeah.
Okay. Sorry, now I'm wasting my time figuring out technology. So, my name is Anne-Marie Sam. I'm from the Dakel people. We are known as the people who travel by water. We're in north central British Columbia. Just to give you a sense, most people know where Vancouver is. That's where I live right now. But to get to my community is a 12-hour drive north. And driving 12 hours north of British Columbia, it only brings you to the halfway point of British Columbia. So we're about central. Our neighbors to the north of us say they're central of British Columbia. There's actually a stone there that says this is the geographical center of BC. So that's about where I am from. This picture that just has come up was one of the first pictures shot of the area that I grew up, known as Chestnut Blow or Mount Milligan. This is where the picture showing now is where I'm from. It's the Nakal Ko. It's the Stewart River. And in the background, Nakal, the mountain, the mountain that this is what we look at every day, and where I live. I just wanted to share some of the pictures to be running in the background, so it gives you a sense of where I'm from and where I'm speaking from. We have a long history connected to the water, and a lot of pictures will show that. And the story I wanted to share with you today is, and I loved last night, the director of the thank you for that, Wabano Center. I loved the title, that it was a new beginning. I also like the story of how she said, our stories make us who we are. Without them, we would vanish. And that has always been my thinking, is that we may feel that we are not being listened to. We may feel that development is happening all around us, but we know our histories and we know our stories. And my story, what I'm going to share with you today, was about impacts from a proposed mine that was being proposed in our territory. And this story is probably similar to a lot of First Nations faced with development coming into the area, that the company will come in saying, this is what we're doing, this is our plan, and the government will allow it to go ahead for the benefit of the economics and the jobs and all the stuff that come with development. And I really wanted to stress from the last panel how they had said the importance of the First Nations perspective, and to look at the perspective of the communities and that impact to the communities. And we live off the land. When we went to the hearings about the mine development, we were told, leave it to the experts. They know how to plan this. They know what they're doing. Can't you just go to the grocery store and get the food that you need? And constantly this trying to minimize our importance, and we are the experts and they need to hear us. And so we stopped the company and said, no, there's a new way of doing business, and it's our way. No longer are you going to bring in your consultants and tell us you're going to collect our data and then use that in the government process. We are going to collect that data, and we will provide you what is needed. That was, I think, a shock to that company that came to our area, because they had already spent tons of money hiring big-time consultants to collect our data. And then now they were saying, but now we have to pay you to bring in other people. And we felt we had the capacity to collect this data. We know our stories, and who better to share these stories than our people. And so this document, we called at the time, and I know some lawyers don't like the title, but was Aboriginal Interest and Use Study. And this focused on different criteria. So we looked at the development from an environmental impact, what it would have on our people, social, cultural impact, the legal impact to our rights and how we're not going to be able to continue our Aboriginal rights in the area. Economic impact, what does it mean when we get cut off from our territory that we've relied on for generations? And we had to go through collecting that data from our perspective of how would, if this mine is approved, how would we be impacted as a people? And it was at the beginning of the process. I think a lot of my elders and community members thought I was crazy because you can't stand up against government. Government's going to do what they want to do. Industry's going to do what they want to do. And I really just felt that, especially because of our history in the area and in the late 1800s when there was a gold rush happening in our area, my great-grandfather and my grandfather were able to keep people out of the area because of our laws, because of our way of you only go in areas that you're welcome to. They were able to protect, and the stories and what have been passed down to us is that they said it was more important for his children and grandchildren to be connected to the land than it was for all the money that could come out of the gold that was in the area. They knew there was gold in the area, but he wanted to keep that connection, and I'm always grateful that they did were able to prevent people from coming into this area. And so on this picture, I think it's going to stop here. This picture that's up is at the time my 4-year-old daughter. I always say she's eaten very traditional foods, Tostitos. She was tired after beaver hunting in the creek that's just behind her. She wanted to take a break. And this was in the fall of 2010. Her first time we brought her out to this area to go beaver hunting. And we knew the area behind had a proposed mine on it. There in 2009, there was approval for a mine to be developed in this area. We just couldn't imagine what that meant for us. And here I was with my uncle, and we were teaching her about what to look for when you go beaver hunting and how to prepare. And I think I just pressed the next one. And 6 months later, this is what's left of that same area. And the picture is a little blurry because we're not allowed to take pictures on the mine site. But for me, I really wanted to, there's no other way to, how do you explain the impact than to show what you had and what is left. And just another bad photo, but. And this picture also, I just wanted to quickly mention, this is the area again, just the aerial view flying over. So this was taken in about 2006. And this was what it looked like as of 2013, September. And I'm going to go to the next one because I don't want to look at that picture. So that's what we are dealing with, and that's why, like, when I listen to speakers talk about free, prior, and informed consent, why it's so important for communities to be involved on the ground level. We were accused of trying to delay the mine because all we wanted was money. But our elders and our community members really were focused on the environmental impacts that this mine was going to have on us. Are we still going to be able to hunt? This is a caribou area. When we looked at that, we were already impacted by a dam that was, and caribou weren't coming into our area because of a dam development downstream from us. But what they did was one day fly over, we don't see any caribou. Therefore, we don't have to do a caribou management plan. And so for us, it was our future generations, my children, my grandchildren, being able to live off the land like we did. And and to continue that connection to the land. And we just were, I felt shut out from every avenue that was available to us. We went to the courts, but unfortunately, and we're trying to build on this, really, I don't want to focus on this, but build our relations. Well, I should say it this way. What we did really well, I think, was figure out the environmental assessment process, figure out the Canadian environmental assessment process, meet with the company, and meet with the company, and again meet with the company and government. And a few times we met with our neighbors, our neighbor and First Nation. And that was, if anything I learned out of this process, was our what we had to, our tough lesson of what we had to learn, is that we should have been sitting in a room together and saying, what are our priorities and what are our fears and how can we work together? Because in the end, that's how the project got the go ahead. We were concerned about it. We didn't give consent. Our neighbors gave consent. And so when you look up the Mount Milligan project, it does have Aboriginal support. And you know, our no hard feelings to our neighbor and community. I'm from there. I'm connected to my great-grandfather married into the community. We're directly related. And the result of the Eastern Nation and the Western Nation, so Nakazli and Sekini coming together, is my family. We're part Sekini, we're part Dakelh Carrier, and we lived on the Nation River. And that's something that I think only we could figure out, that all the, you know, free, prior, and informed consent and all the government consultation process, they couldn't figure that out for us. And this is our lesson that we have to live with. And now we have a mine in our backyard that the other focus for us was not only the environmental impacts, but the social and health impacts. A lot of companies and governments focus on the jobs that development brings. And we weren't so concerned about nailing down contracts and getting money out of this. We were concerned about all the research showing that Aboriginal women were impacted by development in their areas. We were starting to see, check in on time, 2 minutes. We were starting to see the direct impacts of more drug dealers in our area. This is supposed to be a drug and alcohol-free project, but for some reason the drug dealers were able to move in. We were seeing more domestic violence, increase in charges related to alcohol and fights at the bar, and prostitution of both young women and young men in our areas. And when we brought that to the government to say, look, we need you to get a plan together with us, because we don't want our community to be impacted by this development. They said, prove it to us that you are being impacted. The industry, the company official said, we're not accountable for what our employees do off-site. We don't have to, you know, we don't know what they do on Friday night in town, so we can't tell them what they can and cannot do. And that's where we as a community also just stepped up and said, well, we need to do something. And we started looking for a researcher. We found somebody that had just completed her PhD out of UBC Mine and Engineer program. And we brought her into our community, and it wasn't just Nakasley as the First Nation community, it was our neighboring First Nation up the lake that were left out of the assessment process, and it was the municipality of Fort St. James, so the mayor and council of the local non-native community realizing that they had issues on their table and they had to start doing something and planning. And we came together and we've collected data over the construction phase, which started in about 2010 to 2013 when the operation started. And that data is available on the First Nations Women Advocating Responsible Mining website. So it really outlines the impacts that happened to us. And that's, I think for us, I guess I'll just end on this, is that for our community, we are the ones that know our territory. We are the ones that know what is needed. And if the BC government is willing just to ignore international law, and the Canadian government is saying it's aspiring to try to get to FPIC. As Indigenous community, as an Aboriginal community, as a Dakelh community, we have to stand up and uphold that law to ensure that our people are not impacted and are not left on the side when development is happening in our area. So I'll end it there, and thank you for listening.
That's Tselkotin River song. Tselkotin means river people. And river people, the river is very important to us. I'd like to take this time to thank the Algonquin for being on their territory. Chanasya. Says Nagodin E. Guzun Jitam Nanjan. Chiharadil Guk and Zin Hult Ejit Nunduha Gotat is Sajit Nuhidan I could inguya in Negotat as. So our declaration of August 23, 1989 of Hanikut in short says that nothing in our caretaker area inside the Tselkotin is going to happen without us. And this today is we're talking about consent. Last night I talked about the history. The history. I always think about this word, Aschaidam. And this word to Tzilchotin, Aschaidam, is very important to us. Aschaidam was an individual Tzilchotin person at 1862, prior to smallpox. An individual who had jurisdiction, language, culture, laws, respect and honor. When this person took you in their home, it was like your home. And since, let's think of the Tzilchotin War of 1864, and then later in 1800s, where reservations, reserves, residential school, this Aschaidam has been impacted. There's been a lot of impacts. Although some of our Tzilchotin people, they're still very strong in their language, their culture, out on the land. A lot of our Tzilchotin people are also have degrees in education. And we need to get caught up. Our goal is to get caught up. In terms of Aboriginal rights and title to our people is very clear. On our land, on our resources, who we are, there's no question. Throughout the whole Tzilchotin territory. But it's the government, the provinces, the federal government, the territories that are confused. They're the ones that, in trying to define and limit what that means. And in the different court cases that happened throughout all these years, finding loopholes. And these loopholes, we always say in the Tzilchotin, we never concerned about what the government's doing. We're concerned about us. We're concerned about me. Because Aschaidam is being impacted. Title is with me. Title is with my community. Title with my nation. That is first and foremost important, because if we can't do that, if we can't say that, this is where the government has control. I grew up, I never knew English. I learned English in the residential school. My mom was in residential school, but my grandparents weren't. So in a sense, for me, I feel very fortunate who I am. And as I went to school and learned English, I got more confused. You learn about, in the schools, nothing about where you come from. All these legends and stories, these creations, the history of our people, not being taught in the schools. I always think about a lot of my friends, non-First Nations. When I was in school, they were all talking about where did they come from. I believe I was only one of few First Nations in that class. You know, they come from their background, Europe, Germany, Britain, all these different places. And they got to me, and I was confused. You know, I spoke Chilcotin. I went to residential school, and I was learning the system, and I was confused. And my buddy, my non-native friend, was like poking me. You're First Nation. You're first people from this country. Now that's, I can imagine what our people are going through. And our people, in terms of that mass confusion that the government, you go right from the smallpox to the contact to the laws, pre-title decision. I remember growing up, and any non-First Nations that came in, some of our people thought that was authority. And that's where we're coming from. In the Tselchotin War, that story is passed down for generations. We all know what happened there. We know the treason, we know that we don't trust government, we don't trust companies. So that's, in terms of who we are and how we're going to move forward. As I was going through high school and then eventually running for leadership, I was also into a lot of sports. Hockey, rodeo, horses. I was born on a horse. And that's where my pride was. And my language was strong because sports and the things I did and the language, I was fortunate enough to get elected in. And the experiences coming from my elders, our elders talked about, if you prepare yourself every day in your life in the most honest, most respectful, and this red road to get to a place, and that place either doesn't exist or is not working, our elders always told us it's not meant to be. This teachings that were brought down as I learned is that they were teaching us we don't want to dwell on things because things happen for a reason. But I was also told that if you were not prepared, you're trying to take shortcuts, you had intent, bad intent, and then you fail. That's harder on you, on your future, on your family. So those are some of the teachings that has been brought down to us as First Nations, as Tselchotin. In terms of Aboriginal rights and title, all these court cases, I want to also say and thank each and every one of you. Court cases, we have people, First Nations, non-First Nations, since way back, through meetings, through lobbying, direct actions, treaties. That's why we're here. We've been pushing the government and the companies that we have Aboriginal rights and title. You talk about the 73 Calder case, the 1980 Constitutional Drive, 87 Delgamuk, 94 Haida, many court cases like that to get us here. And when I got involved in politics in my community, our elders always told me about Aboriginal rights and title, the Tselchotin War, place names where we lived, our roots, Tselchotin names all over in our area. And there's history behind those names. So that's when we're dealing with companies, we were seeing Honeygut Inn is one of Tselchotin, 6 Tselchotin communities. We're the most west in the mountains, the Cascade Mountains. We're the most remote. We have no hydro, no BC Hydro. There's several times that BC Hydro tried to come in, but our people fought it and turned it down. There's the hydro dam that was planned in terms of what and how they're going to create energy. So these are some of the things that our people had to deal with. Referrals. Before referrals, companies, governments make decisions on our land, and then referrals come. There's no resources to deal with these referrals. What's your Aboriginal interest? How does this impact you? And then we start going to court. Between the court cases, the 5-year trial, we tried to negotiate with BC and Canada. That didn't go anywhere, but one of the portions from that was called the Strategic Engagement Agreement, which we've negotiated, and that's a consultation agreement where our Tsilhqot'in national government, our computer, our portal mapping, so all the communications go through there. This is where every referral would go through the nation and would have enough funds to be able to, at the nation level, help the communities respond. And since then, that win last year, that was huge. We've been talking about this day over 25 years. We've been doing ecosystem-based planning since the court case started. We've been dealing with companies, mining companies in our area. We've been involved in non-First Nations, local operators in our area, doing different plans. And that decision was huge. So from there, what's next? What is our next step? We've been, since that decision, going around to doing presentation, exchanging notes, thanking everyone, and trying to, because in terms of negotiations, this could be a template from this tidal win. We're looking at the tidal land, to give you an idea, about 10% of the Tsilhqot'in territory. And outside the tidal land, there's a declaration of rights to hunt, to trap, to trade, to catch and use wild horses. That area is also off limits to Ministry of Forest. And if Ministry of Mines wants to come in, there's a referral to be had. They need to show us, to prove to us, and how are they going to mitigate the impacts of those rights, the declaration of rights. What species do we hunt and trap? What about the habitats of those species? What are the numbers? Is it sustainable? So it turns that around. Tidal land, we have, I call islands, private properties, local operators that have history with our people. Some of these operators are 3-4 generations. My uncles, my aunts, grandparents, my parents have history with them. And we want to, at the end of the day, because in history, they had to pay Crown government for permits and license, and now they need to get approval of the nation because it's tidal land. From those meetings and relationship, we know some of the issues, and we want to improve their situations on tidal land. There needs to be a transition process. We need to also look at the big picture. Tsilhqot'in territory, the other 5 communities. Without the nation, this title wouldn't be possible. Without honey, this title wouldn't be possible. And when we negotiate the whole Tsilhqot'in territory, we're looking at being able to be involved in all decisions in the Tsilhqot'in territory, all revenues. We understand that some it will be quick agreements, some will be more complicated, and some agreements wouldn't be there. But we do have a club, and there's a title, Aboriginal title. And there was strategy, we discussed that we almost went right back into court for damages. But in the end, we agreed to try and sit down with the province and the federal government to negotiate an agreement on the big picture. This is an opportunity for us, an opportunity for the provinces and this country in recognizing First People of this country that you need our consent. There's a fear-mongering out there that title land is off limits. There's no economics. But we all know in this country we need to look at economics sustainably in a way that we're not stealing from our future generations, in a way that we all are benefiting from it. So with that, I'm going to leave it at that. I'm sure there's going to be a lot of questions. Thank you.
Bonjour. Ogema Nimanagojing Goyakazid Ishnakaz Bajunang Donji Gajak Dodem Nishnaben and Andal. Good morning, everybody. I'm Ogema, our Chief Sayers. I'm from Batchewana First Nation. About 500 miles west of here on the shores of Lake Superior. A couple of weeks ago, I had the opportunity to go to London, England to have a soft screening, a screening of a documentary that was made about Batchewana, that was made by a very nice lady from Ireland that is a proponent, a developer. And it was great to be able to tell our story in that documentary. And it's going to be screened here. The premiere is probably going to be here in Canada somewhere at some point this summer. She really understood or tried to understand the plight that we're in as Aboriginal people here and the challenge we were facing with the colonizing governments. And so it's an incredibly world-class documentary that was made. But while I was there, I was thinking, me and one of our counselors, Chief Bell, we went, and I was thinking maybe I'll rent a car just to be able to get around a little bit. And then when I got there and we were leaving the airport, and it's a lot different. The highways are a little narrower and everybody's driving on the wrong side of the road, and and everybody thinks that way. Everybody thinks the left-hand side. And it's hard to get used to it. Even the drivers are sitting on the right-hand side. It's really a different world, a different perspective. And the other thing that I noticed was that when we would walk on the streets, you know, in Canada, people normally move to the right-hand side. When you meet somebody over there, they move to the left, and I keep bumping into people because they were always trying to move to the, even they were conditioned to think from the left, you know, think that way, and even how they walked, even how they moved. And I was thinking, gee, that's really quite a, I guess, a a good comparative for us and how we're conditioned from a colonizing perspective. And a lot of the things that we do, even us as Nishnabek, or Ongwehoe or Nishnabek, like the original people here, we've been conditioned, we've been colonized in so many ways. And there's so much work for us to be able to do in order to have our own people understand who we are. And it really, like, even in our ceremonies, we don't stand up to honor people. Instead of, the best way we can honor somebody is to get as close to our Mother the Earth as possible. And we get down on the earth and we sit on the earth. And the only one that stands is the speaker. And we channel our prayers and our thoughts through that speaker, through that song, to the Creator. And it's a very spiritual time when we honor somebody, when they're doing that work for us. But colonization, the churches have taught us to stand up, sit down, kneel down, stand up. And when you honor somebody, you stand up. And that's contradicting to us in how we originally envisioned our way of honoring the earth and all of creation. Again, another example of the incredible amount of work that we have to do. I want to say miigwech to the Algonquins for hosting this, and I want to acknowledge as well all the chiefs that are in the room. I noticed there's a few chiefs here, and principal people, and elders, and all those people that are wherever, back home. I want to express to you guys back home, elders and whoever might be watching, that I'm going to try to do my best to try and relay what you've taught me. And if I'm off the mark a little, you can talk to me when I get back home. But I'll do my best. And I'm glad Chief Pictou spoke a few minutes ago, because I wonder about the follow-up to the repatriation process that happened in the early 1980s, and because the intentions were there, and I don't really see the evidence today of the improvements that were supposedly inevitable. I do want to talk about free, prior, informed consent, but I want to provide a little bit of a segue for you around the people that I'm a part of, that nation, the Ojibwe Nation. My name is Nimnagojing Gweakasid, and I'm a hereditary chief as well. And my name is, he stands and walks tall. And I'm part of the Crane clan. And I periodically, on behalf of the chiefs, and there's a couple of them here that are the people that I work with and work for, because I do represent the chiefs. I speak on specific issues with specific messages that I need to relay to the settlers, whether it be Canadian or Ontario governments, or even with the Queen. I actually took a letter with me a couple of weeks ago to London. I wore my hat and I walked right to Buckingham Palace and kind of knocked on the door there. But it was her birthday that day, and she wasn't available. But I said, I want you to tell her to get a hold of me. And they said, we can't even take your letter, but you can go blah, blah, whatever. I said, okay. Prince Charles told me the same thing a couple of years ago. He said, I want your mom to call me, Chuck. You need to tell her. He said, okay, we'll tell her. We'll tell her. Like we met with her down in Toronto there at the Royal York. I spoke on behalf of our 21 chiefs that are part of our alliance. And I told her the condition. I told him, Prince Charles at the time, the condition of our relationship was dire straits, basically. We need to meet. There's just a lot of dishonoring of your family and of the crown and of our relationship, and we need to resolve this. It's inappropriate, it's illegal, it's unethical what's happening today in 2014. Anyway, as the Nishnabek, as the Ojibwe Nation, we have our own land, our own law, our own spirituality, and our own language. Those are those things that define a nation. From that nationhood criteria being met as a people, we as nations are able to enter into legally binding contracts, otherwise known as treaties, with other nations. We expressed that, we asserted that, we existed from that premise from time immemorial. We've always been here, and we've always acted as nations. Britain came along, and they as well, they have similar. They have land, language, law, spirituality. They meet the criteria to be able to act like a nation. They came here, and they wanted some action. Not only them, but a lot of people from around the world came here. And since they came here, we knew of the coming. We have lots of prophecies. We knew what challenges we'd be facing. But we knew that we'd have to enter into some kind of a relationship. And it was from that relationship that we created treaties. And in our instance, what our elders tell me, and that's where I derive a lot of the understandings that I know. They come from the elders and the traditional knowledge keepers, and very little from like institutions like this, because this is not our story. The story that's being told on the most part in these types of institutions are not our stories. But so the elders tell me that when we contemplated treaty, we left our villages, and what was the custom every year to head to Baoting or to Sault Ste. Marie. At a certain time of the year, there was a huge gathering place there, and that's where the treaty was going to be contemplated. But when we went to the treaty meetings, we went there, the elder said, and our boats were full. Our boats were overloaded with everything. They were overloaded with pelts, with deer, with moose, with fish, with our language, with our ceremonies, our culture, our trees, all of our relatives, all of creation. We went to treaty. And the visitors, the settlers, came here, and they went to that treaty ceremony with nothing in their boat. They came here with nothing. And then an elder told me, he said, you know what? Guess what we left the treaty ceremonies with? I said, I don't know. So we left there, our boats were still full. We had our language, our law, our spirituality, our land, we had the animals, we had our everything about a nation, and we never gave up anything. If anybody gained anything, it was the settlers. So he said, one of the things I want you to always remember as the chief, as a representative, is that we gained nothing through the treaties. It was the people that came here that gained from the treaties. Our people have no treaty rights. It's the visitors that have the treaty rights. We have always had it, and we always will have inherent obligations, inherent rights that we have to look after as a people that came from the Creator. Nothing that we have today came from Canada. Nothing that we have today came from Ontario, and they can't give us anything because we already have it all. And we never gave everything away at treaty. We said we would share. And that's what they tell me when I go out here. And they said, remember, as a nation, that we have the obligation and the legacy to protect that we are a nation, and that we have that nationhood relationship with Great Britain, and that Canada is not a treaty partner. Canada is the administrator. They inherited the relationship. They are only the administrator. Canada will never and can never be able to negotiate a treaty with us because they are not truly the nation, they are a state. So our elders tell us that as nations, we are not willing to reopen the treaties. We negotiated the treaties at the time of the signing of the treaties. We negotiated our expectations at that time. The only role that Canada and Ontario have today are the development of an implementation plan based on the spirit and in the intent of our treaty relationship. So that's where I was yesterday. I was actually meeting with Ontario to try and create a new political protocol on how we're going to resolve outstanding nation to nation. We were intentional though. We didn't refer to our relationship as nation to nation. We referred to it as an Indigenous First Nation government relationship to the Ontario government to government, because it's not a nation to nation. It's us trying to encourage that level of government to create the proper implementation plan, which we're concerned about to some degree, because Ontario is a tertiary level, a third level of government. Us being the first level of government, Canada being the second level of government, and then the provinces being the third level, because it gets watered down, the true spirit and intent of the original relationship. So we really are intentional in our vocabulary. We're trying to really create the proper foundation. So it was nice to hear, from what I perceived this morning, one legal perspective, a Canadian legal perspective, a Canadian legal framework perspective, but there's also the Anishinaabe legal framework, our legal framework perspective that is just as powerful, if not trumps, the visitor's legal. And that's what we say back home, is that we have a real difficulty in recognizing Canada's Supreme Court, because it's really an illegal court. There was no acceptance on our part. We never consented to that court system being imposed on us. We have our own legal courts. We have our own systems. We have our own Supreme Court. We have our own people's law. We have our own natural law. And that was never extinguished in any treaty. Our canoe was full. There was an illegal assertion. And so historically, all the way through, and in 1867, when Sir John A. Macdonald, through the British North American Act, he said, from here forward, I'm going to look after Indians and lands reserved for Indians under Section 9124. And we said, that's BS. You cannot unilaterally extinguish, from your perspective, our pre-existing nationhood rights. That's illegal. And you cannot, and we will not accept that. So we are not aligned with, and we will never accept 9124. For us, it was probably the worst day in our history, was 9124, when they said they would be our fiduciary and look after us. It has destroyed, on the most part. We've been able to be resilient, but that made a lot of work for us. So we have always, historically, asserted our rights around free, prior, informed consent. As a nation, we have inherent responsibilities to protect our relatives, the lands, all of the animals, the trees, the rocks, the forests. And we can't shrug that responsibility. And it was never a part of a negotiated treaty. We have always made sure that the sharing relationship that we created was about that. Was never an extinguishment. Even in our treaties, there was no surrender. There was a conditional agreement, the treaty. So part of that conditional agreement was that they needed we were able to do what we're in the habit of doing, continue for perpetuity, and that they needed our permission for whatever they wanted to do, because we had our ultimate sustainability obligations that we had to fulfill. We actually had to take drastic steps to enforce that. And we were actually arrested in 1848. We borrowed a cannon in the Sioux, and we went up to an illegal mine that was operating on the shores of Lake Superior, a copper mine. And we fired one volley into the mine, and so they all come running out, and they gave up, and we put a padlock on the actual mine. And of course, they sent the army up there and arrested us, and took us off to York and to the Governor General. And the Governor General said, well, they're right. There's no treaty. You need a treaty. You need an agreement. You can't go up stealing up there. The First Nations, that's their lands, their resources. So that's when the treaty took place a couple of years after that in Baoting and Sault Ste. Marie. And so we've always expected free, prior, informed consent. Even before then, we even sent representatives in 1764 after the Royal Proclamation. Our chiefs went to Niagara, to the Treaty of Niagara. Similarly, same kind of expectations, no more stealing from us. Free, prior, informed consent is not giving us anything. It's something, it's acknowledging and recognizing something that we already had. And we're careful with those assertions within the free prior informed consent, because there's still some caveats that are not really aligned with our nationhood expectations around our ability to either provide consent or not consent. And 2 years ago, I was at in the Yukon, and I was at the all the chiefs in Canada met out there, and Mr. Prentice came out there. I think you know him. He's in Alberta there. He was involved there, but he used to be the Minister of Indian Affairs. But he was out there a couple of years ago, and he was working for a private company. But he told us, all the chiefs that day, he said, consultation and accommodation is a yes process, so get used to it. Indians, if you do not align yourself with it, and you do not, like, I'm talking like not literally, but that's what he was saying, that we will do whatever we need to do anyway. So we don't need your consent. We're going to come in and do it anyway. And that really threw me back anyway, as far as the progress that we were hoping that we had made to that point. We, as a people, have every right legally to expect our voices to be respected. And if we want to provide consent, we can. If we don't, we won't. And all of those are aligned with our original expectations and our original obligations. Free prior informed consent is something that we appreciate that's happening more globally, and it does support the work that we're doing. And actually, if a developer comes to Canada and they want to know if First Nation has any interest in a certain area, if they want to do some mining there, this is the way it was about 10 years ago anyway, that developer would phone Indian Affairs, the Indian agent, and the Indian agent, he'd ask them, so is there any First Nations that have an interest in that area? And if First Nation hadn't registered any specific claims process, a lot of times the minister would say, no, there is no interest in that area. So our people were saying, what's going on? There's all these mining companies out here, they're all staking claims, they're drilling holes, they're stealing. How come we're allowing that? We said, we don't even know about it, because we don't support the specific claims process. It's the thief that stole the land, and then they're creating the system of specific claims. And if you measure all this criteria, you can you don't get your money, you don't get your land, but you get money. And we don't want the money. So we want the land back. It was stolen. So we said we're not going in that specific claims process. We will just take our land back, 150 miles long, 30 miles inland. And because of the failure to pay the rent based on the treaty, and we'll reclaim it. We'll just take it. And if Canada, if you believe you have an interest there, you'll make a specific claim to us, and you will justify. And that's what we've done. So in order to get around is there anybody got any interest at Indian Affairs, we took out full page ads in the Toronto Star, the Ottawa Citizen, the Sioux Star, the Sudbury Star, the Thunder Bay Chronicle, basically saying, full page ad, no more stealing from us. Canada's failed in the protection of their fiduciary obligations to us. It's we have unresolved issues. We're going to work on those, but in the meantime, if you don't have our consent, we'll shut you down. And the developers have lined up now. And one of them refused Hudson River Minerals a few years ago. And you can probably Google that about Batchewana. And Ontario said publicly, because they went public, the developer, they said, we're not going to meet Batchewana's requirements. And Ontario said, well, you don't have to, but we advise you to. It's a good business decision, but legally there is no foundation for that. But that's their legal system. And our legal system, there is foundation for that. So we encouraged, and they said no. So there was nobody on the land. They never went to the land. And then eventually they pulled their development. They didn't want it. And because of what we were doing, we were forcing them to meet our permitting requirements. And as soon as their shareholders caught wind of that, their stocks plummeted, and the president had to come and apologize to us. He was forced by his directors to come and apologize and meet our requirements. So there's value. Even though Canada's law doesn't go as far as we want it to go with recognizing our inherent rights, there has been some movements. But anyway, I wanted to let you know a little bit about what's going on up there, and I got my 2-minute notice here too a few minutes ago, so I wish I would have been able to talk a little longer, but I put a lot of notes here that I wanted to share with you guys, but I hope that really helps you create a little bit of an awareness of something else that's going on the lands, and if you can do anything, you can ask a lot of First Nations what their expectations are around permitting, what their expectations are around coming onto the lands. Like for us, we have our own environmental assessment process that surpasses Canada and Ontario's environmental assessment processes, including flora, fauna assessments, bird migratory assessments, herding assessments, like trail assessments, sacred site assessments, burial site assessments. We do every type of environmental assessment. We have elders, we have ceremonies on the lands that are part of that process. And then at some point, we'll contemplate whether or not that project will move forward based on its ability to really be a minor impact on the lands. So that's what we're doing in our area, and we have every legal foundation to do what we're doing, because as soon as Canada gets us in their courtroom, the cloak of immunity is then lifted on them. They have to prove everything that they assert. So we say, bring it on, Canada. We'll go to your courtroom. But last time I was served a summons to go to their court, because it's illegal for Ontario to come into our lands, like to the natural resources. We banned them. But they asked for permission to come and serve me because we reopened a village. They illegally imposed a provincial park on us. And we won that in court a few weeks ago, the Gargantua decision. But when they came to serve me, we said, yeah, you can come on this date at this time. We had national media there. And so the enforcement supervisor from Ontario came with his hat and his fancy uniform. And he looking at the camera, and he gave me my summons documentation. And so I was fine with that. Pictures. And then I said, just a minute now. I have been instructed to tell you, Minister, and, well, representative of the Minister, the enforcement supervisor, at the time it was Minister Cansfield. And he said, you hereby put on notice that there is an investigation being conducted into your failure to fulfill your fiduciary obligations to us. Part of that investigation includes theft of our resources and failure to protect the Indigenous peoples, and that you may be brought in front of our court at some point, and you may be sentenced under our law and be put into one of our jails, which we won't tell you where it'll be, but that is part of our ability as a people, because who said your legal laws are the laws of these lands? That's an illegal assertion of jurisdiction. And so we don't put all of our eggs in one basket. We don't recognize their law, but we said we hope to get a fair share of justice from their system. But if we don't, we'll have our own system, and then we'll take it from there. But that's free, prior, informed consent from our perspective in our neck of the woods, anyway. Okay, Miigwech.
Presentation here. It's just a couple maps. Just from the beginning, but not something that's flipping through. Good morning, everyone. Is this on? Just going to speak to you a few minutes because we are pressed for time. Some of you may have heard of Pekanjicum First Nation. If you haven't, you could go to Wikipedia, and the community is said in Wikipedia to have the highest suicide rate in the world. It's known in the Department of Aboriginal Affairs and Northern Development as a troubled community. I'm going to speak a little bit different, about a little bit different reality of this community. And in the context of their White Feather Forest Initiative, how they developed planning, moved ahead in a way that embodies a practice of free, prior, and informed consent on a practical basis. This map is a map of intact forests. The red is the world's largest remaining intact forest. The White Feather Forest is in the southwest of that landscape. Pekanjikam elders have proposed to do Shnabe Mitkokewin. And I bring welcome from the Gitchinashnabek, the elders who are guiding the White Feather Forest Initiative. And they're working hard to get their message across as to what that means. This map is from the Academic American Encyclopedia. Languages, North America. In the green, you have areas where the majority of people speaking on the ground are speaking indigenous tongues. I like their map of the far north, uninhabited except for a few Inuit communities.
More power to them.
The hidden ground of meaning. Things aren't always as they seem. But this is a global singularity. This is the largest area on Earth where indigenous peoples are speaking their mother tongues. And to the south, Chief Sayers country, it's English and Algonquin. They call them the Algonquin family of languages. Grassy Narrows, English and Algonquin. It has very, very profound significance. And probably there are folks in government, in business, in NGOs who look at the North and see a vast wilderness, but then they come across this. So that's where the White Feather Forest is, Wapamiaguan Nopamakamic. And it is a place of working towards community economic renewal, but within a customary stewardship approach. It's called Chikanawendamang Kitakiminan. I put this picture up of the late Oliver Hill and his son because when he was alive, he used to fire this landscape, Ishnabiashkote, Aboriginal fire, indigenous fire, to make food for Bematswatch, living ones, all kinds of little ones, big ones, Wosak, Wabusak, Shishipak, strictly illegal in provincial law. Go to jail if they catch you. Elder Solomon Turtle, who you see in the top left, was hounded, Shishibans Sipi, by the ministry for practicing a landscape management technique, a stewardship technique, which simultaneously increased abundance and diversity. I'm going to pass around these two packages of monomen. It's called wild rice. If you look on the package, natural. Somebody mentioned Donna Cansfield. There she is. That man's beside her. You see the guy who was lighting the fire, driving the boat. That man beside her, his family planted Ogan CB with that monoman. And there are ways of caring for it, of stewarding it, and of hunting and harvesting the living ones that it supports, that monoman supports. But that monoman that I'm passing to you right there, that was planted by Gideon Peters more than 60 years ago, who is one of the current coordinators of the White Feather Forest Initiative Steering Group. It's owned, access to it now is owned by a non-native resort. And it's a sideline business for them. So how would you feel? You are working on the land. You are building on the gifts of the Creator. And all of a sudden, it's gone from you. How would you feel if forestry is coming into the southern part of your land, so their territories go into the south of that red area, just south of that red area, how would you feel if a forestry company was harvesting the trees that grew in amongst a landscape mosaic of a landscape of yards, corridors, and mosaics that are developed by your people? But more than that, they harvest trees and they replant in what are called plantations, where the elders see the trees as being enslaved. They're losing their freedom. They compare it to their makate wias niniwak kwewak, our black brothers and sisters, and how they were enslaved. But worse than that, when they replant, they have a regime where they're spacing trees far apart to increase growth, which then is used in an aspatial analysis tool called the Sustainable Forest Management Model. And that is used to increase the annual, because the plantations are growing quicker, they can increase the annual allowable harvest, so they're chasing more of the other trees that are gifted by the Creator to sustain the Anishinaabe. This is not what the late Whitehead Moose called the sharing relationship that was envisioned by what we call the treaty process. We are at an epochal moment in time. In South America, the yellows are the next largest intact areas, set of intact areas. The Brazilian government has just approved a genetically modified tree, Futura gene, eucalyptus, which will grow at more than 100 cubic meters per hectare per year, or 100 times faster than the wood grows in the white feather forest. How will the First Nations go forward on this? Here's what the elders challenged Ontario with. We don't want to talk about the treaty. We have a plan that we want to renew our First Nation. We see a new use, but we have our own way of living with those tkok, those trees, the forest, and our forest will look very different. Here's what we're proposing. We will create a plan for this area, And we will work out every issue on the basis of consensus, coming to one mind, mamuin and damuin. And Ontario accepted that, partly because there are new groups, organizations, the environmental community has an interest. The forestry companies are working with the environmental community through standardship processes. But what would an approach look like? What would a standard look like? The stewardship approach is grounded by I-thou relationships. These people are making a plan for a landscape where they live in relationship with Pematsuat, all living ones. Their obligation is to sustain those gifts as the Creator has given them so that they will continue to come back to them. The elders talk about they will come back to us. So that's the first key element, is that territoriality, authority, responsibility extends out to the I-thou relationship. The trees aren't abstracted as its. The landscape does not become an it looked at from space. Authority is exercised in relation to relationships with those living ones. So if I want to go to to an area, let's say Tom Quill's area, where he has stewardship responsibilities, I just don't go there. I have to go and talk to him. My brother and I would like to fish in your area. He would then set up, and if it's necessary, they can work with the other elders, and there would be a remuneration if that was deemed appropriate, a responsible, respectful relationship. Maintaining diversity and abundance is another key driver in this. So what Ontario did was they put in place what was called the Northern Boreal Initiative Policy. So they were looking for timber up north, and there had been an agreement with the environmental community, the forest industry community, and the government called the Ontario Forest Accord, that as a result of making dedicated protected areas in the south, the Ontario's Living Legacy, that they would seek to move forestry expeditiously. The Ontario Forest Accord. You can still Google it on the website. And that formed the basis of the elders' concern. They had already been looking, starting in 1996 after a suicide cluster, youth suicide cluster. They said, we need something. Our trapping has gone. So they went into this relationship. They led a land use planning process, and the governance of the activities on the ground is going to continue to be expressed within that customary stewardship approach. The role of the elders, the role of experts. Perhaps this offers something for the future. And I want to just refer to cultural landscapes, because I just read an article, in closing, I just read an article from the Vancouver Sun about fire and in BC and how to restore the landscapes. Instruction. It's by a fire ecologist, a wildlife ecologist, and another author, I can't remember. Instruction in the role of fire in BC's ecosystem should be a required part of any prescribed fire training curriculum, as should the cultural significance of fire use over the centuries by First Nations. It is ecologically and culturally inappropriate to ignore the significant role First Nations have played in creating a cultural landscape driven by fire. So we've got these wonderful knowledge legacies, many of which have been suppressed, some of which are being actually renewed by First Nation students going to archives and finding out what happened. We've got a way forward for this vast, beautiful northern landscape to work in respect to understand the needs of the First Nations, which can renew their economies and contribute to our economic well-being as well. Miigwech, thank you.
Wachimna gakna. Amunik sebahak. Mawaj numedan humayan. Ekwa dojo achim kuna wa tekstnemek speak. Snemek sebenenwa. I was not speaking Mandarin. I was speaking Anchininimonde. That's the language of my people, Kishnamek Sabanenwak. And I bring you greetings from Kishnamek Sabanenwak, which is about 600 kilometers northwest of Thunder Bay. And I'm glad to be here with you today. I thank Jamie for inviting me to be a part of this panel. Appreciate it, Jamie. Miigwech. Free, prior, informed consent. The closest thing in our language that we would understand free, prior, informed consent is nibagita shwajigat. Nibagita shwajigat. That means I give my consent. And a lot of times we do not have the opportunity to be able to provide our consent in the past. And also, when you think about it, I was thinking about that term, Nabagada. Where does that come from? It comes from the ability of you as a person who has authority, who has been given that authority to be able to express and to be able to provide consent to another person coming into your home. I give you consent to live with me. I give you consent to share with me. And those are the things that our people understood, was that we were to share with His Majesty and His subjects forever. But the way the text of that, I guess, of that process ended up was that we gave up everything to His Majesty and His subjects forever. We gave up our birthright to this great land. That is how that text is written. But that is not what our elders tell us. Our elders tell us that we agreed to share. So we can use and benefit from this great land, the resources of this great land. And so, who do we listen to? Who do we listen to? Do we listen to someone coming in with a document written in a foreign language that says we gave up our birthright to these great lands? Or do we listen to our elders who have corporate memory of our life, our culture, in an oral society, who tell us, no, that's not what we agreed to? As Shimek Sibaninwak, I have to follow the instructions of our people, our elders. It's difficult for me to be able to say, but this is what the treaty writes to my people. And so, based on that, we've been involved in, I guess, situations where we are expecting to benefit from our lands also, with the newcomers that come into our territory. We are a very generous people. We are a very kind people. but that should not be mistaken for weakness. We have our laws, and if most of you are familiar with our story, we've tried to use the established mechanisms of society, some of which was touched upon this morning, one of them being the comprehensive land claims process. We've also used the rulings from the Supreme Court of Canada on consultation and accommodation. And the result of that was that they have been ignored. They have not been honored, I guess, in the context of what they were to do. In the land claims process, we believed that we had an outstanding land entitlement that was owed to our people. And I remember doing a presentation in Toronto one time at the St. Andrew's Club, I think it was called, and I left after my presentation and I went back there. A government employee told me, you're going to have to wait for a long, long time to have your land claim settled. And I said, that's fine. I really do not care if it ever gets settled. And I'll tell you why. One of the things that we understand with the comprehensive land claims process is that there's a process of ratification that the community has to go through in order to be able to accept that land settlement that they're being offered, or that's being offered. And that ratification process is the process of consenting to take that land entitlement, and everything else is left to the Crown, which then at that point for us becomes Crown land. And until that happens for us, Aboriginal title remains with Kchinamexip. And so that's why I said, it doesn't matter, just leave it, just let it be. He looked like I slapped him in the face. I guess they never really thought about that we are a nation who are able to provide consent. And they thought that we did not have that ability to think for ourselves, that we do engage and we have been placed sovereign in the sovereign territory by a sovereign God to be able to interact with other parts of the human race. So that was part of our position. That was part of our challenge on the using the established mechanisms. The other part to that was the consultation and accommodation. When courts started talking about the need to consult and accommodate, one of the things we looked at was how did we want to be consulted? There is a duty to consult with our people, but how do we want to be consulted? So what we did was we set up what we call a consultation protocol. And it was very simple, straightforward. It had 6 steps. First of all, if a developer wanted to come into our territory, they would have to contact the chief and council in writing. And they would have to provide information onto what it is that they want to do. And the second step would be to hold a public presentation on their proposal, on their work program, And then the third step would be to talk specifically with the families that are within that territory that will be directly impacted. And then there'll be a meeting again with the community to clarify some of the issues and to talk further about how can we move this project along and what are some of the contentious issues that need to be worked out. Now, here's the important part of that, is the step 5 of that consultation protocol. In step 5, we have a referendum within the community to decide whether the project is acceptable or not, and that whether it should go ahead or not. And then step 6 is just communication of the approval and the necessary work to try and get a project in place. Now, one of the ways that it's designed, I have a minute left. Why it's designed that way is step 5 is to give choice to our people. And that's all we ever talk about is choice. Our people to be able to provide their consent, whether they want to or not. And so that is one of the other mechanisms that we used. It was recognized by the court that there was indeed a consultation protocol that the committee has put in place. This was at a lower court level. But at the same time, it recognized that there was an implicit, although it was not explicitly written, that there is a process of consent through the referendum process, because that's what a referendum in our mind does, that you have a choice of yes or no. So those are the things that we did. But at the end of the day, that was even rebuffed. So we tried 2 mechanisms of Canada and Ontario to live within the means of society. And what did we do? Well, because they were not being honored or respected, we invoked Ganoe Dandake. Ganoe Dandake, which means I'm looking after my land, I'm looking after my land. The mandate that I have from the Creator to be able to protect these resources and the territory for future generations. Ganoe Dandake. That is the law that ultimately governs Kchnameksupininwag, and that was what was invoked at that time. What were the consequences of a lot of our actions? Well, you probably heard that our leadership were incarcerated they were sentenced to 6 months. But we got them out after 68 days. And the court ruled at that time was that there was a duty to negotiate in good faith to reconcile Aboriginal interests with competing interests. That was what they had ruled. So what do we do then as Kchnameksupininwag? Well, we have a consultation protocol that has been enhanced. It's going under legal review right now to make it as bulletproof as possible. And we have a watershed declaration which the elders instructed that we put in place to protect the whole watershed. And so those 2 documents then are our interests that we expect to be reconciled with competing interests. We are not saying that we don't want anybody to come into the territory. We're just saying, come in, come work with us, be respectful. We'll sit down with you, we'll talk about these things and see if they're compatible with Kchnameksup idea of sustainability. And so we've done that, and one of the things in the enhanced consultation protocol is the fact that those lands and resources are now, based on the invocation of Ganoe Dandake, those lands and resources are now nationalized under Kchnameksupininwag. So anything that happens within our territory then has to go through this process where Kchnameksupininwag is the authority over anything that happens within the territory. So those are some of the things that we've done in terms of pushing forward the idea of choice and the idea of being able to consent to things that will impact our people. We are not difficult people. We're not radicals. We're people that belong to this great land, that were placed here by the Creator with a mandate to ensure that the territory, the lands, and the waters are protected, and to ensure continued generations of Shnimek. And we continue to do that, and we continue to welcome people into our territory. Our young people have programs. This will be the third year that they've invited Canadians to come in to live with us for weeks at a time to talk and learn about who we are. We've invited the Duchess of Wessex was there last year. The Premier was there. But we are a generous people, and we continue to be generous. But where the problem lies is, where is our fair share of the resources to which we agreed to? We did, like I said, we did not agree to a mass land surrender. We agreed to share. And so we continue to move forward that we do have a right to our fair share of the resources. And that's what we'll continue to stand upon. And I'm glad to be a part of such a group of distinguished speakers here. And thank you so much, everybody. And I guess I'll leave it at that. But as you know, we continue to move forward with our mandate, and we do have a mandate, and that is what guides our people as we move forward. That's all for now.
Okay, I'd like to thank our panel for their patience and their stamina with this incredibly informative, instructive panel, a very powerful panel. So I'd like to thank each and every one of them. I'd also like to thank the audience similarly for patience and for your stamina. I'm actually wondering whether we have time for questions. We don't. We've actually, as promised, had to delay lunch and rejig the agenda a little bit. So what we're suggesting is that we have brown bag lunches waiting upstairs. We suggest that everybody go upstairs and get a lunch and then bring it back down so that we can reconvene at 1:15 in this room. You can't eat in this room. So with that, I guess we can break now.
I'd like to encourage people to take their seats, wrap up their conversations, and we can get on to the afternoon program.
I think it's my sign. It's your sign.
Oh, you did talk to her a little bit.
In a sort of relation that she was thought of.
Right.
So which ones must be young?
Yeah.
Okay, so you're moderating, and what
Yeah.
order are we going in?
It will be Lena,
Okay.
Francois, and Ian.
Francois, your presentation is pretty much all set to go.
Okay.
And
And I just I go like this? No. Probably.
Yeah, I wish.
Yeah.
It's just I'm asking you when you're ready to go. It's blank right now, but when you're up, it's go ping.
Okay. All right.
You're there.
Great. And it's measured from, is this, that does the
Or the
clicking,
arrow,
or
just
or
the
the
arrows,
arrows?
Yeah,
Okay.
it's whatever you're most comfortable with. We have a remote around here too, so
Yeah.
really want to get fancy.
Hey, oh, wait. I think there's another one. It's not the right one.
Okay.
Yeah.
This is the newest one.
No,
you
no,
see.
this is the PDF.
Okay, PDF is right here. Actually, I brought that over as well.
Okay. Good. Good thing I checked. Okay, that's it. That's a good one. Okay. Thanks.
Okay, well, let's get going here. There will be a lot to cover in the afternoon, and hopefully we'll get a chance to engage some of the people both on the line and in the room around some of these issues. The later session in the afternoon will be a chance to pull together a bunch of the threads that have been put out on the table during the day today, and we'll have a chance to sort of sift through the meaning and implications of what's gone forward. My name's Alan Young. I've been working in and around issues related to mining and forestry and other things across Canada for the last about 20 years or so. And it's my honor to be here, and I'd like others to thank the Algonquin people for their generosity in hosting this forum on their grounds, and to Ottawa U for opening up this wonderful facility for us. So greatly appreciated. We're going to take a bit of a different angle on the subject now, and we're going to move from those who kind of make the law and those who shape the law, whether they're Aboriginal or Indigenous governments or national or international bodies, to those who are kind of left to figure out what the law means on the ground. In this case, we'll be focusing on the implications of free, prior, informed consent for companies and their investors. And it is the companies and the communities that are often left with the big challenge of interpretation and implementation, and that's no small thing. I think the good news is that in my work with everyone from banks to energy and forests and other companies, it's increasingly recognized as a fact on the ground. And people may not know what the heck that fact means, but whether it's the IFC telling you or the International Council on Mining and Metals or whatever, your investors, it's a fact that you're having to increasingly grapple with. Whether you're a company doing the business or a company financing the company doing the business on the ground, it's a fact that is firmly planted on the landscape now. It's basically a fundamental prerequisite for the much vaunted social license to operate, and it is being reflected in different forms of policies and guidelines going forward. Not a lot of unanimity or consensus on those yet, but that's where these things start. I think the data is also mounting on the implications of not getting your head around the idea of consent, consultation, and others. A recent piece that came out of the Harvard Kennedy School on cost of community conflict was a rather eye-opening example of the, I think the figures they were using on major projects was in the order of $20 million a week for delays caused by community-related conflicts and delays. So these, whether you have a moral obligation or simply a monetary one, you've got to come to terms with it with FPIC, and that's coming increasingly into play. I guess the bad news or the challenge is, as I said, there's a big gap between the principles that are articulated and the important, broader ideas around FPIC and its implementation on the ground. And to a degree, that's what we're going to try and deal with here today. We've got 3 panelists who have been working around these problems in various ways for a number of years, and I'm very pleased to be able to be here to facilitate the discussion. I'll introduce them in order, but I won't go into the bios. You've got the bios in your kits there. But we'll start with Lena Holgen, who is the policy director at Oxfam Quebec and who leads Oxfam's policy work on the extractives in Canada. We'll follow with Francois Meloche, who is joining us from Montreal. Francois is a long-time advocate and expert around issues related to social and responsible investment areas, and currently is the extra financial risk manager for Bâtirante, which is a pension fund system in Quebec, and is a servicing members of the CSN labor organization. And finally, Ian Thompson is the Resource and Rights Partnership Coordinator at Kairos, the Canadian Ecumenical Justice Initiative. So without further ado, I will have Lena come up. I'm going to try and keep people on time so that we have time for interaction and get some feedback. I'm sure there's a variety of questions and discussions that could come out of these things. So take it away, Lena.
Okay. Good afternoon, buenas tardes, and bonjour. Je suis vraiment honorée d'être ici aujourd'hui. I'm really honored to be here with you today and to share with you some of our thoughts and from Oxfam on this issue regarding the challenges and opportunities that we are seeing and the trends we're seeing in terms of the implementation of FPIC. Oxfam Canada and Oxfam Quebec are both members of a confederation of 17 organizations working in more than 90 countries. We work with partners organizations to end the injustice that cause poverty. Oxfam has been working on the extractive industry sector for more than 15 years in Latin America, Southeast Asia, and Africa. We support local communities and partners affected by extractive industry operations. We advocate directly with corporations, financial institutions, and governments to encourage greater respect for human rights, particularly on FPIC, for greater transparency and accountability and over the financial flows and benefits from extractive industry projects and for better development outcomes. In Oxfam, we believe that ending poverty starts with women's rights. Extractive industry operations have disproportionate impact on the lives of women, and Anne-Marie talked a little bit about that this morning. In our extractive industry work, we are supporting women's leadership, and we are seeing how it can lead to promote greater accountability and respect for the rights of all community members. I would like to talk now about a report that is coming, we're publishing in July, so you're going to have a first sneak peek into it. And it is the Community Consent Index. But before I talk about that, I think I would like to also clarify on what is Oxfam's position on FPIC. So we define FPIC as the principle that indigenous people and local community must be adequately informed about oil, gas, and mining projects in a timely manner and should be given the opportunity to approve or reject a project prior to the commencement of operations. For indigenous people, FPIC is established as a right under international law. Indigenous people's rights under international law reflect their standing as distinct, self-determined people with collective rights. However, FPIC is emerging more broadly as a principle of best practice for sustainable development, used to reduce social conflict as well as increase the legitimacy of the project in the eyes of stakeholders and right holders. In Oxfam, we believe that FPIC process must be ongoing. Project developers should facilitate community participation in decision-making through the life of the project, and communities should have the opportunity to give or withhold their consent at each phase of the project development and when changes to project design entitle potential impact on communities. So now on the Community Consent Index. This is a policy brief that examines public available corporate policies regarding community rights and community engagement with a particular focus on FPIC. The research that I mentioned will be published in July, includes 38 oil, gas, and mining companies. 6 of them are Canadians, and it also includes some Brazilian and Chinese companies. The policy brief provides an update to our 2009 and 2012 Community Consent Index that you can find in the Oxfam website. The main purpose of this research is to evaluate company commitments in practice, but to highlight changing trends across the industry in order to encourage a race to the top among companies with regard to policies. So what are the trends that we're seeing there? First, we are seeing an increase of commitments to FPIC by companies, commitments to respect FPIC for affected indigenous peoples. We saw that from the 38 companies, 13 companies committed to FPIC for projects that affected indigenous people. All 38 companies in the sample at least committed to consultation or dialogue with communities. 22 of the companies reviewed for this research make public commitments to seek the support or agreement of local communities, and this regardless of whether communities self-identity as indigenous people. While not equivalent to FPIC, this is at least a beginning to acknowledge the role of communities in influencing decision-making. There is also the issue of the business case. Some companies are understanding that FPIC is actually good for their business, and if they don't implement it right from the beginning, it is going to catch them up later. Mining and energy companies have lost billions of dollars invested into projects that have experienced clashes with local communities, to say nothing of the cost of reputation that they have regarding these issues. And Alan mentioned this recent study from Harvard University that found that approximately 20 million per week are lost as a result of production delays from social conflicts. And a representative from a company also said FPIC should not be looked by companies as a philanthropic enterprise. The FPIC needs to be taken out of the philanthropic world and make it part of the business case. Other positive trends that we are seeing is at the level of the international organizations and some governments as well. So we have the World Bank private lending branch, the International Finance Corporation, that has updated its sustainable framework to require that corporations that corporate loan recipients whose operations impact indigenous peoples must implement FPIC. We have also the International Council on Mining and Metals that published in 2013 to ask members to commit to FPIC processes. And last year, the China Chamber of Commerce of Metals, Minerals, and Chemical Importers and Exporters produced voluntarily social guidelines for outbound mining projects which call on companies to protect the rights for FPIC of local communities, including indigenous people. At the level of governments, we have seen in Africa commitment from regional organizations like the Economic Community of West Africa, and that they are calling FPIC of local communities that face potential impact from mining, hydrocarbon development, or natural resource projects more broadly. For the Americas, the Inter-American Court of Human Rights also issue finding callings on states to implement FPIC to projects with potential significant impacts on indigenous people. And we heard a little bit about that this morning as well. And then at the level of national governments, we have seen also progress in Latin America, and we have, I think it's Peru and Chile that have some consultations law in place. And another research that is coming out in the summer also by Oxfam and the Due Process of Law Foundation is an evaluation of the advances in Latin America regarding national level legislations and also the challenges in implementation. And this research will include analysis from Brazil, Chile, Colombia, Guatemala, and Peru. So now I will talk a little bit about the challenges that we saw in the Community Consent Index. So I mentioned there is a growing commitment from companies to carry out engagement consultation with communities. And however, detailed implementation guidance on FPIC remains lacking. Several companies interviewed for the index expressed reservation regarding the rights of communities to withhold consent. There is also a notable difference between oil and gas sector and the mining sector. Oil and gas companies are clearly lagging behind on FPIC commitments. There are no commitments from companies to uphold FPIC for non-indigenous projects affected people. And on gender, there is a great gap. The issues on gender were not a strong focus for the majority of companies, and neither regarding the engagement on women in consultation. And now I would like to talk also about the buzzwords. I participated at the PDAT convention, and I have been in other international spaces where the issue of consultation has been at the table. And we hear a lot from companies about the need to build trust, to create shared value, and to manage community expectation, and how this is a huge challenge. But I think that a lot of the time what I'm hearing and what I was hearing in those spaces was about the create shared value is more about the value of the values of the companies. When we're talking about managing expectations of the community, I wonder if companies are managing their own expectations, because companies that are talking about consultation with communities, but it often sounds as we're going to consult, but we need to get to the yes. If companies are not managing their own expectations, it means they are not willing or they are not ready to hear the answer they don't want to hear, which it might be a no. We actually are thinking of our development in a different way, not the way you're coming to talk to us about it. So, thank you. And then, so there is this, the buzzwords, and I also heard a lot about on consultation is, and I think Anne-Marie and some of the speakers referred to it this morning, how it is the need, we need to consult, to dialogue to community, to build partnership, but it is also a lot about, in the background, what I'm hearing is, we need to go and teach them that we know what development is, and that the development we're proposing is the right one. And so this is also something that we're hearing from governments. The presentation that the government of Peru did in PDAC, not this year, but last year, they were mentioning how successful was the consultation process in Peru and how 98% of the conflicts were, they had to resolve those conflicts. And I asked a representative of the government of Peru, what happened where a community say no to, you know, to be simply, they are departing from the, no, we don't want this mining here. And the answer from the representative of the Peruvian government was, well, in Peru, everybody wants mining. And so, and I said, so when you mean success, 98% of success, do you mean is because the project went through? And he said yes. So I think that we are excited to see this progress, to see more companies engaging and all that, but I think we also need to, as civil society, this is our role, and as members of communities, to question how much of this is truly and in good faith is we're looking for a real and truly dialogue. Also, I want to refer to, you know, I think that the conversation around veto is a little bit unfair, because how many times a company gets to a community, they are going through their project and suddenly they decide, well, we don't want this anymore, we're leaving. Are not they saying no to the project? Did anybody ask them not to do that because they were vetoing the project? So anyway, maybe some reactions that would be interesting to hear. And then I mentioned, yes, progress in terms of legislation from some countries, but there are a lot of problems in implementation, and in Peru we are seeing this, and there are some challenges around, for instance, identifying who is indigenous and who are not. Some communities, campesina communities from the highlands, they are not considered indigenous, so there is a debate around that. And again, I will note, because I have to stop soon, the new research that I mentioned on the analysis in legislation in Latin America will have a lot of content on that. And just to conclude, I will say that while change is happening in the industry and with some governments remaining to that, we need to continue as civil society groups and communities. We need to capitalize on the movement of companies towards embracing FPIC. Yes, we need to encourage companies to get on board, and also governments to create an enable environment for FPIC. But we also need to demand that companies to develop a clear and overarching commitment to gender that respect the rights of both women and men and involve both women and men in the consultations and decision making. And we need to continually monitor the implementation of company FPIC policies and to hold companies accountable. So I hope that the Community Consent Index that we will be releasing in July will be a great tool for you to use. There is clearly expressed there the commitment that these 38 companies made, and so we can hold them to account on what they have put in paper. So thank you.
Okay, thank you. Is it on the screen? Okay. Well, thank you very much, everyone, and thank you, Alan, for the invitation and for the organizers of the conference. So I think my comments will be brief, and there will be some overlap with Lena. I think I come from the investment world, so I represent an investor. But I guess there's a number of different types of investor. And we're called what we call an asset owner. So we represent the beneficiaries directly. So I don't manage the actual portfolio. So just to give you an overview, my background is really in the environmental movement and social justice. So I come to this world with that perspective. Okay, I'll give you a quick, really just give you a sense of the history. Responsible investment, and before I guess we could have called it shareholder activism, shareholder engagement, really dates back to the 70s, when the first slide here is on the Interfaith Center on Corporate Responsibility had was calling for divestment from South Africa. And it just to give you an overview of the different issues, since then we've been talking about labor rights, human rights, climate change, etc. This is a pie chart of the different type of shareholder proposals, and it really gives you an idea that there's a number of environmental proposals, political contributions. The human rights part is maybe a bit newer in these types of proposals, and this is where the indigenous people's rights would fall in. More recently, the responsible investment became mainstream, if you will. The UN created the Principles for Responsible Investments, and this is really a commitment to integrate. When we say integrate environmental and social issues, is really to consider these issues when deciding whether or not to invest in a company. And the other commitment is to engage with companies to discuss issues of social performance, human rights, etc., and try to affect change in companies. Right now, there's over 1,200 investors that have signed on. If some of you are contributing to the Canadian Pension Plan, for example, or the Ontario Teacher, or Caisse de Dépôt, these are large pension funds, have all signed to the PRI, so they all have a commitment to responsible investment that they can be called on. Okay, so now to the case for FPIC. I think just this is very high level, but I think to explain, we have, as investors, we have a fiduciary duty to our beneficiaries to take care of their pensions. The way we interpret this is to look at the whole interest of our beneficiaries. So we want them to have money for their pensions, but we also want them to have an environment that is clean, to have, as citizens, have rights, to be basically working towards sustainable development. So we try to look at it in that view, and that would include human rights. Of course, environmental and social issues affect long-term returns. This is quite clear, I think, and studies show it. The issue is perhaps more on the long-term versus short-term, and the market right now is geared toward the short-term too much to include adequately these issues. And this is strange because, in a way, people don't need to have their money right now. They are investing for the future, for many years to come. So we should not be so short-term, but that's the way it is. The other sort of framework is the stakeholder view of the company. So the companies should not only be responsible to its shareholders, which is the sort of dominant view, but to all its stakeholders. And so we keep on repeating that shareholders are just one of the many stakeholders. The only thing we do is own part of the company. It doesn't mean we own the company and we can decide for the company. Okay, and so just in relation to extractive companies, we're really seeing FPIC becoming more and more important as sort of the guiding principles to address community relations in general, in particular Indigenous people, but I think in community relations in general. And this is increasingly important because of resources are increasingly in areas where there is populated areas and in many geographies. So FPIC being the best practice, it's clear that the benefits outweigh the cost, and that it's the best way to build long-term relations. And I think another element is for international companies that it clarifies the position of a company towards the government, because a lot of the issues that companies report, their sort of concerns with adopting FPIC is the relation with the national government, and the fact that they don't want to be seen as imposing their own processes when there is already processes in place. Okay, there's a number of studies, I won't go through them, but just to take down, to note that IRIS, a London-based company, has done studies on Indigenous people's rights risk, comparing companies. And the other one is First People Worldwide, which has just released a study looking at US companies and their individual mining sites and oil and gas sites. And of course, as Lena says, there's a number of cases, I don't need to go through them, but of clear evidence that there is a risk for the financial value of companies. Of course, in the case of Barrick, that has to write off temporarily Pascualama, for example, or Hut Bay, or it has an impact which may be hard to identify clearly on the stock price, but it does, we think, have a long-term impact on the capacity of the company to access resources and perhaps investors. Okay, I quickly mentioned some of the response we're getting. We're basically, as I said, FPIC is the main topic of discussion. When we come to a company, we look at their processes in place and really say, have you considered adopting a policy that clearly states you are in favor of FPIC? And as Lena mentioned, there are some companies that do mention it, but we think there's progress, of course, to be made. Many companies will say we already have policies and practices that are complying with this standard. We don't need to explicitly say it, but we think they do. Also, the issue of the relation with the national government is an issue, and the fact that they consider FPIC a commitment that government have taken through the UN declaration, and that it's not for them to be involved in this discussion. It's really for the governments to get involved. Okay, I'll jump this. This is just to show you our process for engagement. I mean, the only point in here is that the shareholder proposal is an outcome usually of a dialogue with companies. We approach companies with an issue, we ask questions, a lot of questions, and it's pretty much our main tool, at least for us, is to ask questions and provide some recommendations and these kind of discussions. But when we, at some point, decide the company is not moving, we may file a shareholder proposal, and I can answer questions if you have about this process. And usually the proposal is to either report on an issue or adopt a policy. So an example we've been involved with is Talisman Energy, who you may know, which has just been acquired by Repsol. It's a company that was all over the world, pretty much, Papua New Guinea, Peru, Colombia, Kurdistan, and they were having an issue in Peru. Amazon Watch was an NGO in the US, was on this topic and approached us, but really it kind of went both ways, because we also tried to, of course, interact with NGOs as much as possible and source of information. So we decided to file a proposal asking for, not for the company to adopt a policy on FPIC, but to report on the cost, do a report on the possibility of adopting an FPIC policy. It seemed like sort of a no-brainer, like a proposal that would gather a lot of interest by other investors. But the company accepted, so we withdrew the proposal. And so we worked with them to find a common organization that would do the study. And so there was an organization in Washington that conducted a study and basically came to the conclusion that FPIC, there is some cost to adopting an FPIC policy, but it's the benefits outweigh the cost. And so in the end, Talisman wrote up a new policy, and I have the text here, but I think the main thing to take out of this is that Talisman describes the definition of FPIC for them and in the policy, and then that they will endeavor to obtain and maintain the support and agreement of communities. This is at the time, and I'm not sure right now the state of corporate policies, but this was seen as a good first policy in that sense. There's been other efforts to other companies, Tech, TD Bank, Scotia, RBC. Another example, perhaps, is ConocoPhillips, the U.S. oil companies. In the early 2000s, Burlington Resources, another oil company, was in Ecuador and quite controversial with some of the First Nations. And some U.S. investors, and again with Amazon Watch, engaged with the company and had several meetings. And one interesting aspect of this, which is a bit different than from our approach, they really went directly to the leadership of the indigenous people in Ecuador, wrote with them and engaged with them as well to sort of know what they wanted out of the company. Okay, I'll go a bit faster now. Yes. Okay, I'll come back a bit later, perhaps, to the Talisman example, if you have questions. This is for the engagement directly with companies, but we do have a lot of different other ways to engage on this topic. One is with the Borough Leadership Council, which is a multi-stakeholder organization that is looking for solutions to protect the boreal forest. There's investors, companies, First Nations, NGOs, and we're now about to publish a second report on FPIC in Canada, which will come out soon, I think in June. Okay, in June, and which really tries to look at the three sort of actors, governments, companies, and industry, and First Nations, and look at ways that these three can interact to create the conditions for FPIC to be respected. So I invite you to look at the website of the Boreal Leadership Council for the report. Just quickly, the Indigenous People Working Group is a group out of the Social Investment Net Forum in the US, and they also have interesting work that they do right now. They're focusing on getting the Washington Redskin to change their name, which is a bit outside of our usual work, but it's another issue related to Indigenous people. And we participate in multiple, contribute to the standards of the UN Global Compact, ICMM, World Bank, as any NGOs would do. So we try to provide feedback to these standard setters. So if I have only 5 minutes, that's okay. Okay, so quickly, just my experience with Talisman, just want to go over this case because it exemplifies, I think, a lot of the cases of conflicts around extractives at least in the Amazon. Talisman was in the north of Peru, had already been there for about 10 years, had conducted a lot of testings, some drilling, until they left, but that's the end of the story. I'll come back to it. This is the concession which they had access to. So in green, that's the whole of the concession. The actual area that they were exploring was in yellow, and they had agreements with the communities in this section. So in Peru, there is the concept of directly impacted communities and indirectly impacted communities. So the directed one, they would have agreements with them. The issue is that, of course, it's not as simple as this, and they were talking individually to communities. But these communities are all part of the Ashwar people, and before oil came, because this is not the first oil project, there was more cohesion. There was one federation to represent all the communities together. When Talisman came, there was already a fracture in the leadership. There was, multiple federations. There was one in the red dots, which was the largest one, was opposing any oil very radically, very clearly on their territory. Whereas the other ones were regrouped in 2 or 3 different federations, and they were in favor. And this was claimed that these federations had been sort of created, to divide the people. They were created because of the oil and for no other reason. And so there is, this was a conflictive situation, obviously. This is a map of showing the overlap of the hunting territories. So really the communities are just on the map, but I mean the whole territory is shared by all these people, and so it's never so clear cut. So the fact that they were engaging with communities that were closest to their operations was almost irrelevant. It needed to be much larger. But Talisman was aware of this, but they were always in the position of saying, we have agreements with the communities close to us, and we're open to talk, to negotiate, to anything with the others. But the other Ashwars were simply saying no, and they were coming to Calgary with Amazon Watch, making a lot of publicity, and so very conflictive situation. This is a picture of one of the villages we visited, which was a village that was in favor of the project, and these are members of the communities that we met. I think one way Talisman tried to address this was to create these what they call multi-federation meetings, which were held every so often, maybe twice a year, where everyone would be invited to come and to discuss issues they would have with the companies. The Talisman would explain what their plans were for the upcoming period. And then socioeconomic contributions, which was an issue, of course, because they were basically handing out some contribution. It wasn't just thrown out like that. There was a process, but obviously it created tension and expectations and challenges. So just to conclude that this, I guess, at the source, the issue is that concessions were given out in the Amazon without consultation, and that's, I guess, at the source of the concerns. There was a fractured leadership, very, very strong conflict. Some people told us they couldn't go in the territory of the other federation, or else they would be attacked physically, violently, and they were all part of the same people, really, the same language, etc. There was an issue of identifying the representatives to be at these meetings, which is an ongoing issue with FPIC, of course. And the risk of corruption, the only way to get people together was to bring them in a village, in a town, which already was perhaps disturbing, and it was putting a lot of weight on the shoulders of the representatives, and perhaps giving them a role that they didn't really have in the community. And so there was, this aspect was quite present, the risk of corruption. Okay, so just to conclude, I think just wanted to say for us, for investors, and again, I don't represent really the majority of investors, of course, we're I guess a small group of very interested investors in these issues. In the US, in Europe, there's a number of them. I think we need to talk a little bit about self-determination. I think hearing the speakers this morning, it appeared to me that really what would be useful is to get mining executives to be in the room in these kind of meetings and hear from them directly. But these kind of discussions, the political aspect of the aspirations of First Nation and the Indigenous people is quite important to have in the discussion. I'm not sure how to do that, and not just have a sort of a FPIC as a check mark, and you got to get the FPIC and that's it. It needs to be larger. We need as investors to outreach more to Indigenous people, to NGOs and to Indigenous organizations. I think we're in the process of clarifying best practices in FPIC, and also to assess, how can you measure or how can you demonstrate that you have done everything that you could as a company to create the conditions for FPIC. That's still something we need to work on. And the last thing is to engage with a larger scope of companies, smaller companies, trade association, and finally the board of directors. I think we're always talking to executives in the companies, but the board of directors have a responsibility to have an oversight of the risks, and they need to include, of the mining companies at least, they need to include all these issues, which I'm not sure they do really, and they're the ones that we elect as shareholders, so they're supposed to be responsible to be informed and to take the right decisions. So these are just some ideas, and yeah, thank you very much.
Good afternoon. My name is Ian Thompson, and I work with Kairos Canada. It's a real pleasure to be here participating in the symposium today. On behalf of Kairos, I'd like to thank all of you for turning out. This is really what we hoped for, was a rich exchange between so many people who are deeply committed and care about these issues. Kairos, as an organization, we bring together Canadian churches to work on peace and justice. And we continue a long tradition that has been going on for over 4 decades of Canadian churches acting in solidarity with Aboriginal people. Our programming is both domestic, looking at justice issues here in Canada, and international, working with global partners in Africa, in Latin America, and the Asia-Pacific region on issues of concern to them. So it's a very broad mandate that we have, and a very long tradition of working in solidarity with Indigenous peoples. Our work on Indigenous issues is guided by an Indigenous rights circle, where representatives of our churches and Indigenous partners sit together to advise us and guide us on our way forward. We also work through many coalitions and networks to be advocates. We're a founding member of a network called the Canadian Network on Corporate Accountability, which is trying to raise the bar on corporate accountability standards for Canadian companies when they're operating internationally. And it's really through these partnerships, through these coalitions, and through these networks that we see change happening and possible. Before I get into my remarks, I did want to make a plug for a report that was just posted on our website called Gendered Impacts on Resource Extraction and Indigenous Women. If you enjoyed what Anne-Marie had to say this morning, she was one of the featured speakers at our symposium, so I encourage you to take a look at that report that's available on our website, and you'll hear a lot more. You touched already, Anne-Marie, on some of the gendered impacts of mining that you've experienced and that your research has revealed. But I really encourage you, and it kind of follows up what you were saying, Lena, about gender justice being an integral part of respecting free, prior, informed consent. We can't have one without the other. Kairos is not an acronym, which is, for some reason, we insist on writing it in capital letters everywhere. But it's not an acronym. It's actually a Greek word from the Old Testament. And it's a Greek word for time, not linear time, which the Greek word is chronos. But kairos in the Bible is referred to as God's appointed time. It's a special time or moment, and it can be a time of crisis or a time of opportunity. And our work at Kairos is to look out for those moments of when transformative change is possible. And our member organizations, as we prepare next month for the closing of the Truth and Reconciliation Commission and figuring out what the next steps forward are towards reconciliation, we're seeing this as a Kairos moment. And I do think that this symposium and the level of interest that it's generated around the issue of free, prior, informed consent, in Canada today, we are at one of these Kairos moments around this issue. And whether it's the Supreme Court decisions that we're seeing, whether it's the organizing on the ground, whether it's the allies coming forward, I think there's a real moment of opportunity here. And this panel was asked to look at some of the challenges and opportunities connected to free, prior, informed consent when it comes to corporations and investors. And that's an area that Kairos has worked on for many years. We followed the tradition that Francois referred to of the Interfaith Center on Corporate Responsibility in the United States. Canadian churches have been filing shareholder resolutions and engaging in dialogue with companies for many, many years on issues of concern to us and our partners. And so that's a concern of ours as well, and a strategy that we employ to try to advance positive change. The other thing we do is, rather than speaking on behalf of partners, we actually bring partners to Canada to tell their own stories, to tell them to people in our churches, to tell them to decision makers. This month actually marks the 10th anniversary of a visit by indigenous leaders from the Philippines to testify before a parliamentary committee on the impacts of Canadian mining in their community in the southern Philippines. And the committee members were so moved that they not only wrote in their study quite a strong and ambitious policy change agenda around corporate accountability with respect to the extractive sector operating internationally, they also included 2 recommendations that responded directly to the case that those Indigenous leaders had brought to them, saying that the Canadian government should investigate the Calgary-based mining company and assess the impacts it was having on human rights and Indigenous rights in the particular mine that they raised concerns around. And secondly, they included a recommendation saying that the Canadian government should not be promoting this company until that investigation is concluded, based on the evidence that they heard as a committee. It was really what brought Kairos and other members together to form the Canadian Network on Corporate Accountability, that policy change agenda that this all-party parliamentary committee report laid out, saying Canada needs to develop legal norms for how our companies should be operating when they go internationally. It should include human rights impact assessments. We should be reviewing Canada's role at institutions like the World Bank and seeing, are we a player in advancing better business practices and greater respect for human rights or not? And it's an agenda that we keep pushing as Kairos and with our advocacy partners in this network, because we know that these sorts of changes just won't happen on themselves. It's a network that's continued to expand and grow. Some of the organizers of this event are members of that network, and we're always open to gathering strength and gathering more membership to help drive that agenda forward. But as far as the opportunities and challenges, I think one of the ones that brought our partners from the Philippines all the way to Canada is that free, prior, informed consent is written into law in the Philippines. And they were reporting that they were consistently getting their rights violated despite the fact that it's written into the Indigenous Peoples' Rights Act of the Philippines. They were calling on Canada to play a role as the home country for these corporations, to say, you know, we are pushing our governments to respect our rights and to live up to the laws that they've adopted, but we also feel it's incumbent on you as Canadians to hold your companies accountable for the human rights impacts they have when they operate internationally. And I'd say for Kairos, that's the first challenge, but also an opportunity, is that we are here in Canada, and Canada is home to over 50% of the world's mining and exploration companies. So when you think about globally, that more than half of all companies in the mining and exploration sector are registered in Canada, that's an amazing opportunity. What sort of standard we set for our industry when they operate internationally is going to impact on Indigenous peoples around the world. The companies that are registered in Canada have interests in over 8,000 properties in over 100 countries around the world. So what policy gets developed in Canada matters around the rest of the world. And that's why Indigenous people keep traveling to Canada to tell their stories, to push our leaders and policymakers further on this issue. The second challenge I would highlight is Canada's lack of leadership around the issue of corporate social responsibility. And the two may go hand in hand. I think the Canadian government sees having a lax regulatory regime as a way of retaining all of the mining capital and being the premier market as far as raising capital for mining operations. But I think that's misguided. And as the process of the UN declaration was drawing to its close in the mid-2000s, there was another process at the United Nations that was ramping up around business and human rights, and trying to define what are the human rights responsibilities of business in the UN system. And the special representative on business and human rights, John Ruggie, who was appointed to lead that mandate, I just want to quote a line from a report that he put out that for me sheds light on a great misunderstanding on the part of our government. Ruggie writes, governments should not assume they are helping business by failing to provide adequate guidance for or regulation of the human rights impacts of corporate activities. On the contrary, the less governments do, the more they increase reputational and other risks to business. I think this is a problem that we have yet to persuade our government of, that actually government inaction is not doing business a big favor. It's actually leading to a lot of uncertainty and a lot of risk and things not being addressed and not being dealt with. Canada has not been a leader around the issue of corporate social responsibility compared to even some of our peers. When you think of things like voluntary principles on business and human rights, weren't developed by the Canadian government. Other governments had to step up and do that. Canada was late to the game. Revenue transparency, reporting on payments between mining companies and governments. Canada was very late to the game in that. It's hard to think of an initiative where we've been out front on as far as corporate social responsibility. The one thing the government has been out front on is promoting the commercial interests of our mining companies in every market around the world. Last year they formalized it in what they are now calling a Global Market Action Plan, where they announced that they would be harnessing all of Canada's diplomatic assets to promote and advance the commercial interests, the private interests of Canadian companies in world markets. So that they are providing a type of leadership and a kind of cheerleading aspect, but that other aspect that Special Representative John Ruggie was talking about creating the guidelines and regulations for companies, we're not seeing. Thanks. Our organization has been part of a campaign for the past 2 years now called the Open for Justice campaign. We're realizing that to create change in Canada, the best thing that we can do is open up new avenues for those who are affected by our companies to come to Canada and demand justice. That I don't think that waiting for Parliament to pass the perfect regulatory package is something that we should be putting a lot of stock in. In a way, giving our partners more tools to defend their rights and to push Canada further as far as the human rights agenda is where we should be focusing our energies. The Open for Justice campaign is calling for 2 major policy changes. The first is the creation of a human rights ombudsman to investigate complaints regarding the extractive sector's activities internationally, to report, to make public its findings of those investigations, and to issue recommendations both to companies and to the Canadian government on what needs to change to remedy the situation when necessary. The second change we're looking for is to facilitate access to Canadian courts for those who've been harmed by companies when they operate internationally. Now, we have been down this road before. Kairos and our advocacy partners came very close to passing a bill in Parliament in 2011 called Bill C-300 that would have set new standards for the Canadian mining industry. It was narrowly defeated in a vote by about 6 votes. This was back when there was a minority parliament and things were a little more a little more interesting as far as votes in Parliament. And what happened was that the mining industry lobby came out in force. And many parliamentarians who said they were going to show up for the vote didn't show up that day. And if you plot them out on a map and see where the major mining ridings are in the country, that's how they exerted their influence. They got certain people not to vote against it, but just not show up that day conveniently. And it was a Liberal private member's bill, and even the leader of the Liberal Party at the time didn't show up for the vote. So there was a very high-level push to have that shelved. I think that's another challenge that we face, is that the influence of the extractive industries in our political system is an important one, and we shouldn't underestimate it. We know that when they do want legislative change, it can happen quite quickly, as we saw in the omnibus budget bills that gutted the environmental assessment process in Canada and lifted protection of so many of our waterways. But I do think that, from what Francois was saying, we should be somewhat hopeful about what investor strategies might hold. Kairos, as churches, we don't control a great deal of money, but we are institutional investors. And as institutional investors with longer time horizons, managing the pension funds of the clergy and the employees of our churches, we're not looking to make a quick buck. We are looking for longer-term, sustainable business opportunities as investors. And I think if we can work together with others who are interested in the similar agenda that Francois was talking about, I think there's real opportunities. I also think that as Kairos, we're committed to maintaining a dialogue with the industry on these issues. We met with members of the Mining Association of Canada last year to try to identify what issues are of common concern to the Kairos churches and to the members of the Mining Association of Canada. And resoundingly, the religious organizations within Kairos put the issue of Indigenous rights and free, prior, informed consent at the top of the list and said, if you want to come back and talk to us again, this is what we would like the topic to be. And the Mining Association, I know this is a more challenging topic for them. I know that they were invited to participate in this panel. The Prospectors and Developers Association of Canada was invited to participate in this panel. And as industry associations in Canada, they haven't taken formal positions on the question of free, prior, informed consent. But they were willing to speak to us in an ecumenical dialogue space about the issue. Several of their members turned up to discuss the issue. And I do think that they recognize the importance of it. And the Chilcotin decision certainly came up as something that has raised it up on the level of importance for the industry. They know it's an issue that they have to deal with. And on one level, I would say the industry may actually be more pragmatic than our governments. They want to, get a project running, and they, know that there's going to be certain expenses and certain agreements and certain deals that have to be made. But at the end of the day, there may be a sort of pragmatism that may dominate there that we may not see on the part of the government. But I do think that we have to keep dialoguing. We have to keep encouraging our partners to come and speak to decision makers, to speak to Canadians, to tell their stories. I think as investors, we can be doing more to strategize and network and work closely with Indigenous peoples to try to raise the bar as far as what corporate policy looks like. And I do think we also have a role in holding our government to account in the activities, particularly when they go internationally and are promoting our companies often at the expense of the human rights of Indigenous peoples. That has to stop, and we have to work to demonstrate that respect for Indigenous rights is a fundamental part of Canada's international reputation and has to be part of the business strategy that Canada adopts internationally. I think we can become a leader in the area of corporate responsibility and in the area of respect for Indigenous rights. We just need enough people to get behind that movement to make it happen. Thank you.
I'd like to thank all the panelists for really stepping up and providing some really good insights on both the opportunities and challenges that are presented by this increasing set of demands and expectations around FPIC. I think they drew some really important links between corporate action and government action and the interrelationship between those two, set out some priority areas for action, and also I think identified some hurdles that hopefully we can work to better understand in order to overcome as businesses that are in the business of making money are faced with this deeper sense of obligation around justice and around collaboration at the community level. So with that, we have 25 minutes before our break, and that leaves us time to deal with questions, discussions, and thoughts. If people want to bring those to the microphone, I encourage you to keep them short and concise so that we can allow people to join them. And I'm wondering if we might start with something from those of you out there in the virtual world, and thank you for your patience wherever you are.
We do have a question that came in earlier today, which was if there is a company or a corporation that has an FPIC policy, and yet they're not honoring it, what kind of steps can be taken to hold them accountable to that policy?
Any members of the... So the question is around accountability for stated policy.
Yeah, well, yeah, maybe, I think as for any type of engagement with a company, it comes, at least for an investor, it comes down to the usual strategy of communicating with the company, asking questions, and filing shareholder proposals. I think maybe one thing that I haven't discussed is the fact that some investors have asked for independent reports on human rights of certain projects, and that might be one route. So if there is allegations of issues with a community, and if that involves not having FPIC, maybe one thing to ask is for the company to provide for an independent assessment of this. And then there's the issue is who pays for the assessment, and is it really independent? But that can be addressed in a governance format. For example, the Gold Corp a few years ago had this type of issue and proposal by shareholders, and the concept was to have an independent assessor conduct a human rights assessment of a situation in Guatemala, and there was a committee formed that would oversee this research. So choose the who would do it, the scope of the study, etc. And there was one person. The idea was to have 3 parties in this committee that would oversee it, and would have someone from the company, someone from the investor, and someone from the community. And so that's the sort of theoretical way to do this. It's not perfect, and there was a lot of issues with this project, but it's maybe one way to address it. Yeah.
Any of the other two want to comment on that question of accountability?
I may just quickly add to what you said, Francois, to say that the human rights impact assessment was conducted by Gold Corp, but the implementation is actually where they've fallen down, and it's one that I know some of the religious investors continue to push the company around actually implementing the recommendations out of the human rights impact assessment. So that's something, I agree that it's a step in a process of winning greater respect, but we're not there yet, even with that process. The other thing that the litigation recently involving Hud Bay and the lawsuit in Ontario around, well, there's 3 separate suits, but it's around a mine that Hud Bay owned in Guatemala. Part of the case is built around commitments that the company had made through their corporate policies, their corporate social responsibility commitments that they had made, played into the statement of claim of the plaintiffs, saying you said you would do such and such, and that was part of the basis for their lawsuit moving forward. So as increasingly possibilities open up for litigation in Canada involving human rights abuses in other countries, I would think that's another strategy you can employ if you feel that a commitment to free, prior, informed consent is contained explicitly in a company policy. And if you're interested in taking a legal route, you could build it into your statement of claim around a lawsuit.
And I will just add that there are also civil society organizations organize campaigns, and one example is the campaign on El Salvador and Oceanagol. And Oceanagol, they committed to respect human rights policies of the host countries, and which is this is not the case, but there is a global campaign on El Salvador and the lawsuit that the Oceanagol is putting on the government. So as citizens, I think this is something that we can do, is to join and support these campaigns.
Great. I'll go to the microphone on the right, then we'll go back up to the cloud, and then come back on the left. So.
Thank you. I would like to say how pleased I am to listen to someone from Peru. I haven't heard that before. I've always had an idea or belief that the Christian church was involved in indigenous peoples throughout the world. But I wondered if Ian, if he doesn't mind me calling him that, and of course I want to make a response to Francois, and I'll try to be as quick as I can. My question is in reference to New Brunswick, what took place with the shale gas protests in Rexton, New Brunswick on the 17th of October 2013. I first want to bring to your attention what then Premier David Alward, who also held the title of Minister of Aboriginal Affairs. Now, what I'm about to tell you is going to sound a little like third world, but it's the truth. His government released a document which someone secretly gave to me, dated the 23rd of November 2013. And this is the essence of what he said in reference to Indigenous people and how they were going to take care of the land in reference to Indian reserves in New Brunswick. He used the word, when Indian lands become extinct. He is referring to Indians or Aboriginal peoples as though we were dinosaurs or some animals or some kind of birds, some reptiles, something like that. When we become extinct, all land will revert back to the province of New Brunswick. And those of us who have seen the paper concluded that this is how he was going to be able to deal with the land in a peaceful manner. Now, my question would be to Francois here, and maybe I could also add to Ian, how much confidence should we place in Christianity when those of us who are well informed see that the CIA sponsors a lot of your events? Thank you. So back to Francois. Sir, I want to know, do you consult with major governments, like when fracking is to be done in New Brunswick or in the Atlantic region or any other place? Are you in consultation with David Alward and those types of people before you do your fracking testing or whatever? And where does the money come from? Thank you.
Yeah. Well, as investors, well, first of all, we don't decide necessarily where companies will operate, because we simply own shares in companies and let them decide, really. And we try, my job is really to try to influence the way these companies operate. But just in terms of corporate influence, I think as investors, we're trying to lobby governments as well on these issues. For example, in Quebec, I don't know so much the New Brunswick situation, but in Quebec, we presented some memoir, to the public audience on fracking. And so we put forward FPIC as a standard that the Quebec government should apply in any type of project proposal. So this is the type of, we contribute to public debate just as any NGO or other group would. Yeah. So I don't know if that answers the question.
So you're saying you're not aware of what took place in New Brunswick when?
Oh yeah, well, I'm aware of the issue just by reading in the paper, but not more than.
And you're not involved in that?
No, we're not.
Would Christianity be interested in mediating, or, I mean, there's 800 heavily armed men, came to kill. I mean, that's serious. Thank you.
Yeah. Do you want to?
I just quickly to respond that, Kairos and our members, we are living into right relation, but we know we're not there yet, and we know we have a long way to go. We were very disturbed by what happened in New Brunswick, and put out statements to our members of concern as soon as the incidents that you're talking about occurred. And our Indigenous Rights Circle has put the issue of fracking squarely on the agenda of Kairos and our member institutions. Later this year, we're going to hold an ecumenical forum on fracking to try to bring together as many of our churches as possible to try to understand the dynamics of those struggles. And Indigenous peoples in New Brunswick and British Columbia and other parts of the country are going to be playing a leadership role in shaping that forum. I do hear what you're saying, and we are working on that with our Indigenous partners.
Okay. As I said, I'll go for another one from the cloud, and then we'll go left and then right.
One more question come in, Alan. A person wanted to know if there were examples of a corporation having their operating license revoked where they were found to have violated the rights of Indigenous peoples. And the person who's asking the question was specifically asking this in relation to what Delia referred to earlier today, the Common Article 1 of the two conventions, which right of self-determination, but also that no people should be denied their means of subsistence. But I think more generally, if there's examples where, in defense of the rights of Indigenous peoples, the operating license has been revoked.
Okay. Well, I would refer people to the Davis and Franks article that came out last summer. It's a University of Queensland study, but also co-authored with or co-published with the Harvard Kennedy School. That has a number of it went into with the question of there appears to be conflict with a variety of communities where the social license negotiation would be a very polite way of putting it, as completely broken down, and what are the implications of that. And part of the research within that it details the huge cost, obviously to the community, but in this case also to the companies. So that is a really good source. But there may be specific examples that you might want to refer to.
Yeah. Unfortunately, I can't say I know many examples, and maybe just some other people in the room might know. But I know in Chile there has been some cases, and now I might be confusing either Goldcorp or Barrick, or both actually, have had to go back and review their permit applications because they hadn't consulted Indigenous people enough. So there's some cases, but
what I wanted to ask, and maybe this is jumping the gun a little bit on the next discussion that we're going to have, but we started off this morning with a very clear sense of the state's responsibility towards the rights of Indigenous peoples, and a strong legal definition of that. And we're now talking about corporations who are, I suppose, legally bound to do certain things. And in between, we have other jurisdictions. We have provinces. We have a messy situation in Canada with different levels of jurisdiction, trying to pass the buck so that the federal government would like the provinces to deal with consent or as they call it, prefer consultation. The provinces would like proponents to do that and just sort of report back that everything's fine. We talked to the Indigenous people. We've got everything sorted out. All you have to do is rubber stamp it up the chain, which creates obvious pitfalls and is not fair. Probably for anybody involved in the process. It's not fair for the communities. It doesn't work very well for the proponents, and it doesn't work very well legally for those who actually have those legal responsibilities. And I'm always sort of amused by the promises of companies and their corporate social responsibility statements. The first thing is often, we promise to respect the law wherever we go. And frankly, for the rest of us, it's not optional. But I guess if you're a corporation, it's different. And then we have the Canadian government saying, sort of echoing that, saying the government of Canada expects Canadian corporations to respect the law wherever they're operating. And yet there's no consideration for how functional that really is. And so I'm intrigued as well by the suggestion that it's actually really good policy and helps those governments, whether it's the Canadian government or any other government internationally, to know what proponents' expectations are, what the company's expectations are, that the government will actually uphold its own laws and its own obligations under international law in dealing with its own peoples. But again, it comes back to this question of who is ultimately responsible, and how do we make it clear that while it's certainly good practice for proponents to talk to the people that they want to work with at the community level, that doesn't address the legal responsibility in terms of the kinds of relationships that people
do the right thing. But if companies are not doing the right thing, companies some companies might truly want to do the right thing, but if the state is not allowing that, if you have, for instance, I think it's in Peru, you have a quite nice consultation law in paper, and at the end they say do everything, and at the end of the day, however, the government is the one that decides. That's not necessarily talking about real consent. So I think it's for us, we're looking at it is ultimately the responsibility of governments to ensure the rights of the citizens.
There's one, well, Francois mentioned this report that's coming out. It's a second report from this Boreal Leadership Council, which has a range of actors and players on it, including the Casca Nation and Treaty 8, but it also has TD and Desjardins, has a number of extractive companies, including Suncor, Tembec, and others. And it's been an interesting process listening to that report come to the front, and the key drivers there are some people in the financial community who are saying we're the meat in the sandwich. We're being told up here what the principles are. We're running into big problems on the floor, and what they are trying to look at is how to get some guidance on what's a successful role that companies can play, governments should be expected to play, and how can communities be part of this mix to create success. And so I think that report will be an interesting one of just trying to move that genuine conundrum that you're talking about, because it keeps getting shuffled between people, but it's ultimately some of the people who are trying to do the work on the ground that end up being the sort of the meat in the sandwich. But ultimately, yes, it is the government.
Yeah, and just a quick point on that. Maybe, just maybe, if this, the standards and the company policies are moving upwards and are getting closer to expectations of indigenous people, maybe it opens the door to government. It makes it maybe easier internally for governments to be able to support those kind of policies. I mean, it's the same for, climate change regulation, for other types of, so that's the theory. I'm not saying that's necessarily what's happening. It's just that, for us, that's our leverage is with companies. So we're always focused on what companies can do. But of course, we also have a big approach right now looking at how companies are lobbying and how they should not lobby, and maybe they should be more transparent about the way they lobby on all sorts of regulation and laws. And so, so I'm just throwing this out.
But I do think the Gold Corp is a good example that we've already talked about, which is that the Human Rights Impact Assessment revealed violations of Indigenous rights. And the point being, you got your permit from a government that had ratified the ILO 169 and then gave out permits in complete violation of its international obligations. And I think what the new human rights framework says, that as a company, it's not your duty to actually live up to the state's human rights obligation, but to move forward with a project with the full knowledge that the permit you were handed was handed out in violation of the human rights obligations. You have a due diligence as a company to do something about that, to not just move ahead like, oh, I got my legal permit, good to go. So it changes the dynamic. But I think it's good to point out that we're not asking companies to assume the responsibilities of states, but to do the due diligence to make sure that if you're in another country or even our own country, if the state isn't living up to its obligations, that becomes your problem too as a company.
Great. Thank you for your patience.
Thank you. My name is Ian McDonnell. I'm a certified mediator and group facilitator. In a previous life, I was executive director of the North American Plant Protection Organization, and that body brought together the agriculture departments of Canada, US, and Mexico to try and keep agriculture and forestry pests out of North America. A lot of our work was involved in establishing standards, and we took our own regional standards to a UN body that we belong to and proposed them as international standards. And so that leads to my question about the FPIC in terms of, does the UN body have, and I guess this is out of ignorance because I'm not familiar with the mining sector, but is there a standard protocol for conducting FPIC? I heard this morning from one of the speakers, they had just developed one, and I wonder how many others are working on protocols and whether or not there wouldn't be some value in having an international protocol.
A sector-specific protocol
Yes.
for, say, the extractives or the mining sector in particular related to FPIC.
Yes.
So,
yeah, well, Just quickly, the closest thing, at least from the UN, is the UN Global Compact is a series of 10 commitments, among which companies are invited to join, and there's a number of companies that have signed on to UN Global Compact. Human rights is part of it, and within this, recently a guidance document was created on indigenous, how to implement the UN Declaration on Indigenous Peoples' Rights. And so that I would think that would be the closest things, at least from the UN. But there's a number of standards from industry that we refer to that also addresses this.
Okay, thank you.
Thank you.
Hi, my name is Alana, and I'm a student here at the Faculty of Law. I'm currently interning for Just Governance Group along with Laura. She's my co-intern. And we're working with a lawyer, and she does a lot of international assessment. And one thing that we're working on now is Indigenous rights. And one question that I had in doing my research and also in listening to the panel discussions this morning and this afternoon was, maybe we can refer back to the Peru example. What happens to the indigenous communities when they're relocated? Because I know from reading the literature that the companies that are sort of imposing or maybe getting the consent to relocate these groups, they have sort of like the responsibility to improve the quality of life of these individuals. And it just really concerns me because I'd like to know what type of compensation is really allotted to these groups, and are there certain measures that need to be sort of discussed beforehand? So who has the right to land? So is it like I'm in the French section, so I would say like dédommagement en forme d'argent. Is it compensation of just replacing the land? And then when these companies get the licensing, what happens when they just decide to leave? So I know from the steps that we are taught and that we read, they have to have an exit plan before opening. So just if there's any comments about that, I'm interested. Thank you.
So the subject of resettlement, I know the IFC has guidelines on that, but any comments on?
Yeah, I think just on Peru, and I think every country will have legislation on resettlement. So that's one thing. I visited the Democratic Republic of Congo, and they had in part of their mining legislation some regulation around that. So in terms of what is the compensation, but I think as Alan mentioned, it's part of the international standards of any type of standards, and the idea is really to ensure that it's not only property, or it's also land that is used in a customary way, or that is land use, so that needs to be compensated for. So that's one element, but I don't know if you have any other thing.
Just to say, it does seem like the most well-developed area of policy, given the ILO kind of had a focus on that in their convention, and the World Bank standard has more developed around that issue than others. But just, as we all heard from the previous panel, the land is so fundamental to the identity and the survival of Indigenous peoples that I think even the best policies that we have out there are missing something. And as I heard everybody repeat that in the previous panel, and just that idea that no amount of gold that we could extract from under us could compensate for the land that we would have to leave. I think even the best policies aren't there yet. We have a long way to go around that issue of resettlement, although I think it is the most well developed, or that the more work has been done around that element of free, prior, informed consent with respect to extractive industries than any other issue.
I'm going to say we're just about at time. We started a little bit late, so if we could be to the point, and what we can't grab here, we can also carry into the next one as well. So thank you.
Thank you. My name is Nancy Rubenstein. And Francois, in your presentation, you said that Talisman Energy has made a commitment to endeavor to obtain consent. And I just wanted to comment, there's a big gap between to endeavor to obtain consent and to obtain consent. And to borrow the language of Chief Dean Sayers, I'm afraid Talisman Energy is coming to negotiation with an empty canoe. Thank you.
Yeah, and just a note, and not necessarily for Talisman, but I think any type of corporate policies, you usually will go through lawyers, their own internal lawyers, and they'll make sure that language is, precisely to avoid sort of maybe some type of language that we would like to see. So it's true that words are important in those kind of policies. Yeah. Okay.
Thank you very much. I just wanted to say that this panel is probably one of the most important panels in this whole discussion about free, prior, and informed consent, especially because this is where Indigenous peoples are pressured the most in relation to finance, foreign direct investment, extractive industries, and so forth. But I just wanted to come back to the question that was posed about the duties and in terms of the guiding principles, and it was important that Ian referenced the guiding principles on business and human rights. And there is the state duty to protect. This is the state's duty. There's a corporate responsibility to respect. And then, by and large, because of so many problems with human rights abuses, the third pillar being access to remedy. And it goes to the question about how do you then compensate for Indigenous peoples that may have been forcibly removed from their lands and so forth. And if you read the UN Declaration, the article first and foremost goes to the heart of land and relates to the right of self-determination, but also any kind of remedy has to be done on the basis of free, prior, and informed consent as well. And it really is, it pivots on the desire of the Indigenous peoples concerned. But I think that the work that Kairos is doing in terms of open for justice, especially with regard to the number of the mining companies that are registered here in Canada, requires that something more on the part of the government to, and this is what I understand you're working to do, to apply pressure to, in fact, have laws that require corporate respect for Indigenous peoples' human rights, and that the state has to undertake that duty to protect, and that's the part of the constellation of really being responsive to human rights. And there's been now a call through the Human Rights Council to try to morph some of these guiding principles into a convention. And I'm a little bit leery about that, because then these principles would only really be applicable to those that ratify a convention. And this is one of the beauties of the current Declaration on the Rights of Indigenous Peoples as a declaration, and the way that it's written in terms of rights and responsibilities or duties on the part of member states of the UN. If you then morph it into a convention, it's only applicable to those that ratify it, in contrast to it being a declaration that is now universal in terms of all Indigenous peoples and all governments, and the same would potentially be true in relation to a convention on business and human rights as well. So I just wanted to highlight that this panel, I think, has been very, very crucial in this discussion about free, prior, and informed consent.
Thank you. Yeah, and I'd like to thank the panelists and everyone who threw in questions. Are there any other burning questions from the cloud? Okay, that's great. Well, there's certainly surfaced a lot of very meaty challenges, and that was really part of the point of this whole forum, and we've done a good job of that. So thank you very much. We're 5 minutes behind, which is not too bad considering we started 10 minutes late. Let's follow the same principle of grabbing a coffee and coming back down here as quickly as we can. We've got from 3 till 4:30 to wrap up the panel, think through some ideas and potential actions, and thank you very much.
was a dude who came down. Yes. Typing stuff.
Okay, I think we're going to get started again, so I'll ask everybody to take their seats.
There's some water there.
Yeah, there's a jug here. So I have the pleasure of moderating the final panel of the day, the one that our panelists say is where we get to the fun part. My name is Craig Benjamin. I'm with Amnesty International. Some people in the online chat have been asking about how an event like this can be organized. Key thing is that a lot of organizations had to come together to pull this off, and we'll thank everybody for their contributions at the end of the day today. But I just want to acknowledge the Algonquin people for the opportunity to have this event here on their unceded territory, and to acknowledge the University of Ottawa for hosting us here in the law building. Today, the final panel is a little different from the previous ones. We have an opportunity to hear from one speaker who is not presented yet, and to have a return engagement from two speakers from this morning. And what we want to do is to move the discussion forward. We heard in the first panel today that free, prior, and informed consent is already part of the framework of Canada's laws. It's part of the framework because it has been recognized to be part of how the constitutionally entrenched rights of Indigenous peoples need to be recognized and protected, and that there's a series of Supreme Court decisions that affirms that. We've heard that it is well established in international law, the UN Declaration on the Rights of Indigenous Peoples and beyond, and that these international standards, contrary to the efforts of the Canadian government to tell us otherwise, in fact do have legal effect in Canada, have been recognized as such in courts. So it comes in this way as well. We've also heard from our second panelists that for Indigenous peoples, the exercise of the right to make their own decisions about their lands, their territories and waters for the benefit of future generations is an inherent right, that people have laws, traditions, institutions that they have exercised since time immemorial, and that people are today creating new protocols, new institutions, new methods to maintain and carry that on into the future. But that right is there and is being exercised and exists regardless, and people are determined to exercise that right. And then in our last panel, we heard that there is a business case for free, prior, and informed consent, a business case that important sectors of industry and finance are increasingly recognized. So as we come to this fourth panel, we have an opportunity to say, okay, how do we do it? What are the nuts and bolts of moving forward? What are some of the obstacles, and what are some of the ways that organizations, institutions in different parts of our society can come together for the common purpose of advancing free, prior, and informed consent? I said we have a couple of return engagements. Anne-Marie Sam from the Cowsley First Nation in northern BC will be a member of our panel. Among many other achievements, Anne has recently overseen a long-term research project looking at the social impacts of a large-scale mine that has opened in her territory without free, prior, and informed consent. Lorraine Land, who is a partner at, and because I'm challenged this way, I have to look this up, or I'll ask you, OKT or OTK? OKT, and has been working with First Nations and Inuit peoples in a number of really crucial court cases that have helped advance these rights. And if people who were here this morning knows that she brings a wealth of knowledge and information to the discussion. We're going to begin, though, with a presentation from Brad Young, who we've not had the pleasure from hearing from yet today. Bradley Young comes from the OCN in North Saskatchewan River. That's in present-day northern Manitoba. He has a master's degree in governance, and he has worked on a wide range of Indigenous rights, including in the areas of development, culture, and nation building. He was the first director of the Aboriginal Involvement Program of the Foothills Model Forest in the Rocky Mountains. And he currently chairs the Forest Stewardship Council's Permanent Indigenous Peoples Committee. So it's a real pleasure to be able to welcome him to be our first speaker today.
Thanks, Craig. Also like to acknowledge the Kichisipi, Usky, Anishinaabeg, our hosts here, the traditional hosts here, and the leaders in the room, Chief Dean Sayers, Chief Roger. I was going to sing to Chief Roger here. He's always singing for us, eh, Dean? Wherever we see him in our gatherings. He's always very respectful, and he brings in that, I think, that natural law belief that's in all of our hearts that comes from our home fires for First Nations across this land. Thank you, Craig, for the introduction. As he introduced me briefly, my name is Bradley Young. I am the Executive Director of the National Aboriginal Forestry Association. The National Aboriginal Forestry Association, just for a little bit of background, is one of the I would say one of the older national Aboriginal organizations in Canada. We were split off from the Assembly of First Nations in the early 1980s to handle and to separate, if you can ever separate anything in the First Nations world, from politics. So to separate a bit of the forest interest discussion with the larger political debates that still really ignite all of our confederacies and all of our nations as they come together through the actual political mandated organization. So this is where NAFA comes from. It's a First Nations organization. It's comprised of First Nations leadership from all the regions of Canada, and I'm the executive director. Why the separation? Why the focus? Why the detail? I think it really comes down to the importance of the forest and what it has always meant for First Nations people. First Nations people actually convened the relationship with our non-Indigenous settler friends, now through many years of interrelations, sometimes relatives, co-workers, neighbors. And this was done on the ocean. This was done before the first colonists were allowed to even land on Turtle Island. And what I'm talking about is First Nations people actively traded for firewood and timber mast replacements for the first ships that came across the water. And if you think about this metaphor, and you know some of the history and some of the teachings that come down from our elders, they'll talk about really how this was foretold, how the wind would bring settlers from all parts of the world, and the different families of the human people would come together on Turtle Island, and they would create a new world. That's some of the traditional teachings that are there. And that wind is very important in its connection to the forest, because everybody here today, and who has ever been for the human race, has taken that breath and exhaled. And we are inhaling the exhalation of the forests of the world. These are some of the teachings, some of the knowledge of Indigenous people in terms of why Turtle Island and why the forest is so very important, why these lungs of Mother Earth continue to be a central discussion point, policy area, legislative battleground, economic zone. It will continue to be that because the forests of the world are frankly pressured right now, pressured by human beings. Now, in terms of the kind of crass politics of today, it still is a very important sector in terms of the relationship with Indigenous peoples and non-Indigenous peoples. And I think one of the things that I always tell people is forestry for a lot of people is not sexy, right? It's kind of hidden away. The big mega projects, Patronus in BC, some of the mining, I guess, developments that are planned, Ring of Fire, the prosperity mines that the Chilcotin people are continually, actively pursuing free, prior, and informed consent, and have won some very important battles, including the Supreme Court decision that Chief Roger told us about. These are sexy. These are very, very easily, you can reach into the media and it's accessible. The forest is a little bit less accessible, but it's underneath everything. The Prime Minister of Canada, he lives in a home called Greif Wisfa. Groffrisfa, and I'm sorry for, I don't know the Welsh language, but it's a Welsh name of his house, 24 Sussex. And this house was built by Joseph Merrill Courier, who was one of the original Ottawa Valley timber barons. That's how formative and how important the forest sector is to Canada and continues to be for all Canadians. Of course, for First Nations, the forest is much more. The forest is a homeland. It's a vibrant part. It's the foundational component of all of our identities. And as this map tries to show in some level of detail, there have been different attempts at, I guess, coming to agreement, a relationship with the non-Indigenous settlers and the original peoples of the land. In terms of the, I guess where the forest sector comes into, with my mind, in terms of this homeland, is it comes to interim measures. It comes to tactics over time that change with our population numbers, with our awareness of the tool sets that are around. And FPIC is just one of the latest manifestations of the tool sets that we are utilizing to come to some sort of a different equilibrium in terms of power politics and an imposition of ways that we may or may not want to take up as Indigenous peoples. Because I think Chief Dean here really laid it down in a strong way. We still have our own languages. We still have our own territories. We still have our own laws. We still have our own ways of being on our territories. Now within that, because of the 633 formal First Nations, there is a lot of diversity of how to go about getting to that place, right? Different ways of asserting, different tools, different nations, different geographies. But I'm going to tell a little story in terms of the forest sector and the modern day forest sector in particular, how this is important with this dialogue. I go back to a young chief named Ed in BC. And at the same time that NAFA was being broken off from the AFN, but which was not originally the AFN, it was called the National Indian Brotherhood. And in terms of civil society in the world today, I'll just take a little tangent here and explain some of these nomenclatures. And there's some, some full circles that are being drawn here. The National Indian Brotherhood. Where does this brotherhood come from? Very, very kind of a dated term now. But it came from Indigenous peoples learning from the unions. It came from them learning from social mobilization and a large extent in the forest mills around Canada. This is the first updating of our skill sets in our confederacies, how you can come together. And this is why you have terms like the Union of Ontario Indians, the National Indian Brotherhood. And you think about how the union movement over time, it was, for these unions, it was an organizational point for a different vision of society, one that was based on social justice. And when I look at the co-sponsors of this event here today, I see some of the successor energetic components that you have all inherited in terms of Kairos, Oxfam, Greenpeace, Amnesty, this whole area of social justice. So I want to thank our non-Indigenous allies out there in terms of civil society. This is still a relationship that is worth developing. It's still a relationship that is very, very rich and ongoing, and we hope to continue it. Now, coming back from this tangent, in terms of this time of foment in 1982, Constitutional Express, this young chief, Chief Ed, he got a good idea. He got a good idea that he was going to be the logger on his land. And he was going to take up tenure. He was going to own the tenure on his land base. Now, where a lot of nations were at that time, they weren't willing to take, and many still are, they're not willing to take that step and actually take up a provincial tenure or some type of concession, because you're agreeing to, in one sense, an interim accommodation. That is kind of agreeing to the federal, provincial, municipal kind of ordering of things. And that's still an ongoing debate in our communities, in our nations, in our political discussions, if that is the right way to go. Well, anyways, Chief Ed, he decided his community was going to take up tenure. And at that time, they were the only nations taking it up. And there was, in terms of a number, they had 125,000 cubic meters of volume of logging. It's really, they had a big logging contract. And what we've seen over time is a huge development of indigenous capacity in terms of coming to different forms of political settlement, developing different business operations, governance operations, an awareness in the communities that they can put their imprint on forest management on their lands, and they can take control of discrete portions of their traditional territory. And this is where those red bubbles come in. It paints a picture quite clearly from that very, very beginning step in 1982 to currently right now. There is not a fifth bubble there. There could be, but 2015, where actually First Nations hold over 21 million cubic meters of wood supply in terms of tenure. Now that's an imperfect kind of interim accommodation, I think, in the minds of a lot of First Nations people, but it gives you an idea of the scale of tool sets that Indigenous peoples are utilizing to repatriate tenure on their forested land base. It gives you an idea of this growth, and if a mathematician looks at this, it's almost an exponential growth curve. As the non-Indigenous economy went through a period of the Great Recession, many Indigenous peoples were prepared and willing to take back control over the tenure systems in their neck of the woods and assume another level of responsibility. And it's always viewed in my mind when I listen to communities and when I go to communities who take up provincial tenure, it's always an interim accommodation in their minds. Just one step, one more step, as they eventually move towards full Indigenous self-determination on their landscape, which is really, from what I've heard, about respectful partnerships on their land, so that they can create value with their neighbors and with everyone else around them. So they're not the poor cousin at the table that has to beg. They're there with a position of strength, and they can contribute to the evolution of their community and their neighbors. This idea of FPIC, I would argue, has been really impacted by forest management and First Nations active in the forest sector. A lot of the court cases going back to the treaty constitutional issues of the day, a lot of them will have a timber concession or a tenure concession that is under dispute. A lot of the original activist political movements were in response to logging operations or some sort of forest operation that communities downstream or in the middle of a cut block didn't want to be a part of. And this is where a lot of that community energy, in the words of, the romantic words of the colonial period, they had a good enemy. They had someone to stand up to for their people and to galvanize energy to say, we're going to stand up for our rights. We're going to stand up for our vision. So there's this covenant from the land as an identity, going through the Aurora Proclamation, going through the Constitution Act, coming to the Chilcotin Nation's magnificent win in the Supreme Court last year, and now into the market space, which is the bottom picture here. I know it's hard for people to see, but in terms of the forest sector, it's figuring out that FPIC is probably the way to go when you're wanting to, keep the peace with Indigenous peoples, have some sort of modern day management of a forest unit, to have some sort of an economy, to have people working with some level of social justice with environmental covenants in place. And FPIC has been programmed now into a lot of the forest management standards in terms of market access. Now, the primary one, internationally speaking, is the Forest Stewardship Council. And Craig, when he introduced me, he mentioned one of my chair duties that I've been asked to to sit in for the First Nations forest sector, which is the Permanent Indigenous Peoples Committee of the Forest Stewardship Council. And I know that's a lot of terminology, and it's coming from at the end of the day, and you know there's more acronyms here, but basically what this is market access. Civil society has made a decision for a lot of consumer products that they want a level of social justice and environmental performance in the products that they buy. It's part of the dialogue with slow food, with buying organic. People want to know that the products that they're using basically aren't destroying the world. And so the mother system, actually, the grandmother system for this movement actually was the Forest Stewardship Council. It came out of the Rio Convention in 1992, and civil society came together and they created a market access certification system that said you have to have a level of standard of operating in the forest, and if companies agree voluntarily to perform against this standard and they agree to be audited by third-party auditors, so it can be verified independently, then there'll be a creation of a label, which is, you'll see it on a lot of your envelopes, FSC. Now this movement has moved off into other areas, and I was thinking about some of the comments that I was seeing in the comments section of the YouTube channels. The Marine Stewardship Council, fair trade. For some of the in the Amazonian basin, I know it's called the EQUAS, or the Equitable Oil and Gas Initiative. This all has traces back into the forest sector, into the original energy that went into the Forest Stewardship Council, and has now come full circle because the Forest Stewardship Council has actually taken free, prior, and informed consent, and we have just put it right in the standard. It's right there. And there's sub-indicators, there's criteria, there's verifiers there, because I've been hearing, well, what are the steps, what are the codes? It's right there from the forest sector. There's a set of answers for you there in the Forest Stewardship Council that you'll find. But again, that to me is just a reflection, a codification. Our colleague who has been operating at the UN Permanent Forum for Indigenous Peoples for many years, she spoke last night about the process there. There's the high principle and position that we have as Indigenous people, wanting to maintain ourselves, and then converting it into legal language, standards language, principles language. You'll definitely find that in the FSC system as well. But I would say with this system, you'll find it very clearly stated. Free, prior, and informed consent is right there. And there's a bunch of sub-articles there. I can get into that in terms of questions. But again, it's just a reflection. To me, it's just a shadow of really community will on the land. And to me, in the forest, communities, First Nations, they have to really think about their will to maintain themselves. If they have a will to maintain themselves in their homelands, then they're going to need a strategy to do it. If you have a strategy, then you're going to need tactics. And this is where, well, where do you deploy tactics then? Well, you have to have a conceptualization of this, and this is where you're searching for interim accommodations. You're blocking, you're tackling, you're moving things forward, and there's going to be projects, natural resource development on homelands. This is where a lot of these interim accommodations in terms of searching for a unique crystallization of FPIC will come through. Now in the forest sector, interim accommodation has been crystallized over time into two main streams. Forest management and forest equity and control. So basically, people who just want have agreed to say, okay, well, we'll put up with some level of forest management. We're not going to be loggers. We're not going to be tree planters, but we just want it done. We want it done better. And so that's one big bucket of engagement in the forest that you have. Basically, First Nations, Indigenous people wanting to maintain themselves, but having the space to do it on their forest homelands. So that's one big bucket in terms of FPIC processes in the forest. The other big bucket is in the forest sector, equity and control. And this is where First Nations have moved up the value chain, and they've actually bought out companies. They've actually taken the tenure under their control legally, economically. They own the forest management company. They own the general management company that does the forest management. They own all the companies that do the subcontracting on their forest landscape. And now many are starting to buy out the fiber transformation facilities on their homelands. They're owning the companies that build these beautiful products out of wood and are marketing them. And this is where the FSC system, but other market certification systems are very important, because we have a choice as consumers to also support social justice in the marketplace as well. And so that is, I guess, the forest sector's approach to FPIC. There's a lot of richness there. There's a lot of history there. I don't have time to get into too much more detail on that. But FPIC should be seen throughout and should be recognized throughout that you will always hear free, prior, and informed consent in community meetings. Not only with a non-Indigenous operation, but also for now that there's some advanced level of development under Indigenous control for within the actual community itself. So grassroots members know that it's just, we just haven't taken control of business, and, now we're the big bosses and we're going to do what we want, and there's no, there's no governor on our operational ability. That's not the case. There's FPIC internally as well within our communities. To close off the talk, because I've been given the shepherd's crook, but I think it's the end of the afternoon, and I'm going to take a little bit of license here, Craig. I'm going to talk about the Lords of McDonald's. And I'm going to talk about, connect it back with this Chief Ed. Chief Ed is now Grand Chief Edward John of the BC First Nations Summit. And you see the vision that leaders like this have, chiefs, men, women, elders, because it was elders and communities that pushed him to do that. They said, we want a vision for our young people, for a better future on their land base. And they pushed them. And what they were trying to create, in my mind, what I've heard when I've sat in those meetings, is they were trying to create Lords of McDonald's. Now let me explain this to you. There is a community in northern Saskatchewan, actually 9 communities. And it can be done, so that's why I'm saying you can take control of your forest and you can control the regional economy. A group of 9 communities, Cree, Dene, but also Métis communities that have worked together, mainly through the Meadow Lake Tribal Council, but now through the forest business complex that they own and operate, beginning with Mystic Forest Management, and their sawmill that they own, North Sask Forest Products, and with the dozens of other businesses that they've taken the retained earnings from their mill and they have bought out bit by bit around them, controlling their destiny. And what does that come to? What does that free, prior, and informed consent of saying we're going to be the ones to control our destiny in our regional economy? Did it mean that they pushed out all the non-Indigenous settlers and they kicked everybody out? No. It means that the wealth that is generated in these regions where Indigenous peoples are the rightful owners in the business equity and in the management of these regions, it means that that wealth will stay in that region. You can go into the McDonald's at Meadow Lake, Saskatchewan, and you will see these beautiful First Nations boys and girls come in at lunch. They're not coming in with torn up clothes, snotty noses, clearly in some level of dysfunction. That's not what they come in as. They come in well dressed. They come in carrying themselves with pride. They come in with an identity that they're on their land and that their moms and their dads are in control. And they're very respectful. But you can feel that strength when they come in there. And that's what I'm talking about with free, prior, and informed consent through the forest. It began with an idea You know, sometimes our leaders, you get a good idea and you get creative. It can be done. I want to encourage the leadership in the room. It can be done and you can get there. Now, the reason why there are lords of McDonald's there in Meadow Lake, Saskatchewan, is because now at the mill that they have, they're going towards a majority of First Nations employment in that mill, and it's a lot of First Nations women. Union jobs, high-paying jobs in manufacturing. And those resources are going into the home fires of those communities. And I guess in the socio-political, socio-economic conceptualization, they're middle class to upper middle class because of the earning power of their parents. But to me, it's more spiritual. It's having your parents and knowing that you're leaders and knowing that you are getting up and you're helping build your destiny on your land base. That's what if free, prior, and informed consent is somehow translated through the forest sector in your home territory. And chances are, if you're First Nations, you're in the bush. I'm from the bush, OCN, Opaskaya Cree Nation. I'm from the middle of the bush. And that's what I want for my kids. I want my kids to have that identity, to know that we are speaking for, we're managing, we're developing my homeland. And the benefits are staying in my traditional territory, not just for us, but for the whole regional economy. So that doesn't get siphoned off to New York, doesn't get siphoned off to London, doesn't get siphoned off to Bay Street. No offense, Canadians. That money stays in the rural heartland that is Canada. That's the vision there. Now, why is this important? While connecting it to the political dialogues of the day. Oshkosh Bagosh. A lot of people have heard that. It's a brand, it's a clothing brand now. But Oshkosh, Chief Oshkosh, is one of the formative chiefs of the Menominee tribe in upstate Wisconsin. And the white paper came from a number of ideas. I'm going to connect this directly here. There was a trial run with the white paper, and it was successful. It was successful in the States. It's called the Indian Reorganization Act. And at the sign of a pen, the federal government white papered, was successful legally, totally white papered over all of the American tribe rights for a number of tribes. They were just disenfranchised overnight with a stroke of a pen, with a, I don't know what president, I think it might have been President Kennedy signed it. Well, the Menominees had been operating a little sawmill since 1905 on their territory. And with their retained earnings from their sawmill in upstate Wisconsin, they hired lawyers. They hired lobbyists. They employed families so that the disenfranchisement that happened with a lot of tribes that were reorganized in the states was countervailed. They weren't successful 100%, but they were successful enough as a mill to retain the core of the leadership and the employment strength of the Menominee people. And they fought, finally, to the point under President Nixon where they got the Indian Reorganization Act reversed. And that's why the forest sector is very important for the First Nations leaders in this room to take control of and to own. Because if you think about some of the stories, some of the things that have been put forward on policy tables for our leaders to consider, for our rights to go away, for our membership codes to be watered down, for our people to go away into the wind like leaves on a fall day, blown away. You think about what's still there. It's that tree. It's that forest. And I think that's the story that I would like to close my presentation with, is that free, prior, and informed consent is there with the Menominee Tribal Enterprises, with the Menominee Tribe in the States. It's there with the Meadow Lake Tribal Council. It's there in the interior of BC with Nakadzli, with all the tribes that have an ownership stake in Conifex. It's there with other nations that are making those steps incrementally, using FPIC as a leverage to move up the value chain. I'm going to encourage the First Nations online but in the room to keep up with your good ways and to put a chip down for Chief Roger and sing him a congratulations song. We got to do that. Some of you Anishinaabe leaders out there, you guys got to sing him in too. He can't just always come in and sing to us. We got to sing to him too. And I want to thank all the other speakers. It's been a pleasure to speak with you all today. Hopefully I've provided some level of energy, I guess, in the late hours of the afternoon, Craig. And I look forward to taking questions and interacting with the rest of the room and also our participants online. Thank you very much.
Thanks a lot. Good thing about the way the day is organized is we do have a good amount of time reserved for questions and further interaction. We are going to ask Lorraine Land and Anne-Marie Sam to give us brief remarks to help connect some of the previous discussion of the day right through to what we just heard from Bradley Young, and then we'll open the floor to some discussion. And we've also, through the day, we've been collecting a lot of unanswered questions that have come into us through the online chat, through Twitter, and we're going to put some of those questions to our panel as well. And like I say, really focus on the practical details of how to achieve the kind of free, prior, and informed consent we've been hearing about. So I'll start with, I think, with Lorraine Land, if that's all right.
Sure. Okay, so I wasn't quite sure what was entailed in being on this final panel, so I've been trying to think throughout the day of some of the themes that I've heard emerging repeatedly, or where some of the direction of the discussion is going. And so I'm just going to throw out in no particular order some of the things that I've been hearing in terms of key themes. So, and these probably reflect some of my own biases as a lawyer, but let me just start. So one of the intriguing questions I think that came up in this morning's discussions and has kind of reiterated in different ways throughout the day, not so much in the most recent panel, but the question that John Merritt asked, which is who is the self and self-determination? He related it back to Daly's comments this morning. So there have been a number of questions and discussions, and then also sidebar discussions that I've overheard about. So when you talk about Indigenous consent, then who is doing the consenting? Who are the parties that industry, that government needs to engage with? It's a complex issue, as Daly pointed out in the Greenland example with uranium mining, where you have a disconnect between some people at the local level and the political leadership. So who is the self and self-determination, I think, is one of the issues that is a key issue that we need to wrestle with in terms of understanding practically how FPIC rolls out and how we support robust FPIC processes, because that can be actually a fairly complex question. One of the another interesting theme, I think, that was emerging in different ways, both in last night's comments and today's, was I heard some of the Aboriginal speakers talking in their language about how they translated the word consent. How did they understand the notion of consent? What was the word in their own language? Chief Williams talked about that last night and today. John Cutfeet spoke about that very eloquently today as well, trying to articulate in their languages what is consent. And what the theme seemed to be was this notion of sheltering, that consent from the perspective of their languages, and recognizing that that doesn't translate necessarily into English very well, or even into Canadian cultural conceptual frameworks. But the notion that I was hearing was a consent as the notion of sheltering, the person who has the authority to offer you shelter, who takes you in. It's fundamentally relational. It's the person who has the authority to bring you into relationship with the place that you're in, with the people that you are with. And I think it's interesting because I think it points out to the fact that there are these fundamentally different cultural constructs, but I also think it points out that one of the challenges that we face is trying to envision more embodied notions of consent. What does consent really mean, as much as it's possible to articulate that from an Anishinaabe perspective or a Cree perspective or a Mohawk perspective? And I think that is so essential, because that's the way in which we'll actually understand what the process requires. It's by trying to articulate what the cultural understanding is on the Aboriginal side that we begin to have some understanding of what the just process is. Another repeated theme I heard several times was Anne-Marie brought this up, and it also came up in the panel on business responsibility, is the gender component of FPIC. There's interesting intersections there at the domestic and at the international level. Another thing that I heard coming up repeatedly was people talking about how they are developing the capacity to deal with consent, like in terms of the internal processes and protocols. So, for instance, again, John Cutfeet talking about the protocol that Kitchener-Wadsub and Innuig have with the different processes, stages in their process, including their ratification process, where the community ratifies what is being consented to. It came up in different points from different speakers. I think Anne-Marie talked about it too, the internal processes within communities. And then finally, I'd say one other thing that I guess this also relates to that notion of what is the Aboriginal perception or understanding of consent. I think Chief Sayers made a really important point, which is we need to be cognizant of the fact that we're not just talking about what is international law saying, what is the force of international law, what is Canadian law saying, what is the force or authority of the Canadian law, but it's also what is Anishinaabe law saying, what is Mohawk law saying, what is Cree law saying. So it's about also the relationship between these legal systems. And I think it also points to an interesting direction in Canada, where actually we're talking about, in some ways, the recognition of a pluralism of legal systems. We recognize already we have a common law and a civil law system. This is a great place to have that discussion here at University of Ottawa. But there is this third trench of law in Canada, which is Indigenous legal traditions that have force, that are customary law, that we need to recognize as having robust aspects in terms of both understanding norms, but also, for instance, what is appropriate for enforcement. What can communities do when it's appropriate or necessary to enforce the need for consent? Then I think it's appropriate to look to those Indigenous legal traditions to figure that out. So those are just some thoughts about some of the themes that I heard emerging.
All right, so this is on. Thank you, Brad, for starting us off in this last panel, the energy that you brought, and the reminder and the connection to our family, the trees. Like where I'm from, we have a story about the time when the trees used to walk with us, and how important they are to our people. And I always loved hearing that story. One of our elders would tell and talk how the trees got their bark because of how they were acting out in the forest one day, and then the Creator said, okay, now you have to stay put in your certain areas. When I have more time, I could tell that story. So this was an amazing day today, the information that we heard and we collected. And I guess for me, I just wanted to share what I see, and I didn't get a chance to put that forward so much in my talk, but what's happening out there to show that Indigenous communities are ready and can take up the call of our responsibility to Mother Earth, and to do things that are to ensure that our future generations are able to live off the land and to live with the land and with the water and with the animals like we have. I mean, the pictures I had showed earlier of my daughter and then the land devastated is heartbreak. That's heartbreaking. That's our reality. But I didn't get a chance to say what we are doing. Like that's not the end of the story. They might have got it wrong, they might have not followed FPIC, but we're still there, and we still have to keep our connection to the land. And I felt really that it was important that we keep that connection no matter what. And so 2 weeks ago, we went out onto the mine site, and Craig was able to join us. And Hugo Lapointe from Mining Watch Canada also joined us. And we put tobacco down and had a ceremony on each of the 4 corners of the mine site. And a surprise to have a lot of the staff from the mine come out and join us for this. But for me, praying for their safety, we're taught that we're only supposed to take what we need, and the mine takes so much from the earth. And we wanted to ask for that protection for the workers who are there, to provide for their families also. And we realized that. Also, as we were driving by the mine site, through the mine site, we went by the tailings pond, and my heart dropped when I saw that the tailings was starting to cover trees that they just left in the tailings pond and didn't log out. And it reminded me of that story of the trees once walked with us and our people just like us, and we should be respecting them, and how disrespectful it was to see that the company had decided to just let the trees stand there and start covering them up with tailings pond, with the tailings sludge that comes out from the mine. So that's for us. I just wanted to share that we are keeping our connection to that area. My daughter's gonna know that area. She didn't get to go on the ceremony this year, and she was very disappointed because she was in Vancouver and I was in Fort St. James. And but next year they both will be there. It's important that we not lose that connection. I also wanted to mention, and just what I heard is the importance of the traditional governance and the importance of acknowledging our hereditary chiefs and where we come from. Also, we have KO. It's the land you grow up on. It's what provides you what you need out on the land. And in our area, every family had a KO that they would go to. And the need for communities to be able to just have those tough discussions and to sit down and say, what is our priority and what are our fears, and to be able to find a way to work together. They're out there, I know in our community, there is distrust for leadership. I'm on council, and I think that it's not about council and Indian Act and that system versus traditional system. I grew up in both systems, and how that's my reality that I know, and how do we work together for the benefit and the best interests of our community as a whole. And so that's something I think our communities have to figure out in that internal process that Lorraine had mentioned. Some examples in our communities that of what is going on. Some of you might have heard of the Save the Fraser Declaration that was established by the Yinka Dene Alliance. And this was a group of communities around the Prince George, Fraser Lake, Fort St. James area that opposed the development of Enbridge, Northern Gateway oil and condensate pipeline from Alberta to the West Coast. And we were willing to stand up and say that this is a direct threat to our way of life, and we do not accept this project in our territory. And so if you look up Yinka Dene Alliance and Save the Fraser Declaration, we were able to go up to the Northwest Territories, to Alberta, to all over British Columbia to gain support that we want to save the Fraser and we want to protect this for the salmon and for clean drinking water. And the election in Alberta a couple weeks ago, one of the things we have to follow up with the new premier is that her campaign was that she didn't think Northern Gateway was an economically viable project, and that was not her priority. So we want to make sure she follows through on that. And the other things communities are doing are the declarations, water declarations, like John had mentioned. Also in the Chilcotin area, Roger, they have I don't know if it's a Honeygoteen declaration or if it's but in their community, they've a declaration of how things will happen in their area and setting up those policies and putting them in place and spending the time in the community of what the priorities are. They've also developed a tribal park on the area that Prosperity Mine was proposed is now a tribal park. And that's it, that I think there should be more tribal parks and communities should be supported in that and not be seen as against development, but as a way to protect the land and our connection to the land. When you live in the city, I see, this year I've lived in Vancouver. I've gone to school at UBC. I spent a lot of time with engineers that are just so smart, like just these smart students that are going to be building things in the future. But I couldn't help but just feel the disconnect from community, the disconnect of that, yeah, they might be really good at building dams or building buildings or making projects. But it comes back to what does the community want and what are the priorities for the community, and having the community at the table to be able to say that this is where we accept economic development, this is where we want logging, this is where we're protecting this area for water conservation. Those land use plans are so important for communities, and a lot of communities are doing that. And to be able to respect the communities that are willing to stand up and say that. And last week was, I don't know if, I'm sure you heard that on the CBC News that the First Nations coastal group in the Prince Rupert area turned down $1 billion offer to allow an LNG project. And my hands go up to that community because that's a tough thing. I'm sure that was a tough thing to do. But then on the other side, I heard them saying it wasn't a tough thing because they wanted to protect the waters and they felt that was their responsibility to say no to this project. And we need to have more communities not be in that crunch of economics that we have to take the money and not protect the environment. We have to find a way that we could develop our economies and develop our communities without one over the other. And so communities are taking that step and doing that through a number of ways, through tribal parks or turn into tourism. And what I like about this next thing, I think I'll end on too. Sorry, I'm taking so much time. I just get very energetic about talking about what our communities are doing. And this program is in BC. There might be some projects in I know in Northwest Territories they're starting up, but it's a Guardian program or a Watchman program, or so there's the Coastal Guardian program. These projects started in Australia, where it was the Indigenous people that were out on the land, and and they are gathering information, collecting data, watching for invasive species, tagging fish or animals, and are being the conservation people out on the land, on their land, and they're protecting it, and they are setting the rules, and they're setting the priorities. And in BC, for a number of years, we were focusing on changing the laws and mining reform. And after spending some time with the communities from Australia and spending time with communities that have these programs, like the Haida have for years had the Haida Watchman program, and just seeing how that has developed into more capacity in the community to, in the Haida, they might have started out as protecting only the park area and being involved with a park that was in their territory, to now their whole territory and having title and willing to go to court for a title to their whole area. And so this program and these types of programs, I think if every community could develop that, not only is it developing capacity, but it's connecting people to the land, it's collecting that data that needs to be out there and keeping people connected to the land, which is, I think, so important. And I guess I'll end on this, that with FPIC, it's not, I heard a few times people saying it's not about bringing something new to the community. It's not about what can FPIC do for our community. It's about connecting for our communities, continuing and keeping that connection to the land, to the water, to the territory, to our language. Because on this land is our stories, our history, our identity is on the land. And that's where FPIC is, you breathe life into it, is when you continue doing what you've always done. And so I'll end there. Thank you.
Thank you, Anne. Before going to any questions in the room, we had a number of outstanding questions that had come in over the course of the day, and we want to. We're going to start first with the questions that were outstanding. Lorraine, in your summary, you flagged one of the things that people have been asking about through the day, and which I think deserves some more discussion, which is the question of who gets to give consent, and especially given some of the factors which all of you have raised, and which others have raised, factors such as how are the voices of Indigenous women going to be heard, how to deal with the coexistence of traditional and elected forms of government, how to deal with other forms of division in the community. What are the best practices? What are the best models for addressing, who gives consent? And maybe the other side of that is, are there situations in which the question of consent shouldn't even be asked, where it's not appropriate to be putting First Nation into the position of having to say yes or no when there are other issues to be dealt with first? Maybe just in order to ask Bradley first.
That's a big question. So I want to make sure that I'm answering the right component of it. So the internal process of who is it right to ask for consent, and then the process, the internal process. What are some of the parameters that you would want clarity on? Yeah, that's okay. So I guess I'll approach it from the second part of the question of who to ask consent for. What I've seen in communities that do FPIC process as well, I mean, they would never call it an FPIC process, first off, right? Most of these communities that come to some level of understanding, a common vision, will have an Indigenous terminology for bringing together the community voice, and it's usually led in part by formal leadership, chief and council. That's one aspect of this. But I think broader than that, the ethical mandate and the spiritual mandate comes from the elders and the men and the women, the youth, that will be involved with the leadership through I guess, ongoing debate, ongoing discussion around, I guess, the political lifeblood of that community. What are the major issues there? To come to a community and just expect an FPIC answer, right? I think that is the wrong approach for an industry proponent to take, for another society to take, frankly. I think what is really has to be in order for FPIC to really be a fruitful engagement on both sides and a real engagement that you can have a meeting of the minds is you have to have an upper level relationship between the different polities that are initiating the discussions. And I think that is probably where there is some of the more pressing challenges in Canada right now, given some of the rancor around FPIC discussions and some of the fear. Again, returning it to the forest area, not that there are not active areas where there is conflict with First Nations in the forest, there are. But I think by and large, if you look at it from a national perspective, you see as a group, you see a long-standing relationship for First Nations in the forest. You know, logging initially, tree planting through time, understanding some of the forest management techniques that are necessary in today's world, and then having that mature kind of rationalization for a lot of First Nations in the forest where the traditional lifestyle is going to be there. It has to be there as a bedrock. That changes in terms of impact and ability for the community with numbers. And what I'm talking about is when I was born in Opaskwayak Cree Nation, well, we'll go to my dad. When my dad was born in the Opaskwayak Cree Nation, his band number was 911, right? And now that my children, I have 4 children, are registered, we're in the 7,000s, the upper 7,000s. And so what we're talking about is a long-standing relationship with our land base and a long-standing understanding of through our chief and councils, but also through the community, understanding that our relationship with the land base is going to change over time with the vision that's going to come from the people. So I think a long-winded answer there. I think you have to have a longer-term relationship scope for industry proponents. And maybe that's where some of the industry associations at an upper level have to get creative. So it's not always just driven by an industry-specific project, right? Because there are industry associations across all the sectors. Maybe that's where some of the upper level relationships have to happen with our political leadership in the communities. And I think also, the federal and provincial governments have a very important role on that side, legally, symbolically, regulatory-wise. I think there is an upper level relationship that has to be figured out. And I think, Canadians are a pretty innovative bunch. They're pretty socially justice-minded, and I think we can figure it out as a society.
I'll just add a couple of comments. I won't repeat your excellent comments. I think in my mind, the first starting point is if you're asking who gives consent, it's up to the Indigenous group to decide who. And that's going to vary incredibly across the country. There's such diversities in not just cultures, but practically what communities are doing. The way you understand that is by having a relationship with the community, which I think takes us back to the whole issue about, at its core, consent is all about the relationships that get built, because you don't get to know who's the proper consent giver unless you have the relationship. That being said, of course, you want to be able to articulate some norms, and particularly senior levels of political engagement, for instance. But I also think a core issue here, just to take it back to comments that Anne-Marie was making and John Cutfeet and others, is they were talking about, and Chief Roger, they were talking about what are the processes happening internally within their communities, because consent isn't only about the state or the industry going to political leadership. It's also about what's happening internally within the communities to understand where the nexus of consent is, like what the issues are, what's going to matter to people, what needs to happen. And to do that, you need to have capacity. And that's where that's one of the biggest issues. Also in terms of, we have this very flawed Aboriginal consultation process in Canada right now. One of the hugest issues is the capacity of communities to deal with being inundated with engagement requests, but also to deal with taking stuff back into their communities to get flow the information and make the communities fully part of the decision-making process. That takes capacity, both human capacity, but frankly also resources, and I think that's part of the equation.
Is this on? I think all I would add is in our area, it is the internal process. We have the KO system as our governance, on the land, but we also have a clan system, and you're born into your mother's clan, so what we're dealing with in Nakasley is 5 proposed LNG pipelines through our territory, and I mean, that's on top of Enbridge and all the mining and forestry. And so last summer, what we did to try a different sense of wasn't going to be just council decision. This wasn't just going to be the KO holders who are directly impacted. We first asked the clans to call their clan members together and to have a meeting. And then the clans would come to an all clans meeting and present what they felt was the proper route to go. And that information then was shared with chief and council. And it was, for me, being on council and being part of a clan and being a KO holder, you try and be respectful of everybody that's at the table, and not that one is above the other, but we're working together, trying to find a way that the communities could work together, and that just one example of what we did in our area. So it's up to the community.
Thank you. There are 2 other questions that have been outstanding since the morning that I want to put to the panel, and then we'll open it up to the floor here. There was actually a number of questions that came in around the environmental impact assessment process. Anne told us this morning about the experience at Nakasley, where an environmental impact assessment, the fact that the people in Nakasley had not given their consent was not considered and didn't affect the outcome. Chief Roger William from the Sokoteen referred to the New Prosperity Mine process, which did acknowledge the fact that they hadn't given their consent, and that was factored into the review. And eventually the government made the decision to not give license to that mine. What's the sense of you as members of the panel of whether the environmental assessment process, for all of its weaknesses or limitations, is this a place that free, prior, and informed consent can be realized, and how, any advice or thoughts on that?
Environmental assessment. So I think there's the environmental assessment process is good at getting info out on the table, is to bring things up and bring experts and people together. What I find in BC anyways is the lack of monitoring and on those commitments, or following up on the commitments that have been made in the certificate. And also what we realized in the EA process in BC was it really was as important as the environment is to us. It was really lacking on the impacts that were directly happening to our communities, and that was why the need for doing a health social impact assessment. And just to give you an example of to figure out where our community was, we needed to do a baseline assessment on community health, and we came up with 9 themes that is outlined in our research project. And so the loss of land came up, increase in industrial traffic, extent of migration or transient workers coming into our area, loss of access to housing, increase in rents, increase in impact on local medical resources, increased vulnerability for women and youth, increased crime, impact on employment and income for local residents, and availability of education and training for local residents. So I just outlined those as those are what came up when we sat in our community with our, and this is not just Nakasley, this was our neighboring community, also First Nation Glasden, where Ed John is from, and the town of Fort St. James and the service providers there, and we came up with this list. The environmental assessment process only looked at and said they'd monitor traffic issues. They would monitor availability of education and training. And I think there was one more list. So out of this list of 9 that was important for our community, the EA looked at maybe 3 issues on there. So it just reminds me of, I was at a meeting in Winnipeg on SIA, so the Canadian Environmental Assessment Process, and the worker that was there was just say, he was saying, we're not here to protect the environment. We're here to make sure that we could say this is how the decision was made. And I said, say that again. SIA is not there to protect the environment. You only are there to make sure that a process was in place so that a decision could be made. And if that's what environmental assessment is about, I don't know if that person is still there. I don't even remember the name of the person, but it's just it's lacking a lot of information, and it's also a process that is imposed on communities, and really, in BC especially, needs some reforming and needs more First Nations or community input into how it's done.
Thanks. I think I'd just pick up on that and add 3 quick comments. The first is that environmental assessment processes can't fulfill the totality of the role of obtaining free, prior, and informed consent for a couple reasons. Is that they are inherently limited. They don't deal with Indigenous rights per se. But also there's the very practical consideration that the environmental assessment processes in Canada have been gutted over the last 15 years. And even at the time of the Haida decision, and particularly the accompanying Taku River Tlingit decision, the Supreme Court talks about how the process during environmental assessment can be used to fulfill parts or aspects of, particularly procedural aspects of the duty to consult. Well, that was a whole different environmental assessment regime. Flawed as it was, it's a lot better than what exists now, which has been completely gutted. Many fewer triggers for environmental assessment, far less robust processes. So there's no way that environmental assessment processes can often deal with, particularly in the case of serious developments, the range or scope of issues that Indigenous communities who are affected may have in the process. And that's why I think there's something that's been happening that I think is an untold story in Canada, is that I think that Aboriginal people are now in the position where they have to go to the courts, spend the money and the time to enforce their Aboriginal rights to consultation and accommodation, basically as a proxy for protecting the environmental rights of all Canadians. So the financial burden, the political burden, the social burden of protecting the environment for all of us is increasingly falling on the backs of First Nations. That is fundamentally unjust and unethical. And one of the things that you see as a practical result is often when there are large development projects and there have been environmental assessment processes, you will also have impact benefits or other agreements between the Aboriginal groups who are affected and industry. And I have yet to be in an IBA or agreement process like that has not included robust environmental conditions that are on top of what the Canadian regulatory regime requires. They almost always require additional environmental monitoring, reporting, impact mitigation measurements. Why should First Nations bear the burden for that? That's our common civil responsibility. I think it's an untold story that we need to be paying attention to, and I think it's the story that, of course, was at the root of Idle No More. That's how Idle No More started, if you remember. It was about the pushback to the gutting of the environmental legislation and the omnibus legislation in 2012 and 2013.
Real quick, I think Anne Marie and Lorraine, they answered in really good detail there. I would just add that an EIA, but any process to me, I would guide and remind First Nations to just use these various processes as just another tool. It's just another tool. It's another site of engagement where you can assert your community's vision, your First Nations visions for how you want that land base to be respected, right? And so there's some prior work that should be done for any First Nation before going into these processes, right? They could help, in like Anne Marie's case, they can help with helping pull together documentation or responding to certain areas of the traditional land use area. But there should be some hard work for any First Nation that's done prior to going into there, and to manage the expectations of what you're going to be getting out of it. So that's my addition to the answer.
Great, thank you. And just one last question that we had promised to put to the panel on behalf of some of our online participants, and that was to go beyond the issues of land and resources. I think there's very good reasons why people have focused today very much on land and resources and territory. But the question was whether free, prior, and informed consent, whether there are examples of free, prior, and informed consent being applied in other arena, in policy and legislation, and where you think some of the priorities might be.
It's a vast area, free, prior, and informed consent. I mean, almost, if you take what is in UNDRIP, I mean, all the articles, the 40, 50 articles in there, it covers all areas of kind of Indigenous existence in every kind of policy area, from child raising to education to health policy, which again would be my gentle kind of and modest push for leaders in government, all governments in our First Nations, to really get to work on those upper level relationships. Because if communities, I mean, expecting communities to be able to put up with 3,000 FPIC processes on everything, right, I think is a little much to be asking. So those upper level relationships and processes are really, really important. And I think there's some very reasonable voices and solutions and that First Nations leadership and community members, elders, grassroots activists, the legal technicians have to support that process.
That's fine. All right.
I would just say one other good example would be cultural protections in terms of sacred sites, burial sites, repatriation of cultural objects. That's an area where, interesting, there's not, from a lawyer's perspective, there's not a lot of good Canadian case law on Aboriginal rights from a Canadian law perspective as it pertains to cultural sites, cultural objects, and so on. That's probably because it's just a no-brainer. It makes sense that when you hit conflicts that people don't try to push the issue because they know how important it is to Indigenous communities. But I think that's an area where there's interesting examples of consent processes that are evolving, that are kind of happening in interesting ways that are kind of around the periphery of the law, because people are just getting on with it and doing things in a practical way, because the law itself is not of assistance, both legislation or the common law.
Thank you, Lorraine. And thank you to the people who've been participating online. If there's time, we'll come back and check if there's been additional questions come in online. But we have only, I'd say, about 15 minutes left, stretching the limits of hospitality here a little bit at the university. So I ask that questions from the floor be very short, and people to minimize statements and focus on questions, please.
Yes, thank you. I'm really quite troubled in lots of the things that I'm hearing. I'm pleased to be here. I'm pleased to see such a forum, and I hope there's more of it. However, I would like to ask you, did you know that what we achieved on March 15th and 16th, 1983, we were formally recognized as a sovereign people? How can a sovereign people continue to do be sovereign by taking on the master's identity. I'm hearing about free and prior consent and informed consent. I'm pleased to hear that, because the Supreme Court judges, I believe, looked at the treaty and saw that we are a sovereign. I want to just remind you two things. One, your bill, what the President of the National Indian Brotherhood said when he first heard of the 1969 White Paper policy, and this is a good Mohawk man, Walter Dieter. This is exactly what he said in 4 lines. We view this policy as a design to divest us of our Aboriginal, residential, and statutory rights. If we accept this policy and in process lose our rights, our lands, we become willing partners in cultural genocide. This we cannot do. Is that what you want to do? I hope not. Now,
Okay, sorry,
Point
was
of
that your
order.
question?
What is the question, Hector? Come on,
I'm asking
man.
you, did you know
There's
that
a
you
lot
are
of
participating and building a paper house?
Hector.
I'd like, please let you spoke for a while. Please allow me.
I know.
quick
Wait a
minute.
second. We come from the First Nations world, Hector, and like for some of the leaders in the room and some of those that come from our world, we're used to the 10-minute question from the band floor, you know, for the council on the floor. So we get that, you know. Those of us who are First Nations working in our milieu, you know, there's an expectation to ask a question for us that's topical, on point here for the content of the panelists, to respect each other. I think that's above board. So please, Hector, ask us a question on what we are discussing, and we will try and respectfully answer. That's just a point of order that I'm asking for.
Well, thank you very much, and I'll do my best to comply with it. Now, did you know, I'm asking you a question, did you know, I'm taking this from the Consolidation of New Brunswick Indian Reserve Agreement Act. Now, I'm going to give you a definition what the lawyers representing the Justice Department in New Brunswick said. Did you know? This is the definition that they gave to First Nations. A term that came into usage in 1970s to replace the word Indian refers to both status and non-status. The term has no legal standings. Why would you want to use a term that has no legal standings when we put in place in 1983 you as a sovereign? Why would you want to do that?
I think, Hector, I'm going to jump in here and just say it's a little bit of a point of order. I think we're getting into some very theoretical and principled kind of discussions on constitution, matters of sovereignty. Look, I grew up listening to my grandfathers, my fathers, my uncles. I don't know how many times I sat at their knees and went over and discussed these matters in a very, very high level in our language, Neheyawian, going through these issues. I just think it's the question is a little bit disingenuous in terms of what we're talking about, getting into the details of free, prior, and informed consent. So I don't know what the question is for the panel. If we know, do we know about the word sovereign? Do we know about what has happened in detail in your neck of the woods? I can't say that. I can't say that I know.
Please, John, I didn't say that. I said this is happening nationally.
Okay. All right. Yes. Mr. Victor, thank you for speaking, but I want to give time to somebody else now.
Miigwech waje greetings. Kagashe hawt en dagos the shinhason maskonato dem. Iu sko gomaga mashke go nina atopsket dochendochin gomaga geshe sibich. Jocelyn the shinhason Ottawa the shitashihan. My spirit name is the one who behaves elderly. I'm from the Bear Clan. I'm Mashkego Niu Cree from Attawapiskat First Nation, and my father is from Jasasibi, Quebec. And my colonial name is Jocelyn Ayatel, and I live here in Ottawa. Please bear with me. I wanted to speak about the interconnection of violence against Ogawi Mawaski, Mother Earth, and violence against our women and our children. I'm a survivor of missing and murdered Indigenous women and girls. My daughter passed in 2001, and I live with that daily. I'm also an intergenerational child warfare genocide survivor. The war conflicts of Indian Residential School, 60 Scoop, Indian Day School, and this current Millennium Scoop, which we know the Indian Residential School has been perfected in a holistic way. I'm also, being from the Attawapiskat First Nation, De Beers is mining our diamonds, the Victor project, and now the new development of Tango. We're also experiencing the onslaught of Noront, Ring of Fire project. And the traditional territory of our lands, which we know is a living spirit of Wokawimau. And I wanted to speak about the indigeneity and the indigenous perspective, the interconnection and the focus on the whole picture, which we know is Waskabamatasuan, circle way of living and circle way of being. This is our natural law. We speak about the holistic impacts, which is very contrary to hierarchical, the triangle, the box, and the linear. And that these are therefore colonialism and our people replicating colonialism. In our language and culture, there are many non-existent concepts. Our code and natural laws of our mores, our ethics, and our values.
Jocelyn, I hate to interrupt you, but it looks like you have a long presentation there that you're reading from.
It's not, it's big writing. When my Mushum, my Jaban, Jacob Ayatel signed our treaty, you know, I need to point out that in our language, there is no child welfare policy in our language. That child welfare concept is foreign and imported. He never signed away our children. He never signed away our lands or our resources. And yet, with the intergenerational child warfare genocide, our children are dying still to this day. Nearly 800 children have died in Alberta alone. That there's holistic injuries and that the displacement issues are ongoing. Our identity is under attack. Our children's organs are being harvested in Alberta. And the parental and community alienation continues, and the failure to protect our people. There is a failure to provide remedies that are Indigenous knowledge-based. We do know that the abductions of our children are based on poverty and neglect, meaning little or no money resources needed for adequate child rearing, and homelessness. Yet the resources are being extracted from our First Nations.
Could you, I think our panelists, I think that most of our guests here understand the context.
Yes.
Could you move to the question?
I am asking, how can we address adequately the gender impacts due to resource extraction by mining? I need for the panel to acknowledge and the community to acknowledge and validate, actively engage in addressing and eliminating misogyny. We need a strong focus on engaging our women at every level and every phase. FPIC must be holistic, Indigenous knowledge-based, with verifiable consultation and consent based on Waskapamatasuan. We need a grassroots balanced representation to address the adopted patriarchal and colonial system currently utilized by some of our people. Monies such as resource revenue sharing, impact benefit agreement, to address the economic violence of inadequate access to benefit monies and collective monies. There needs to be direct resource payments to our women and our vulnerable members. The independent assessor and report on record of human rights of our projects within our own Indigenous communities needs to take place. The gender justice needs to be part of FPIC. Failure to protect our people means all of us, federal, provincial, and Indigenous governance. It is time, as Wabano, the teaching of our stories. There has been holistic violence that's been part of my story. And my story is going to be different from here on. We are going to take this full circle and turn these losses and pains to gifts and medicine bundles. Beginning today, by me sharing my sacred story, I am including you, humanity, our collective spirits, to share in the responsibility to address the inhumanity and learn to base free, prior, and informed consent based on love and respect. Miigwech.
Thank you. There were two other people, I think, who were standing up for...
I'll sit if you don't mind. It's a question that picks up on, Lorraine, what you were mentioning in one of your responses the need, you were saying who gives the consent? It's up to the community to decide. And you're also sort of stressing the need to locate what you were calling the nexus of consent internally within a community. And I guess in a way, this is also a question for Daley, in particular because of sort of the stress on what I think is a hugely important and interesting question of who is the self in self-determination, and the notion of narratives, the importance of, you know, the stories we tell about ourselves and shaping who these selves are. And I guess to me, I mean, listening to the panels today, it's quite obvious there's a, you know, the answer to that, there's a whole multiplicity of meetings. First of all, there's a massive diversity of people, but even more importantly, identity is actually never fixed. It's not a stable, frozen thing, it's fluid. And so my question then is, in that fluidity of identity, is there a vulnerability that concerns you? And I'm referring in particular to what I've witnessed as the real politic of FPIC. In my work is more in Central America, but I've seen many initiatives of Canadian mining companies over the past 10 years sponsoring initiatives that encourage people to consider themselves indigenous and to combine that identity in a way that embraces the model of development exactly the way it's being proposed by the mining company. Not at all in the way that Bradley was talking about, like full ownership of all the means of production. But I'm talking about phony mining marches in Guatemala where Quechua people are holding banners saying, I'm Quechua and I believe in God and I embrace mining, meaning I accept the terms and conditions that are being laid out. So I'm not talking about buying out certain leaders to sort of sully the process, but actually trying to intervene at the level of identity and self to try to manipulate the FPIC process to foment enough kind of organic conflict and resistance in a way that the self that is doing the determination, the decisions, and the agency is almost this kind of hijacked or this skewed or this strangely, you know, subjected to the PR of the sort of discourse of indigeneity and wedding that with mining or development exactly the way it's being proposed, totally siphoning off 99% of the resources and going. And those who object are discursively constructed as irrational, childish, or in Canada, eco-terrorists, or however that may be. So I'm wondering if that sort of vulnerability, when you talk about we need to look at the real politics of FPIC, if there's something in this kind of fluidity of identity that concerns you. There's a strength in there, but it strikes me there's also a kind of a vulnerability, if that's sort of an issue at all.
Good. And because the time is so tight, I think we'll take the other question as well and then ask the panelists to respond to both together. So I think there was one other person.
My question, I think, is more of a softball than anything you've heard today. I was just hoping for some context about how FPIC fits into the construct that we've been trying to understand for the last 5 or 10 years of the duty to consult and accommodate. FPIC, to me, seems like part of that process in that it's a requirement for that process to conclude successfully. But, you know, having worked with First Nations, they don't know where to turn sometimes. You go to the province says, oh, that's a federal matter, and vice versa. You go to industry, they say you have to talk to the Crown. I've heard FPIC today described as both a Crown responsibility and something that business has to do. And Francois, I think, showed where some of the levers to get FPIC into business operations might be. Can you speak a little bit to the interrelationship between FPIC and their duty to consult? Thanks.
All right, we will take the one last one then.
My question is very quick. If the Prime Minister Harper was in the room today with Cabinet, Bradley, this is directed to you and any other First Nations member, what would be your message to Prime Minister and Cabinet about the future of FPIC over the next 5 to 10 years with respect to resource extraction? Thank you.
Okay. So let's just go down the line then, and we'll give each of our panelists the opportunity for last words to comment on those last 3 questions. And Anne, are you ready to go?
I think, yeah. I think I just really quickly just wanted to go back to and thank Jocelyn for her words, and the gendered impacts is, you know, we're living it. I have 2 daughters that are going to grow up in a mining town, and so I know I live on the highway of tears, and family members have disappeared, and so it's something I think all our communities are dealing with, and I just wanted to acknowledge you and thank you for your words and sharing with us today. Vulnerability, FPIC, and identity I have down. I hope I got that. I got that right. I mean, in Latin America, I went to Ecuador. Is the only place that I have visited, and I really struggled with that the identity there, because I knew who I was. I'd go to a community, there'd be these indigenous people, this Campesino, this is, like there was this very different organization of how communities, there it was more community, like it wasn't, sometimes I was told they didn't want to be seen as being indigenous because that might harm them down the road, so they wouldn't say they were indigenous. Or there was all this stuff in play that I couldn't even imagine having to deal with that in Canada. Like, I'm just so fortunate that I was born into my mother's clan, and for the, they're going to take care of me when I pass away, which is not going to be for a long time. And that's what we know, but I really can't, I don't know if anybody else wanted to add anything, but I sensed that when I went to Ecuador, just that that difference in community and identity, and that always worried me about Canadian companies going into smaller communities and being able to interpret what they thought community was, or interpret what they thought Indigenous was, or bring Indigenous people from Canada that might be supportive of the mining industry in Canada, for whatever reasons. They have their own reasons to be supportive, and to say mining is good for Indigenous people in Canada. That's something we have to work on here by listening to and connecting with communities in Latin America. That was the reason Kairos brought us together in New York last year. Women from Nicaragua and Panama and Guatemala, and women from Canada coming together and being able to support one another and try to work together. So that's, there's lots of work that needs to be done in that development of working with communities in Latin America. I think I'm going to leave the rest to duty to consult and accommodate. I'll leave that to the lawyer. And the last one, if the Prime Minister was in the room, what would I say? That's a tough, I mean, it's kind of like an easy question, like get it together and come on. But I think for our communities, we're always told to be respectful. Our elders always remind us, be respectful. And no matter what, we have to keep what we were taught, and hopefully that the government would listen. And I just hope I would be respectful and find a statement that is able to say that he needs to listen to us. We have been living in this area. First Nations have been here for generations, and we have a lot to teach. So.
Oh, answering 4 questions at once. I'm only going to answer 3. So first, I also wanted to say thank you to Jocelyn. I think that is an interesting discussion that was coming up in the sidelines today, is like, what is a gendered analysis of FPIC? And one of the reasons why I think it's important there's 2 things to think about, I think. One is that we've been focused very much today on free, prior, and informed consent, but of course that's only one aspect of the UN Declaration on the Rights of Indigenous People. And the overall declaration deals with the cultural rights, the rights of Indigenous children not to be removed from their families and cultures. And FPIC is embedded in this broader document that's about the rights to retain culture and identity, which is part of what I think you're talking about, Jocelyn. And I think it's an important reminder also because I'm aware of the fact that one of the critiques of the way that our modern treaties and land claims have worked in Canada is that there is a gendered analysis. If you look at many of the modern land claims agreements, they very much reflect the gender of the negotiators. I heard some very interesting commentaries on this when I was living in Nunavut from friends who were Inuit leaders who were women. And Inuit women lawyers who talked about how the hard edges in many of the modern land claims agreement are the protections of harvesting rights, land rights, resource rights, and fewer harder protections with hard edges for enforcement for language rights, cultural rights, and things that are more traditionally the domain of women. So I think these are things that we need to be very aware of, that there is a gendered analysis that we need to be engaging in. So I appreciated your comments, Jocelyn, and your willingness to share your story. About the question about identity, and the question was like within that fluidity of identity and who is the self and self-determination, is there vulnerability? First of all, I think I'd love to hear Daly's comments on that. I'm not a sociologist, so this isn't an area where I feel like I have theoretical expertise. But I think, isn't identity always contested in every culture? I know my own cultural background, I come from a small group of people called the Frisians, who I won't get into details, but we have our own language, our own lands, our own culture that's now parts of the Netherlands, Denmark, and Germany. But my people consider themselves to be separate still. But there's no agreement even within my own family about what it means to be a Frisian, other than we all know that it means to be stubborn. That's the only thing that we can all agree on. So I think identity is always contested, but I think I'm less concerned about, frankly, about the vulnerability in that in terms of how people identify as Indigenous, and more inspired because of the demographics of change. I think one of the things that's going to really drive FPIC and the recognition of Indigenous rights is just the sheer practical reality of the changing demographics in Canada. The enormous young Indigenous population that is growing faster than the Canadian the Canadian norm, and what that's meant, for instance, for Idle No More and these amazing explosions of articulations of what it means to be Indigenous in ways that both embrace traditional culture and ways of being in the world with modern identities. And so I find it more inspiring than sobering to think about what Indigenous identity could mean in terms of debates about that, because I think it's just fascinating what's happening right now, and ultimately I'm optimistic about that. In terms of how Indigenous identity is being debated and contested, I think it's a good thing. And finally, the question about how does FPIC fit within the construct of Aboriginal consultation, I mean, that could be a whole day discussion in itself. I think it's a really good question. The duty to consult that's been laid out by the Supreme Court, I think shares some of the same underlying principles that Indigenous rights are inherent, and that Indigenous peoples should have the right to have a meaningful say in what happens on their lands and with their resources. But I think the problem is practically the duty to consult has ended up in a practical situation where there are procedures for consultation without substantive justice. And I think that's where the nub of using FPIC is for me, is I see it as another tool in the toolkit that is about trying to enforce those protections of the rights in a way that may not be practically happening with the duty to consult, and that somehow in my mind consent is more about the outcomes of the dialogue and the relationship building in a way that Aboriginal consultation has not been on a practical level. So, and I'll leave the question about what I'd say to the Prime Minister, because you probably wouldn't want to hear my language.
I guess I'm up. I'll go in order in terms of the questions. So first for Jocelyn, nanaskumtin betagasinuta kijasi piaski. Just a little bit of our language, because I know a little bit about the Attawapiscats there. Some of my older brothers are from there, and we spend time in the mountains together. So, so thank you for coming and standing up. I know it was hard to do, and it's hard times out there for a lot of our families, and in particular for the women that are really carrying our families, carrying those home fires by themselves, oftentimes without the support of a partner or the community. And I think to balance that off with the positive side of our will as Indigenous people, I think culture camps are a wonderful, wonderful tool for all First Nations people to be taking advantage of. And it'll take the unique form of whatever your people's ways of coming together are around celebrating life. It's usually around harvesting different natural resources, our relatives, the natural animals, the fish, the medicines. These are some of the natural camp settings that will probably could serve as a really good, positive, constructive tool where you can start that discussion. Because what I'm hearing is that there needs to be a discussion there in Attawapiskat with some of the big negotiations that are underway with some of the projects there. And I think, again, following my line of thinking that hopefully I've conveyed here, communities have to be doing a lot of hard work prior to these big projects. A lot of that prior work will help you out then in terms of figuring out, it sounds like on a negotiating team or however you're going to approach the issue, the issues around gender, getting those right voices heard. Those ideas will come from the people, through those discussions that happen, because that's how a lot of our politics and a lot of our formal technical training politically actually happens. It happens around the cultural setting, around the fires, around fish camps, around moose camps, around medicine picking areas, where the older generations talk about stories and they use song, they use ceremony to really teach the younger generation about some of the options that are available, because we've got a long history, and that's what you should be utilizing there, Jocelyn, for your negotiations in Attawapiskat. In terms of actual negotiations with any natural resource developer, I think actually De Beers has a pretty good. They have a pretty good model in Botswana. I'll lay a little bit of a treasure trail for you there to take a look at, to do some research. They have agreed to, with Botswana, that 80% of the revenue goes directly to Botswana. I know that math in terms of resource revenue sharing here in Canada I don't think it's anywhere near that. I was watching TVO and the other day and listening to some CBC stories that you can't even really get a resource revenue sharing number out of different ministries in Canada, which seems really wild to me. We're supposed to be the best at governance, Canadians, accountability, right? And we don't even know. Well, I know in Botswana, I think the number that they have in their IBA with the state there is 80% of the revenue stays with Botswana. So I think there's some models there for you to take a look at. I think the FSC system in terms of gender standards, principles, criteria, how that could be audited, there's some tools there for you to take a look at. I think some of the other market certification schemes also have different approaches on gender, free trade, all the different ways of, I guess, getting companies to voluntarily agree to market performance. So there's some models there for your community to look at, for your families to look at, and to take that and put it through your community process and make it yours. That would be my advice there. FPIC in Canada, and the real politics of FPIC in other venues. That's what I have for the question there. And on one of the meetings that I chaired internationally, we had a gentleman who was a committee member come forward from the Maasai people, and he presented a scenario in his homelands in Tanzania where there was very real ethnic warfare happening around access to land, land grabbing, agricultural conversion, pastoralism, being the Maasai people, maintaining forest lands for their range, for their animals, and also riparian zone wealth. And there was just a reality of open warfare for a lot of indigenous peoples around the world. And while we were focused on some of the discussions around that, what kind of advice we could give to our Maasai brother about how he would protect his, how he could protect his forest homeland and ensure the safety of his relatives in those communities that were in active actual warfare there. One of the gentlemen from Latin America, who is a member of a well-known confederacy, I'm not even going to mention the name, but in Latin America, just so they can't be tracked, came forward and said, he said, you know, we have to be very careful when we talk about indigenous groups in the South. He said, because commentaries that are made about indigenous groups get picked up by vigilante groups in these countries, and then it gets translated very quickly into machine guns and bullets, and women and children being hurt very badly and people being murdered. And where I'm going with this is this real politics that happens and some of the twisting that I think that you have witnessed and others that have witnessed in these kind of the wild wests of the world that are still out there. I think there should be this cold realization in Canada that we have a very high duty to acknowledge the problems that are out there, but to really think about how we can provide the best of engagement tools, the best of FPIC processes, the best of voluntary performance with companies. Because the investor groups, in terms of connecting with some of the other presentations, and the money behind them are paying attention through their risk management committees and programming these into executive compensation models so that the CEOs and the C-suites are incentivized to do ethical behavior. As crass as it sounds, that's what it's come to for a lot of the corporate boards in the world that are doing it right. They incentivize the right behavior, basically acknowledging that human rights performance should be a part of executive performance, right? So those are some of the answers there in terms of how in Canada we could lead the charge on that. Now, I'm not sure if there's any companies outside of a few mining companies that are now have been bought up and have been parceled out by after the Great Recession. There was some mining companies that came out of Canada that were operating properly. That they're no longer in existence. They were bought out in all the commodity swings that have happened. But there's tools in Canada that we can bring forward and communicate. I think that's the role of a lot of the international NGOs in the room here today, because indigenous communities in a lot of these geopolitical areas of conflict are under threat of actual outright massacre if they say the wrong thing in the press, if there's any indication that they're creating problems for the, pejoratively speaking, the rulers of the land, right? So in terms of that, we've got to do it right in Canada. Do we have it right now? I'm not sure if we do. I think we know that there's issues that have to be worked out, and I think this is where the questions between connecting FPIC and the duty to consent or duty to consult comes up. You have to remember, duty to consult and FPIC, all these come out of really the struggle of Indigenous peoples standing up, usually for some type of development on their land base that they weren't being treated fairly with, and then triggering a lawsuit. So the connection is there. It's a historical connection. It's a technical connection that Lorraine has outlined here. To me, a duty to consult should lead to a decision via free, prior, and informed consent. Whether or not that has happened, I don't think it's been programmed in terms of regulatory language, legislative language, by any level of government in Canada yet. I think there's a lot of fear around it. And I think that kind of leads into the question around what, I mean the question was for the Prime Minister, but really it's for the political elites of Canada, right? There's this huge situation where there's a lot of natural resource development potential, supposedly, on Indigenous land bases. And people kind of have gold in their eyes, dollar signs in their eyes, you know. And I think what Indigenous peoples are saying, in a multitude of different voices and venues, is saying, let's just wait a little bit, okay? Let's get the right process to talk about the relationship first. There's some problems with the upper level relationship. There's some issues for a large number of nations, First Nations in Canada, around treaty understanding and treaty implementation. And there's a huge other component of the Confederacy of Nations out there that are looking at Aboriginal rights and title. And then there's a huge other component of, I think, of nations that are in the kind of far reaches of the bush or the mountain valleys that just want to be wild Indians, right? They just want to be left alone. They want to run free in the woods. There are communities like that still. And so getting the relationship understandings and protocols understood at a higher level, I guess. I mean, that question is really, that's really where I think it would take a dialogue of not just one individual, but a dialogue of First Nations coordinating in a mutually agreed upon manner if it can be done. And then having the resource and the wherewithal and the vision coming from their people, pushing them to do the right thing there. Is that the case right now? Do we have that push? I think I don't know more on some of the social media activism, some of the energy levels coming from the young people is there. I think it's beginning. Are we there yet? I'm not sure. I think there is an active analysis underway for a lot of young First Nations people around vehicles to have that discussion. You know, are the current organizations, are the current dialogue spaces the way to go? And so it's really an open-ended answer. That's how I would approach the scenario. And I think I've went down the checklist there. So thank you for the questions and the engagement with the subject matter. For our brother there from Eobar, no offense to kind of trying to push the discussion forward. Just people are getting pretty tired, and we're already overtime here, 5 o'clock, 5:05.
Yes. All right, so thank you very much to our panelists, to Bradley Young, to Lori Land, and to Anne-Marie Sam.
Great job.
I'd like to ask them to stay at the front here for a moment, and for the other panelists and the organizers to join us at the front, because we have a lot of thanks to share to the various organizations behind this and to all of our presenters for the day. And while they're coming down, I want to thank all of you for being with us today, including those of you who've stayed online with us and contributed questions through the chat and by Twitter. And ask a favor of everybody who is in the room here. We've imposed on the hospitality of the university by having our lunch here in the room. So if you could help us to tidy up as you leave, it'd be much appreciated.
Okay, everyone, just in closing, we again would like to thank the Algonquin people for welcoming us into their territory and allowing us to meet today. Again, we want to thank our sponsoring organizations for, providing us with the space, providing travel and accommodations for our speakers to be able to be here for our lunch today. So the Aboriginal Law Group, Amnesty International Canada, Assembly of First Nations, the Canadian Friends Service Committee, the Grand Council of the Crees, Greenpeace Canada, Kairos, Mining Watch Canada, Oxfam Canada, Oxfam Quebec, and the Coalition for the Human Rights of Indigenous Peoples. If everyone could join me in thanking our speakers again today. I think they did a great job. Just a reminder, all this information will be made available on the website, so go to fpicforum.ca for updates, and then ensure that we have your email address so that we can send you further information. Again, we thank you for your contributions. Hopefully this will start a dialogue that will continue on, across Canada in different regions and different time places with different communities. So thank you again.
Yeah, engineering. And then mine in engineering grad.